Hence, WPA 19804 of 2023 is dismissed on contest without, however, an order as to cost. Can 1 of 2023 is disposed of accordingly. Urgency.
Lordship. Grateful to Lordship.
My lord, may I be permitted to mention
No,
one?
mention only on Mondays and Thursdays. Yes.
Do we mention item number 2 for release?
Why release? Determination.
Yes, your lordship. Inadvertently, I have filed it under group 9, your lordship. It should have been filed under group 5.
Group 5.
Yes, your
Learned counsel for the petitioner submits that inadvertently the matter has been filed under group 9, whereas it relates to group 5 of the classification of writ matters. Accordingly, leave is granted to the learned advocate in regard for the petitioner to carry out the necessary consequential corrections in the computer sheet annexed to the writ petition. The matter shall go out of the list with liberty to the parties to mention for inclusion before the appropriate bench having determined.
Extension of interim order, item number 3.
Well, I am for the petitioner in this matter. My lord was pleased to pass an order on 18th of October, my lord, interim order up to the yesterday, and the matter was scheduled to appear on 11th. My lord, in the meantime, affidavit was rejection first. My lord, no affidavit has yet been filed. Let
State budget affidavit is ready, but not yet been accomplished. Huge time may be given.
Why? How much? No. 3 days I can give you. If it's being ready, prepared.
Mela, they are not coming either.
Gangasagar Mela, what is the relation? When was the direction passed, Mr. Basu?
18th of October.
When was the Gangasagar Mela? No. The state seeks 3 weeks adjournment to file affidavit in opposition. Next para. However, since the directions for affidavits were given long back on October 18, 2023, such extension is granted only for a week, reply if any shall be filed within a week thereafter, the matter shall be listed on February 12, 2024.
Instead of 12, can it be after 14th or before?
Shall appear in the list on February 19, 2024 for hearing, The interim order granted earlier is extended till disposal of the writ petition.
Top item, item 4.
Yes, please.
Issue of the one-time settlement. Yesterday, the matter came before Lordship and Lordship got the order regarding that.
Yes, bank is
I appear
here for the one. Yes. What instruction?
I'm sorry, madam, I was not there yesterday.
No, you are not.
The only due, there are 3 accounts altogether for this borrower. This is the guarantor of the loan. After adjustment of 45 lakh, there is a dues of 91 lakh and odd as on date, as on 31st December 20.
But you are selling the property at 50,000.
50,000?
50 lakh.
Whatever the valuation is done by the impaneled valuer.
Suppose you sell the property today, you'll have to undergo the entire procedure for sale and all these things.
My lord.
Some expenses will be required for that also.
My lord.
For taking possession also.
My lord.
So if you sell the property in any event, you will get 50 lakh.
Matter of the case will.
So why don't you consider about the one-time settlement?
Consider the only difficulty here is that under the guidelines and the policy of the recovery process of the bank cannot settle the matter with the property value is more than the dues. That is the only difficulty. Otherwise, you could have done.
Cannot settle if the property value is more than dues. Dues are more than property value here. You say your dues are 91. So you
property
can
value is more than 1 crore.
Property value is more than 1 crore.
Because since it is more than 1 crore.
And you are selling for 50 lakh.
Because this is fourth sale. The could not face the amount.
No.
So what will be the ultimate fun in it? I mean, they can increase it. Suppose if they pay 60 lakh, that will be to your benefit only.
That's all. Only difficulty is that let them approach the bank and increase their offer. That is why we have given the letter to them also. So let them increase their offer. We'll consider that.
What is your maximum limit to which you can pay?
No, up to 60 lakhs I can.
No, because I said 60 lakh.
60 lakhs.
No, but if you sell out the property, if the auction sale goes through, then nothing remains.
The e-auction sale, my lord, property value may go upwards also. The e-auction sale, it is a public auction.
50 lakh is the base value.
Base value, reserve price.
Lordship, 64 lakh.
You participate in the auction.
Yes, yes. That liberty can give, no.
Participate in the auction.
No, Lordship, 64 lakh, they have given the opportunity.
We
to
cannot
pay.
compel them, sorry. The learned counsel for the bank submits that it is the policy of the bank that if the property value is more than the amount due, comma, no one-time settlement can be arrived at by the bank. Full stop. It is contended that the property value is around 1 crore. Full stop. Although the base price has been fixed as consideration to be rupees 50 lakh, comma, since it is an auction sale, comma, the price may go higher up. Full stop. It is submitted that since this is the fourth attempt to sell the property, comma, the consideration base price has been fixed at rupees 50 lakh. Full stop. The debt of the petitioner calculated till date as per the bank is around rupees 91 lakh. 91 lakh.
Dues are.
Full stop. As such, comma, the policy of the bank prevents the bank from entering into a one-time settlement. Full stop. Next para. Since the bank has taken such a stand, comma, it is beyond the scope of the writ court to compel the bank to enter into an one-time settlement. Full stop. Next para. However, comma, it will be open to the petitioner to participate in the e-auction to be held by the bank, and in the event the petitioner comes out to be the highest bidder or matches the price of the highest bidder, comma, the bank shall consider uh, settling the amount uh, accordingly. Full stop. Accordingly, WPA 27181 of 2023 is disposed of by granting liberty to the petitioner to participate in the e-auction sale going to be held by the bank.
Lordship, one line is to be written,
Yes.
Lordship, that is the, they will take the possession on 17 Lordship. That is to be
That
considered.
has to be taken. That is the obvious consequence.
That status quo,
No address to cause certain certificate.
that status quo may be vacated along with.
If you win, if you are the highest purchaser, because this is the fourth auction, maybe you are the only purchaser there. If you can repurchase your property, get your own property and get the possession.
So, but the possession will be taken by.
You will get back the possession if you win in the auction
I
sale.
am residing there with my family, Lordship. This is the problem, Lordship. One line is to be given the possession until the
Until what?
e-auction. They will not take the possession until the e-auction.
Here is the issue, my lord. Here is the issue is that
Because
if we
we'll
take,
be
if we
having-
take, if may
When
I,
is the auction scheduled?
it is not scheduled yet because we'll take physical person, because once you take a physical person, the property value will go up.
E-auction is date is given on.
No, I cannot do that. Sorry.
Only one direction is to be given. I will be on the.
Right, the property value will go down then.
Yes. I'm grateful, man. I'm deeply obliged.
Upgraded matter, item 5.
Yes.
I appear for the respondent.
Bank.
Bank.
Yes.
Lord, I am the auction purchaser. I have purchased the property. I have paid 32 lakhs and odd. Lord, I was the highest bidder. There is a
What is the grievance now?
grievance is, my lord, they have failed to give us physical possession of the plan. Kindly seize page number 48 once. What the story they have made up. Lord,
Story have
this-
made out.
Lord, what they have done in 22nd of January 2019 was the date of giving us the physical possession. What happens that private respondents, some of the persons,
Are you going to use any reply?
affidavit or reply in opposition have been
They
completed.
have served the reply.
It's completed.
Completed means the opposition is filed now.
We had served it earlier.
have served
We are
it.
filing it.
Opposition reply টা বার করে দাও তো।
Hmm.
You are filing it today.
Both are filing.
Lordship, this is the first time the matter has come up after suddenly come up.
Yes, then why are you saying it has already been filed?
I thought.
Anyway, what is their pretext? The bank is saying what?
Bank says, bank makes a, bank says the borrower is in possession. They make a complaint on the 22nd of January on the date of his giving us possession. Now, while on the next page, they themselves admitted that they have failed to give us physical possession. Now, kindly see the page number 48. They make a complaint to the police authorities.
We can only ascertain whether they are making their best efforts. We cannot
No,
compel them under the writ court.
No, let them either they pay back with the money because they have failed to give us physical possession.
Yes, what is your stand in that?
Lordship, in this matter, what happened was at the time of conducting the e-auction sale, the bank was in possession of the property. Then on 22nd of January 2019, the bank also intended to hand over the possession as well as the sale certificate to the auction purchaser. Lordship will kindly take up page 49 once. What happened was they refused to take possession.
2nd January Obviously 23.
2019, yes.
2019.
19. We intended to hand over the possession at the then time. But then he refused to take possession, and that was duly communicated to him that at spot, all of you refuse to accept sales certificate in possession of property which has been purchased by you.
Why did they refuse?
They refused because initially they were doing some dilly-dally, and thereafter suddenly some of the person's relatives of the borrower came and made some chaos in the property. They said, no, we will not take the possession. Accordingly, and they said that we'll take possession only if police hands over possession. So on the self-same date, a communication was also made that
You have to hand over clear possession to
Lordship,
them.
we were handing over clear possession.
Then what happened?
Then the chaos, there was a chaos.
After that, what happened? They did not take.
Then subsequently, again, a date was fixed for handing over possession. But thereafter, what happened was, before we could hand over the possession on the subsequent date in July, the relatives of, they again broke open, and they came with arms, and they took possession from our security guard. So a FIR has been lodged. And also, Lordship, in the meantime, what the bank had done was, bank has already deposited the police cost also in 2019. The bank has deposited the police cost, but only thing is that the SP, there has been no steps taken by the SP to hand over the possession.
1 minute. এটা কিসের শব্দ হচ্ছে? পাশের কোর্ট?
Yes. Lordship will kindly take up page 24.
In 2019, you deposited police costs. Then
Yes.
how did you pursue after that?
Lordship, we have been pursuing, we have lodged an FIR thereafter also. And thereafter, this writ petition was filed in 2020. Now, Lordship, the possession at the time of conducting the e-auction sale was with the bank. The bank tried to hand over the possession, and this letter dated 22/1/2019 was never disputed by them that they did not accept the possession. Thereafter, they had also accepted the sale certificate. We have also executed the registered deed in their favor, and the bank has deposited police cost. Only thing is that thereafter, the possession was taken up, and the FIR, Lordship will kindly come to page 85. The security services has lost the FIR that on
all these are in 2019. What happened after that for these 4 years?
Lordship, this 4 years, Lordship, we have already deposited the police cost, but there has been no steps taken by the SP of Howrah to reinstate the possession
Does the
of the
magistrate
bank.
have any power under section 14 till now?
Yes, Lordship. No, Lordship, that possession was already with us. The DM's order, we had taken possession.
You
Now
have to
we
give
did
the
not-
possession, otherwise they're entitled to
Yes,
refund.
Lordship, we are ready and willing to give the possession. Lordship, only
Well, give
thing
me a
is that-
date. I'll put the writ petition after
Lordship,
that.
only two submissions, Lordship. One, there has to be substitution in the cost title. That is a minor thing.
Take
that may be
police help,
done.
get
Now
the
we
possession,
will-
hand over to them.
Yes, Lordship, we are ready. Lordship, let them make the SP a party to the proceedings. Lordship can directly
Not a necessary party.
direct
You
them.
will have to take the police help. I'll give you liberty to take police help and hand over possession.
Lordship kindly directs us.
Do that within a week.
We are ready and willing, and we have already deposited the police cost.
I'll direct them to do it within a week. I'll give them liberty to take police help for that.
Yes,
And I'll give you a fortnight for that.
Lordship,
I'll put it
I'll be
after
great
that.
because
Under the
first
heading
thing-
top after that.
Yes.
Very great.
Learned counsel for the petitioner submits that the petitioner was an auction purchaser in a bank sale. Full stop. The respondent bank, however, failed to hand over possession of the property to the petitioner. Full stop. The writ petition has been preferred, seeking such possession, alternatively a refund of the consideration paid by the petitioner. Full stop. Next para, learned counsel for the bank submits that the bank has taken all efforts in restoring possession, in handing over possession to the petitioner. Full stop. In fact, when initially the bank sought to hand over possession to the petitioner, such possession was not taken by the petitioner, apparently on the ground that some ruckus, RUCUS, was created by the borrower and his men. Full stop. Next para. Thereafter, although the possession was with the bank, forcible possession was taken over by miscreants. Full stop. The bank has already deposited police costs in the year 2019 and lodged a complaint on the basis of which a first information report has been registered. Full stop. Thus, it is submitted that the bank, although willing to hand over possession, is not being able to do so. Full stop. Next para. The petitioner has a point in arguing that it was the incumbent duty of the bank to hand over possession to the petitioner. Full stop. Since a long time has elapsed after the purchase, the bank ought to have taken appropriate steps for handing over such possession. Full stop. Next para. Be that as it may, since a fair stand has been taken by the bank, liberty is given to the bank to take adequate police assistance at its cost, for handing over peaceful possession of the secured assets / purchase property to the petitioner within a fortnight from date. Full stop. Next para. The parties and all concerned shall act on a server copy of this order for compliance. Full stop. The matter be placed at the top of the list on February 6, 2024 for passing further orders. Full stop. The bank shall file a report of handing over possession on the said returnable date, with an advance copy to the learned advocate on record for the petition.
Very good.
I'm led by
Mr. Rai.
Item 6.
Yeah. Yes, Ms. Oja.
Lots of this matter earlier appeared before Honorable Justice Nijamuddin when His Lordship passed a direction upon the state to file affidavit in opposition. However, on that date also they did not appear. I communicated.
Justice Nijamuddin was taking this determination.
Your Lordship, some of the matters of this determination was
right. Then what
before.
The matter?
Your Lordship, my section 14 application has been initially returned and thereafter rejected. Kindly come to. May I just file the
opposition has been filed?
No, Your Lordship. I'm just filing my communication, which I duly communicated as per the direction. But
they were not present when Justice Nijamuddin passed the order.
Your Lordship, in spite of service, affidavit service is already on the record.
So no opposition has been handled?
No, Your Lordship. Time has elapsed long back. Your Lordship, kindly come to the impugned order, then I will show the relevant other document. Your Lordship, it is at page number 58 P7, Your Lordship.
Yes.
Lordship, it's a small order. The character of the land is in registered gift deed.
58 is a communication.
58 is the letter, Your Lordship.
Yes.
P7, annexure P7 of my writ petition.
P7 to the authorized officer.
Yes, Your Lordship. This is only the order.
Okay.
Yes, Your Lordship. This is only the order.
Yes.
The character of the land in registered gift deed is in favor of Srimati Putul De Sarkar is mentioned as Sali, which belongs to agriculture category and does not come under the purview of provision of SABYASACHI Act. No conversion certificate was submitted along with the application. In view of the above, you are directed to submit the aforesaid application afresh with desired clarification. You are also requested to collect the application from this office within 15 days of receipt of this letter, failing which the application will be rejected from our end. So initially returned and thereafter rejected, Your Lordship. Now, Your Lordship, this 31I applies to a purely agricultural land, which is mere in the records. If it appears as Sali, that does not apply. It has been clarified by the Apex Court in a judgment.
31I of
SABYASACHI Act, Your Lordship. May I place this?
SABYASACHI Act should be here.
I can hand over my
Yes.
31I.
Yes.
Lordship. Any security created in agricultural land. So
yes.
This
so Sali land.
Yes. Agricultural, Lordship, not merely In the records, if it is Sali, they did not convert. However, even at the time of availing financial assistance, there was already a land with a structure existing. They were utilizing as a bastu land. Then this not apply. The provision is only to safeguard the purely agricultural land, Your Lordship, which has been held by the Honorable Apex Court in the judgment of ITC.
How do we know that? How do we ascertain that?
Yes, Your Lordship. Kindly come to section 13 to what was the security interest created and what we are going to take possession.
Section 13.
13.2 of my
Page.
Your Lordship. It's page 17 of my writ petition, Your Lordship, in excerpt P3. It's start from page 17.
Show me the relevant portion.
Yes, Your Lordship. The schedule of the property is at page 20. What was the exactly property which was mortgaged? All that the land measuring about 1 kata 15 chetak and 9 square feet together with building thereon forming part of dag number such and such. So when this property, the mortgage was created, there was already
Is there any section 17 by the borrower at any point?
No, Your Lordship. Not within my knowledge. The second property is also, Your Lordship, there was already a standing structure. When the loan was sanctioned, it was never used as an agricultural land. It was already a pastu land. And may I rely upon a judgment, Your Lordship, where the Honorable Apex Court held that when the parties had specifically created mortgage, their intention was that to create mortgage, it cannot be treated as agricultural land. And in fact, in this case, there was not at all, it was used as agricultural land. Kindly take up head note, Your Lordship. Head note and then paragraph I will come to. Kindly take up page number 101 of the judgment. Head note E.
Yes.
Yes, Your Lordship. Head note E, 101. I'm reading the next paragraph of head note E. Held section 31I is intended to protect agricultural land held for agricultural purposes by agriculturists from the extraordinary provisions of this act. Security interest was created in respect of agricultural land which was meant to be a part of five-star hotel. Here, Your Lordship, my case is even better than this case. In this case, there was a five-star hotel and some portion was used for growing some vegetables or flowers like that. In this case also held that this cannot be treated as agricultural land. Your
property was not
not at all. It was the land with
not a five-star hotel.
No, this is a five-star hotel.
Difficulty is if this is taken to be absolute. I mean, in this case, the parties proceeded on that premise. But supposing there can be a collusion between a financial institution and a party, which is a henchman of the financial institution. This not in your case, theoretically, and you collude between yourselves to usurp an agricultural land. Now, already there are land grabbers everywhere. So there may be a situation where a person colludes, a land grabber colludes with the financial institution, has a loan, bank takes the property, and on the premise that both agree that it's not an agricultural land. Agricultural lands will be taken by land grabbers and financial institutions.
Then
how do we protect them?
That should be a property of a third party. Here, there is no third party. No case has come forward. It is never in dispute that this property was of the borrower's, Your Lordship. Kindly take a page, paragraph 36 and 37 of this judgment, Your Lordship, where everything 37 and 38 has been clarified how it would be dealt with, Your Lordship. Because merely just because it is in record, somebody has not got it converted and without conversion has used as a bastu land and erected a structure, and thereafter by misrepresenting bank,
that is
it
also
never
true.
disclosed, Your Lordship.
That is true.
Kindly take up page 121, para 37 and 38 of the judgment.
Very well, I'll pass an order.
Then,
I'll allow them.
yes, sir.
Learned counsel for the financial institution stroke petitioner argues that the district magistrate acted beyond his jurisdiction in rejecting an application filed by the petitioner under section 14 of the Surface Act 2002 on the premise that the property concerned was a single inverted mode SALI, Sali land, which belongs to agricultural category and falls beyond the purview of the Surface Act. Push up next para. Learned counsel places reliance on the schedule of property as given in the notice issued by the bank under section 13 within bracket 2 of the Surface Act 2002, which clearly indicates that the property concerned is a land on which a structure is standing, comma, which establishes the fact that the property is not used for agricultural purposes. Push-up, it is argued that mere demarcation of a property as a Sali land in the land records does not necessarily mean that the said land is actually an agricultural land, comma, being used for agricultural purpose, full stop. In any event, comma, it is pointed out that since the borrower did not take such an objection at any point of time, and both the petitioner and the borrower proceeded on the premise at the time of grant of mortgage that the property was amenable to the jurisdiction of the Surface Act, comma, such a third objection cannot be taken up by the magistrate at this juncture. Push-up, learned counsel places reliance on ITC Limited versus Blue Coast Hotels Limited and others, reported at 2018-15 SCC 99 in support of our proposition. Pushed up next para, despite service, none appears for the respondents, comma, nor is any affidavit in opposition filed till date. Pushed up. The Supreme Court, comma, in the report handed over by learned counsel for the petitioner, held that section 31 within bracket small I of the Surface Act, comma, which precludes applicability of the 2002 Act in respect of agricultural lands, comma, is intended to protect agricultural land held for agricultural purposes by agriculturists from the extraordinary provisions of the Act. Pushed up, security interest when created in respect of agricultural land, which was meant to be a part of a five-star hotel in the said case, and the debtor had applied to the revenue authorities for conversion of the lands to non-agricultural lands which were pending due to policy decision, comma, it was held that the parties within bracket creditor hyphen debtor bracket close themselves understood that the lands in question were not agricultural, and prima facie it also appeared that having regard to the use to which they were put and the purpose of such use, comma, such land was not agricultural. Push up next para. In the present case as well, comma, at no point of time did the borrower take an objection that the property was an agricultural land, comma, thus not amenable to the operation of the Surface Act 2002, full stop. The schedule of property as mentioned in the notice under section 13 within bracket 2 of the said Act also clearly mentioned the property to contain structures standing on land. Full stop. Thus, comma, apparently both the mortgager and the mortgagee proceeded on the premise that the land was not an agricultural land. Full stop. Hence, comma, the rigor of section 31 within bracket small I of the Surface Act cannot be set up as a defense at this point of time. Full stop. Next para. On a wider premise, comma, it is beyond the scope of inquiry of the magistrate while deciding an application under section 14 of the Surface Act on the merits of the case, full stop, since the petitioner stroke financial institution is already armed in law to the entitlement to obtain possession under the Surface Act 2002, comma, the magistrate cannot reopen the issues involved by recording that the property lies beyond the pale, PALE, pale of the Surface Act. Full stop. Hence, comma, the exercise of jurisdiction of the magistrate in rejecting the application under section 14 vide order dated August 26, 2022 is liable to be set aside. Full stop. Next para. Accordingly, WPA 20723 of 2022 is allowed, comma, thereby setting aside the order dated August 26, 2022, passed by the District Magistrate, North 24 Parganas, vide memo number 1012/JM/BST, and directing the District Magistrate to ensure that the application filed by the petitioner under Section 14 of the SABYASACHI Act is disposed of at the earliest, comma, positively within 3 weeks from the communication of this order to the said magistrate. Push up next para. However, comma, it is made clear that nothing in this order shall regularize or justify any contravention of the West Bengal Land Reforms Act or any other law governing the field of conversion of properties. Push up. Push up, it will be open to the appropriate authorities, comma, if so deemed necessary by the said authorities, comma, to undertake appropriate proceedings under the relevant provision in the event there is any irregularity in not converting the land for the purpose sought to be utilized by the bank, by the petitioner. No arrest to cause urgency. I'm sorry, this may reduce the price, but nothing doing. I have to safeguard the agricultural lands of our state also. Next.
Item 7.
Yes, please.
7 and Your Lordship, actually, item 7 and item 9 are analogous matters, Your Lordship.
7, 9 board You are appearing
Only on
I'm for the
7,
petition.
not in 9.
9. You have served copy also.
Yes, Your Lordship.
Nine, I was appearing for the.
You are appearing. Good.
Respond, state, Your Lordship.
Very good.
In that matter, Your Lordship, I didn't follow because I was aware that 7 is going
No,
on.
I just submitted.
Okay.
No, very well. Yes. I'll hear both of you after I hear her. Yes.
Yes, Your Lordship.
Fine, tell me.
Your Lordship, this is basically on the sand block. Mining permission was granted. EC was signed on
What is the
21/6.
identity between the two matters?
Yes, Your Lordship. Similar matters. Deficit challan, Your Lordship. The similar matter, Your Lordship, in 18/10/2023, Your Lordship had passed an order. There was a direction of affidavit. This is all similar matters, Your Lordship.
Anyway, what is the matter? Tell me.
Your Lordship, actually, the petitioner got a permit challan of 24,54,313 CFT, but he was there was a deficit of 55,97,438.6 CFT challan. As because the suspension of work was due to an outbreak of COVID-19, and there was a notification by the MOEF, that is Ministry of Environment, Forest and Climate Change, on 18/1/2021 for extension or grant of extension of validity period of the EC due to this COVID period. So that accommodation we had followed up. We have given letters to the authorities, but they didn't respond to it. They didn't pay any heed to it. So
I don't understand. What is CFT?
CFT is cubic feet, Your Lordship. This is sand for excavation. Sand
excavation work from them, for them.
Your Lordship, I am a sand block owner at that point.
Yes,
Let's see. I was excavating sand.
Yes.
So I was supposed to get much more, but I could only get a permit challan of 24,54,313 CFT. So the deficit challan, I'm asking from them that I want the deficit challan. This deficit was due to that COVID period. I couldn't operate. For that, there was.
You have permission to work much more.
Yes, Your Lordship.
Portion of the work could not be done because of
this COVID, and there is a notification by the MOEF that there can be an extension.
They refused.
They didn't do anything.
Yes, what do you say? First, Mr. Ganguly, senior. Yes. Who is senior? I don't know.
No.
Mr. Ganguly looks to be senior, but may not be senior. I don't know. Yes. What does this mean?
Short report.
Very short.
Milord, what basically, Milord, I have flagged it out. Just now I received it, Milord, as fastest possible manner. I just flagged it out.
Tell me the crux. Why should
Milord, the issue is that if your Lordship kindly takes up A, it has been indicated very short. That is why I am saying.
Right. Yes.
That the production capacity as per the environmental
clear a certificate 3 lakh square feet per year. As per the report, they were working during the COVID period also.
I'll direct affidavits, ma'am.
And one more,
Maybe a direction of affidavit.
one more issue is, what they are asking for is this extension and this.
So they say they are entitled. They were originally entitled. Portion was given. Regarding the rest, challenge were not given due to COVID.
Challenge they have to apply. We are only supposed
Your
to grant
Lordship, that
permission.
period we were unable to operate, Your Lordship, and
These
there
are
is a
done online.
notification.
Every time they applied, we have given it.
No.
Well, therefore, unless they apply, there is
Sir
nothing.
Ganguly, I'll direct affidavits. How
Malad.
soon
Yes,
can you
Your
file your
Malad.
affidavits in opposition? I'll give this back. Put this in your affidavit. I will.
Malad.
Obliged.
And moreover, what royalty they pay, that much work they do, they used to pay the royalty. Not that they are paying a lump sum and after that they are
Lordship,
unable
let
to
them
work.
come up with
Due to identity of cause of action, both the matters are taken up together. Full stop. The petitioners in both the matters are sand block owners. Full stop. CFT
Malad,
challenge.
lessees.
Pardon?
Lessees, Malad.
Sand
Sorry,
block
Malad.
lessees.
Malad.
Full stop. CFT challenge for a particular amount was issued to the petitioners. Full stop. However, despite the petitioners being entitled to excavate more, challans were not issued to the entire capacity due to the ongoing pandemic period. Full stop. The petitioners now seek the deficit challenge. Full stop. Next para. Learned counsel for the state in both the matters controvert such submissions on several grounds. Full stop. Since factual questions are involved, the respondents are directed to file their affidavits within 3 weeks from date. Full stop. Reply, if any, shall be filed within a week thereafter. The matter shall be listed for hearing on February 19, 2024.
Your Lordship, till date, the tender should not be given, Your Lordship. Otherwise, there will be no case at all.
That is the law.
This is for 9, only for 9, but 7. For 7, Your Lordship, there should be a direction. If their auction is given, Your Lordship, then I cannot, there will be no case at all.
Any action taken in the meantime shall abide by the result of the.
Obliged. Your Lordship, there are similar 8 matters. I'm giving the list of them for upgradation. Obliged, Your Lordship. Obliged, Your Lordship.
Item 8.
Yes. You are appealing for the petitioner?
Petition.
Yes. What is the matter, please?
And I have not listed, my lord.
What is the affidavit of service?
Affidavit service?
Yes. What is the matter?
Well, here the petitioner is a sweeper of Kolkata Municipal Corporation.
Right.
And he is getting salary through the bank. Now, May 23, when he went to bank to withdraw his salary, bank shown a letter of an advocate, and where they have communicated the interim order of the arbitrator. And that order is that to freeze his account.
Interim order of arbitrator?
Communicated an order of the arbitrator. So, page 19A. Bosh. 19A, Lordship. That was handed over to him. Please send enclose the true copy of the order of the so and so, the order for interim application under section 17 of the order for a direction to the branch manager so and so to preach and hold the said account of the Kopil Dev petitioner, realization of the loan amount of rupees 4 lakh and
then you have to approach the arbitrator. What can the
Lordship.
do? But no.
My grievance is not like that. Lordship, it is a very large issue. Why I am telling you, Lordship, give me 1 minute. Please.
Yes, absolutely.
Here it is not for this, my client. It is happening so many sweepers of the Kolkata Corporation, illiterate persons in this Pulbagan, Kakurgachi and this area. There is a this private response number 3 is a finance created a finance institution. And this institution is putting the signature by the name of that he will give loan. That is in my, I am not saying anything more than this is in a petition. I have narrated all these things. And this respondent number 4 obtaining the signature, blank signature, and thereafter he is taking the loan from the bank, and that they are giving the petitioner. And ultimately, this was sending to the arbitrator. That's a self-made arbitrator, and he is passing an award. No communication is given to this petitioner.
Your client or the other sweepers never signed in any agreement.
My client admitted in this petition 2014 he was searching for a loan for his daughter's marriage. Then somebody introduced private respondent number 3, and private respondent number 3 has taken some signature in the blank paper, and there is he said that I will arrange a loan. Thereafter, no money has received.
Then he must have put in some arbitration clause there. I can understand your plight as a sweeper, but the difficulty is if you have signed some document, you have to take all points before the arbitrator. Writ court has no jurisdiction to interfere.
Absolutely, Lordship.
Take your point. If there is a racket, you can file a police complaint also. I'll give you that liberty.
Therefore, I have made it.
But you have signed something and you have taken money.
That I do not know. That is arbitration matter. As soon as my grievance today only is prayer one. Please direct the bank to release my salary.
It cannot be. If there is an arbitral award, it cannot be. I cannot do that.
And second prayer is that for award, I have not received anything. If I get the award, then I can.
That does not entitle you to have an order from the writ court releasing your amount if there is an arbitral award.
Or if I don't get the award, how
Respondent number 3 has been served. Please check up whether respondent 3 has been properly served.
I have served.
Respondent 3 is represented today, no?
I'm for the state.
Yeah, state can't help.
So, Lordship, my
Punjab National Bank is represented.
No. I can go to the arbitration at section 17 or
section 37. You can
file. 37. I can go to the district magistrate to challenge that. But I don't have any documents. If they are giving me, then I will go to Lordship, small player, direct them to give me papers. I have written a letter. This is a page. My letter is at page 29. I demanded justice to page 29. I have written to the private respondent advocate. This is the advocate of the private respondent number 3. And there I requested, I have no knowledge, and I have given the copy to the bank also. Let them serve all these things, then I will go. Page 29, Lordship. I am not reading.
Very well. I'll keep the writ petition pending. Otherwise, they will never get your remedy. I'll keep the writ petition pending. I'll pass an order directing them to produce all details of these
Lordship
arbitration award or whatever, and you have to serve them again because only the state is appearing. Serve the bank and the respondent number 3 the gist of that order. The petitioner contends that the petitioner is. You are not illiterate.
My illiterate.
Client is illiterate.
Illiterate. He is putting signature in English, I think so.
Then not illiterate.
Semi-illiterate.
Uneducated maybe.
Semi-illiterate.
Yes, the petitioner is poorly educated and without understanding the connotations, took a loan upon signing blank papers. However, the petitioner is not aware of any arbitration clause and or any arbitral proceeding being held. The petitioner was never given any notice of any arbitration. However, all on a sudden, the petitioner's, this is your salary account.
From the salary account, correct.
The petitioner's, however, the petitioner's all on a sudden, the petitioner's salary account
was freezed.
Has been freezed apparently on a communication by one Vishwajit Mitra advocate, in respect of a purported order under section 17 of the Arbitration and Conciliation Act 1996, which acted as a trigger for the bank to freeze the account. It is submitted that without having any idea as to the arbitral proceeding or any award or order passed therein, the petitioner is not even in a position to challenge such order, if any. Full stop. Next para. Thus, comma, the petitioner seeks immediate release of the frozen account of the petitioner. Full stop. Next para. Despite service, none appears for the respondent number one bank nor the private respondent. Full stop. An insinuation of a racket going on in similar circumstances has also been made by the petitioner. Full stop. Hence, comma, the absence of the bank and the respondent number three, despite service, is conspicuous. Full stop. The affidavit of service filed today be kept on record. Full stop. However, comma, in order to bring a clear picture of the uh, circumstances leading to the present matter, comma, the respondent number one and the respondent number three are directed to produce written particulars of the circumstances in which the account of the petitioner was frozen and all particulars of the arbitral proceeding, comma, if any, comma, which is going on or has been held against the petitioner. Full stop. The parties shall act on the server copy of this order, comma, coupled with the written communication by the learned advocate on record for the petitioner for the purpose of compliance and file written reports in that regard disclosing the above particulars on the next returnable date. Full stop. The matter shall next be listed on February 6, 2024 at the top of the list. Full stop. The petitioner shall serve copies of this order and communicate the gist thereof to the respondent numbers 1 and 3 and file an affidavit of service in that regard on the next date of hearing. Please do that. Let us see what can.
Lordship, once I have already annexed one letter. Another victim is a 2 lakhs issue.
That's why I have recorded that there's an insinuation that there's a racket going on.
Yes, Lordship.
I have recorded that.
So surprising, this is another racket.
No, this should be, I mean, this should be taken care of. You are right.
And it is happening this area. I'm grateful.
Somebody must be responsible. Let us see.
And they have
ultimately the rat may be on
the problem is that these very poor people, they can't give the
corporation sweeper. What does he know? I mean, yes.
I'm grateful, Lord.
Thank you.
Item 10.
Yes. Respondent.
Lordship,
for the respondent number 3.
Lordship,
Opposition for both.
There are
Lordship,
2 days delay.
Yes. Reply.
Lordship, the reply is not, it's ready, Your Lordship. The same could not be affirmed. The petitioner came back yesterday only. He went for a trip, Your Lordship. For that, lookout circular was.
This cannot remain in the upgraded matters list.
Your Lordship.
Affidavits in opposition filed by respondent number 3 and respondent number 4 today be kept on record. Full stop. On the prayer of the petitioner, the time for filing replies is extended for.
By this week, we shall file.
Extended for a week from date. Full stop. The matter be listed on February 6, 2024 under the usual heading. It are upgraded থাকবেন.
I have it.
Item 11.
Yes. My lord, in this matter, I am appealing for the petition.
Right.
My affidavit of service.
All served? All have been served?
Yes.
Yes.
Lordship, petitioner is an accused of a criminal proceeding under section 498 and 406 in connection with New Barakpur police station case number 50 dated 2022, February of 2023. Initially, he was granted interim bail by the learned additional chief judicial magistrate Barakpur on 28th of February 2023. Thereafter, on 16th May, he handed over all prison articles. In the subsequent event, my lord, astonishingly, on 29 June 2023, when he went before the learned ACJM for filing his confirmation of bail, from that date, the record is untraced, not found. In numerous occasions, he tried, he made the copy for the certified copy, he made an application on 19th of 2023, 19th of October 2023. It is at page 18, and my lord, page 16 is the surrender slip. The petitioner is having, kindly have a look, lordship, page 15A and page 16, the only formal FIR part and surrender slip. And he's totally in dark. And praying.
Your criminal case is still pending.
Still pending. And it is not being advanced. A direction, I am asking for lordship for reconstruction of the record. Otherwise,
Which court? Where is it pending? Which court?
it is pending before the learned additional chief judicial magistrate Barakpur.
Very well. The petitioner is the accused person in a criminal case which is ongoing before the respondent number 1, that is the additional chief judicial magistrate at Barakpur, where the petitioner has been accused under sections. What are the
498A.
498A.
420.
420, 406.
Not 498A.
420, 406, 323 and 506.
লেখা হয়েছে? Please repeat again.
It is, my lord, 420.
Where is it stated? Somewhere stated somewhere.
Yes, yes. It is in the
Page.
list of dates. First 2020, 22, 23.
Under sections 420, 406, 323 and 506 of the Indian Penal Code. Push up, the petitioner is at present enlarged on bail. Push up, however, comma, the petitioner have come to know that the records of the petitioner's criminal case are missing. Push up, learned counsel for the petitioner contends that since the petitioner is under the constant shadow of the criminal case, which is looming large over the petitioner's head, comma, the petitioner seeks that the records of the said case are traced out immediately so that the criminal case against the petitioner reaches its logical culmination early. Push up, in that regard, comma, the petitioner has also written to the respondents, but to no effect. Push up, it is submitted that the case records of the petitioner be reconstructed and the trial be proceeded with expeditiously. Push up, next para, you are with him. Despite service, none appears for the respondents. The affidavit of service filed today be kept on record. Full stop. The prayer of the petitioner is innocuous and justified. Full stop. Accordingly, WPA 26530 of 2023 is disposed of by directing the additional chief judicial magistrate Barakpur, that is the respondent number 1, to immediately seek a report from the respondent number 2, that is the learned registrar, additional chief judges and Metropolitan Court, Kolkata, with regard to the whereabouts of the records of the case pending against the petitioner. Full stop. Such exercise shall be completed by the respondent numbers 1 and 2 within a week from the date of communication of this order to the said respondents. Full stop. Thereafter, comma, in the event the records of the petitioner's case are not traced out, comma, the respondent number 1 shall take all possible steps for reconstruction of the said records, comma, if necessary, by directing the parties to produce the documents which are in their custody for such purpose. Full stop. It is expected that such reconstruction, comma, if required, comma, shall be completed within 3 weeks, within a further period of 3 weeks thereafter. Full stop. Immediately thereafter, comma, the respondent number 1 shall proceed with the trial of the case against the petitioner and expedite the hearing of the same, comma, making all endeavor to conclude the same within 8 months thereafter. Full stop. No orders to cause urgency.
Item 12.
State in this matter.
12 I am for the petitioner, my lord.
Yes.
This is one of those matters, my lord, which is covered by your lordship's judgment as well. My lord,
Lordship will find your lordship's order.
yes, my lord.
At page 63. An identical order may be passed.
Yes.
63 it starts.
But I have annexed 2 orders, my lord, one by your lordship and one by another coordinate bench of this honorable court. My lord, same respondent, admitted position.
Whose order was better? Apparently page 63 because Mr. Mujumdar places that.
Yes.
So I'll follow that. What is the matter? I would just
Lord, matter is, my lord, it's a works contract, my lord.
Yes.
In a nutshell, works contract.
Right.
Lord, I participated, successful bidder. I completed the job. Some completion certificate was given to me.
Dues payable. That's
Admitted
all,
dues,
but
my lord, part payments made.
But it has to be routed through the state government. That's it.
5 crore 96 lakhs pending.
And my lord, they have admitted due to paucity of funds, they cannot pay.
State will release to you and you will pay to him.
Yes, yes.
Very well. The matter pertains to admitted dues of the petitioner. Which of the petitioners did work for the Hooghly River Bridge Commissioner. Full stop. Although the dues are admitted, comma, the same have not been paid as yet to the petitioner. Full stop. Next para. Since the nature of the prayer is innocuous, comma, upon hearing all parties, comma, WPA 27416 of 2023 is disposed of by directing the respondent number 1 to ensure that the funds necessary to pay the dues of the petitioner are disbursed in favor of whom? Respondent number 5?
HRBC, madam.
HRBC, all
2 and 3.
2 and 3. 2 and 3.
In respondent numbers, in favor of respondent numbers 2 and 3, as expeditiously as possible, comma, positively within what time? 6 weeks?
No, my lord, last order, my lord, it was 8 weeks.
No, in this I'll follow my order. Within 8 weeks from date.
Yes.
Yes. The previous portion I followed Justice Bhattacharya's order, but this portion might.
It's the entire part we followed.
No, within 8 weeks from date, full stop. Immediately upon receipt of the said amount, comma, the HRBC shall pay the same to the petitioner, comma, preferably within a fortnight.
Yes, yes.
Within a fortnight thereafter. Full stop. No rest to concern.
Just because he's the red carpet guy, man, he cannot take advantage.
I am not it.
He's green carpet guy.
No, the affidavit of service is kept on.
Affidavit of service filed today. We kept. Thank you.
13 and 14.
Madam, I appear for West Bengal Dental Council, madam.
My lord, my senior advocate Caldwell Bosu was appearing in this matter. There was a direction for exchange of affidavits. The main answer.
Drop names of seniors. Yes. Because Mr. Basu is appearing, time has to be granted.
No,
you start the matter.
My lord, the prayer is that the main answering respondent, we received the affidavit in opposition yesterday. So if a week's time could be granted for filing reply, my lord.
But only one thing, my lord, this is the matter concerns election process of election.
Yes.
To that.
So what is the underlying?
But the underlying issue is that, my lord, so long as the matter is pending, my lord.
Yes.
But we have not taken any steps, but we may proceed with the election process.
Election of dental council.
Dental council. We may proceed with the election process, and my lord, in the meantime, lordship may fix the matter someday. The matter can be heard out. The other process that
if we proceed with the election process, what remains?
My lord, we kindly post this matter any day, subject to lordship.
That I'll do.
Yes. Well, kindly then post it this week, sometime this week.
If they can use their reply within that period. Today we are on 15th, 16th. This week not possible, Mr. Mujumdar. I can put it on 22nd.
But 22nd, my lord, I have some difficulty next week. That's the whole difficulty.
Next week entirely?
Yes, yes.
Then I'll keep it on January 29th, the date immediately.
29th.
My lord.
On the prayer of the petitioner.
But my lord, I know there is a CIS system which takes us to the bottom of the list. Can it be ensured the position of the
no, fairly at the top.
Yes. Fairly at the top.
Oppositions you are filing today?
Yes.
Affidavits in opposition filed today be kept on record. Full stop. The time for filing reply is extended on the prayer of the petitioner till January 24, 2024. Full stop. The matter shall be listed on January 29, 2024. Fairly at the top of the list under the heading upgraded matters. Under the heading upgraded matters.
Only one submission may be recorded. My lord, we are also raising the question of maintainability.
Kindly. যে পর্যন্ত বললাম সেটা থাকবে তারপর the issue of maintainability raised by the dental council is also kept open for being decided along with the writ petition.
Yes, ma'am.
My lord, much obliged.
You are for? Yes. So who is supporting who? Dental council is supporting?
Yes. I had given them the approval. So I will have to explain that one.
15.
Item 15 and 16, I am for the petitioners.
Item 15, 16, I am praying for a week's time around.
I need to take instructions. My lord. We have.
Yes.
I have just received instructions. My lord,
You are
today.
appealing for whom?
My lord, the respondent number 2, my lord.
He is the answering respondent. Successful bidder. I completed the job.
What is the urgency? Let it go down there.
No. My job was completed in 2016.
Yes.
I received the bill amount. The security amount is lying with them. My money.
What is the instruction? Return the security amount, then take instruction.
I have to take instruction whether they have completed the job, whether the
Yes, a compliance certificate is there.
After Monday, my lord. Any day after Monday, my lord.
On the you are for respondent 2.
Yes.
On the prayer of respondent number 2, the matter is adjourned till January 24, 2024, when it will be listed under the same heading.
But affidavit of service
matters. Both 2 matters.
2 matters.
Affidavits of service filed today be kept on record.
2 matters.
Deeply obliged.
Grateful.
আচ্ছা 8টা ডেকেছিলে না?
17.
Yes, what is the matter?
Yes. My lord, I beg to appear for the petitioner. My lord, here the question is with regard to the challenges to an order passed by the registrar of
In
societies.
morning, my lord, Mr. Bose is informed Mr. Dhar that today he is not do the matter. He take time.
He also informed him, sir.
He's not asking for time.
My lord, I was not aware of that. Then they must be correct.
It's on the ground of Mr. Basu, it's rejected. Move the matter.
My lord, he's on his way, my lord. He's on his legs, my lord, doing a matter online. My lord, I may move it, but
Very well. On the prayer of learned council, they let the matter stand adjourned for the day.
Obliged, my lord.
Yes. Yes, Mr. Kutubuddin.
For the
80. Same order. Mr. Kutubuddin's জন্য একটা আলাদা template করে রাখো।
I appear on behalf of
Quotation, you should have
WB.
deposited quotation amount, my lord.
My lord, I say, my lord, this is a premature application, my lord.
Why?
My lord, it is correct that the quotation has been issued, my lord, and the amount has been paid. But my lord, there are only one obstacle, I will say, in respect of regulation 57.
What is that?
My lord, may I hand over, my lord, a copy? Clause 4, my lord, it is marked.
আমার কাছে আছে তো তবু দাও দেখে করে যাবো ফেরত দিতে।
The time limit in respect of drawing of the low tension overhead line is 180 days. We are already on process of that. The application has been made in October. The 180 days has not yet, my lord, elapsed. But I kindly see clause 4. Earlier it was.
Do it within 180 days.
No,
I'll dispose of the writ petition with that direction.
Will do that.
There is a within 100 meters, there is a LT line, my lord. Only
according
one pole is required only.
It is, we are all the work
In
is
100 meters.
already on process, that is my instruction.
When did you apply?
October.
My lord, October, 6th October.
One 180 days is over. 6th October.
October.
November, December, January.
No, that is 90 days, man.
Oh, 90 times.
Earlier that is regulation 47, it was 90 days.
Oh, right.
Only
now
one,
it has
one pole is required, my lord.
No, I appreciate, but we are already my instruction is the work is on progress, man. Within 180 days we will do it, man.
Not 180 days, I'll make it less.
The difficulty is that, man.
Within 1 month, do it.
The difficulty is that, man. I have taken specific interest on. There are certain crops are there, man. We could if we do it, man. It will be.
Mr. Kutubuddin, I cannot direct them because they have time till 180 days.
My lord, at the moment there is no crop, my lord. What is my lord?
My instruction is that.
It is open field
it
now.
is 180. We will do it by 180 days.
When does 180 day expire?
April 6th.
No, do it before that.
I'm good.
The counsel for the petitioner submits that the petitioner applied for electricity connection, but the same has not been given by the WBSCDCL, despite the petitioner having complied with formalities as per quotation raised by the WBSCDCL. Full stop. Next para, learned counsel appearing for the WBSCDCL places reliance on regulation 57 of the WBERC the relevant provision, that is clause 4 of which provides that in case of drawing of LT stroke HT overhead line through paddy land, the time period may be extended up to 180 days, considering the season of cultivation. So it is submitted that the work is in progress, but the connection could not be given due to ongoing cultivation. Fullstop. Learned counsel for the petitioner submits that only one pole has to be installed for giving the connection, and there is no cultivation going on at present. Fullstop. Keeping in view the rival submissions of the parties, it transpires that Rule 4 only provides for the outer limit being 180 days. Fullstop. However, in the circumstances of the present case, there cannot be any impediment for the WBACTCL to give the connection earlier than that. Accordingly, WPA 28087 of 2023 is disposed of by directing the WBACTCL to give the electricity connection applied for by the petitioner within February 29, 2024.
Give us some time, Manoj.
February 29th, we are on 16th January. 1 month, more than 1 month. What cultivation is going on now, Mr. Mukherjee?
Nothing, my lord.
As your lordship.
What is the name of the crop which is going on?
Paddy is over, my lord.
I'm grateful, man. I'm grateful. I have given a copy of Regulation 57.
19.
No,
this is a separate copy when I have Xeroxed it. As well.
My lord, every service kept on.
No. How can it be?
Evidence service.
How can it be?
No, my evidence service.
How can it be kept on record?
19.
My lord, may I please your lordship? May I just file the affidavit of service?
Yes.
It's been served except respondent number 6.
Yes.
Yes.
Sorry. All have been served, Mr. Go.
All has been served except respondent number 6, which a remark came that addressee left without information. And 6 is a private respondent, not that important. Why I say so? If I move my application, my lord will.
Very well. Yes. What is the matter?
So, my lord, this writ petition has been filed being aggrieved by an order passed by the district magistrate in a section 14 order. I am an financial institution, non-banking financial institution.
Yes.
My lord, a section 14 order was passed on 31st of March 2022, whereby the district magistrate has given me power and authorized a officer subordinate to take the possession. My lord will get that. I'll come to the pages, my lord. Now, my lord, what has happened? That particular order was challenged by the borrower, who is a private respondent, before the Learned Debts Recovery Tribunal. Debts Recovery Tribunal, after hearing the matter, was pleased to find that there is no infirmity, hence did not pass any stay order. Simultaneously, that particular order was challenged before this court also by way of a writ petition. However, that
tribunal's order?
No, that district magistrate order simultaneously.
Okay.
So that writ petition never came up for hearing. They just filed it and kept it. They never moved it. In the meantime, what the borrower did, or the private respondent, they went back to the district magistrate and filed an application seeking a stay of district magistrate's own order on the ground that my writ is pending. However, the district magistrate failed to consider that once he passes an order, he becomes functus officio. And he is passing that order on the administrative side and not on the judicial side. He cannot review, recall, modify his own order. But what he has done, he himself has stayed his own order. That particular order by which he has stayed it is at page 97.
And what is the original order, the first order?
53. Actually, my lord, it starts at page 50.
No, need not. Yes, they are relevant.
The operative part is at page.
So everything
50.
was directed. Version to be given an order.
Everything. Well, that generally, my lord is aware that generally happen. But my lord, I am aggrieved. A district magistrate, how can he stay his own order when he has become functus officio? And on this, I am carrying a couple of, if my lord is desirous, I can rely upon.
Doesn't have the power, probably.
Exactly.
You can cite judgments.
Yes, ma'am. May I just copy that? So one of the judgment which I am citing is.
Don't cite too many, cite the best ones.
Well, there are just 3
Oh, three then side.
Yes. So this is of High Court at Ahmedabad.
Do these say that he does not have the power?
Functus officio cannot recall, review, modify his own order once he passes. How can he then stay his own order?
Of these of the Supreme Court? Or
No,
all
my lord.
persuasive?
No, my lord, all are of
I agree with this view. You know, they are
Exactly, my lord. So I just wanted to trouble because of
Yes.
my lord's list.
What do you say?
There is nothing further to say because
Right.
whatever.
The present challenge has been preferred against an order passed by the district magistrate staying his or her. Do you know that?
My lord, I'll just indicate.
Please check up. Staying his own order.
My lord, it says P. Bhattacharya. But
P. Bhattacharya.
I'm extremely sorry, my lord. I cannot make it out from the.
Always the authorities, they should be named actually. I mean, his stroke her করে যাও. His stroke her order whereby the magistrate stayed বললাম. His stroke her order dated March 31, 2022 passed under section 14 of the Surface Act 2002 in favor of the petitioner. Push up, the petitioner stroke non-banking financial institution obtained the original order under section 14 upon compliance of all formalities. Pushed up, it is argued by learned counsel for the petitioner that the district magistrate does not have any authority in law to stay his stroke her own order, comma, since the district magistrate, comma, upon passing an order under section 14, comma, becomes functus officio. Push up, in the circumstances of the present case, comma, the borrower had taken out a challenge before the debts recovery tribunal but could not obtain any interim order before the said tribunal. Push up, a challenge had also been preferred against the same order under section 14, comma, apparently in a writ petition before this court, which was kept pending all along. Pushed up, next para, by the impugned order dated August 23, 2022, comma, the district magistrate proceeded on the premise that since a challenge is pending before this court, comma, he stroke she found it appropriate to stay further execution of the order dated March 31, 2022 for the period of 1 month. Who's up next para? Perusal of section 14 of the Surface Act 2002 indicates that the same is merely by way of an administrative authority vested in the magistrate to implement the order to which a decree to which a financial institution stroke bank is entitled under the Surface Act. Pushed up, the district magistrate does not have power akin to an executing court under Order 21 of the Code of Civil Procedure and or any such parallel power to adjudicate or pass any incidental order reviewing its own order, comma, recalling its own order, and not even staying its own order. Full stop. In fact, comma, as rightly contended by the petitioner, comma, the district magistrate becomes functus officio once it disposes of the application under section 14 of the Surface Act, as in the present case. Full stop. Next para. In view of the above discussions, comma, the impugned order dated August 23, 2022, whereby the district magistrate stayed the execution of his stroke her own order dated March 31, 2022 is palpably without jurisdiction and dehodes the law and thus is amenable to be set aside. First up, accordingly, WPA 28568 of 2023 is allowed, comma, thereby setting aside the order dated August 23, 2022, passed by the Chief Judicial Magistrate, comma, Alipur in miscellaneous case number 520 of 2022. First up, it will be open to the petitioner to take all steps as permissible in law to have the order dated March 31, 2022 implemented at the earliest.
Great.
No orders to cause service. Great. প্রথম লাইন একটা দিয়ে দাও, despite service none appears for the respondents apart from the state. Full stop, affidavit of service filed to be kept on.
Grateful.
অনেক একটা জিনিস despite substantial service করে দাও, 6 পাইনি, despite substantial service. Thank you. Next.
Item 20.
Yes, Mr. Shroff. Yeah.
This matter, your lordship directed for
seeking the clarification from Honorable Chief Justice whether you
Tell me that I don't have jurisdiction, it will be easier for me.
So it is not yet clarified. We have submitted this letter.
Why go before Justice Sengupta?
No, my lord,
Letter from filing says-
my lord, what I submit is that in the determination, it's a false and whether it falls under the police or not police, my lord. In that, my lord, there is a judgment of the Honorable Supreme Court which clearly says that the authority as a PMLA are not police officers. So how can it go to the category under the police?
No, you're right. You have an arguable point there. It has not yet been clarified.
Not yet been clarified. It will be clarified today or tomorrow. So, my lord, can you allow it to remain in the list? So
very well.
My lord, then kindly make it next week, my lord.
Yes, I can. I'll keep it when. Tell me. Give me a date.
Next week, my lord, the difficulty is that they've already issued a notice, and for which it is, my lord, we have to submit reply by 17.
Mr. Can you come back on Friday? Very well. I'll keep it on Friday.
Grateful.
It is submitted by learned counsel for the petitioner that clarification has not yet been obtained from the Honorable the Chief Justice as to whether this court has determination to take up the matter. Push up accordingly, let the matter stand adjourned till January 19, 2024, when it will be listed under the same.
Grateful.
I am for the petitioner filing the evidence.
Yes.
I am appearing before the respondent to the matter. So what happened?
Please take the microphone, Mr.
What happened? I, not having a residential accommodation, purchased a piece of land for construction of my residential house. As the land was not Vastu, I made application before the authority council for conversion from the other character to Vastu.
What was the character?
What was the Shali? It was Shali, then it has been converted to Vastu. After conversion, I made an application before the Panchayat Council for having the plan sanctioned on the land. Plan was sanctioned. After sanction of the plan, I started construction of my residential house. It has been constructed up to first floor. Yet the second floor, the ground floor has been completed. First floor is to be constructed. Now the respondent authorities are trying to lay electric line. If your lordship kindly come to some pictures what I have annexed, the high tension line at page 54, your lordship kindly see the bottom picture at page 54, that where has not been laid down. There are also the second is 55, there is a back-end land where through which the line can be taken. Your lordship knows better than me. There should be a minimum distance as prescribed by the authority for laying the line both horizontally and parallelly. If the line be taken over my roof, just up above the line of roof of my proposed residential second floor house, they are trying to take away. I prayed for them, divert it and take through a vacant land so that my building can be restored. For in the meantime, they called me. I went there. They requested me take the compensation of the land and go away. If they give the compensation, where I will go? What will be the compensation for my residential house which I have been constructed already? In spite of the laws, they have permitted me as there was
the notice for the project was published before you purchased.
Not that. After purchase, after sanction, after starting construction. In spite of the circulars, they have given me the permission. They have been permitted me to construct. I have spent money for construction.
Some other authority permitted you to construct, not the
those authorities whose are to give the permissions. This is the Panchayat.
Panchayat and WBACTCL are two entirely different.
No, your lordship, all bodies were informed by the circular. The circular was not only to one body. It was
but the Panchayat's permission cannot bind the WBACTCL. The Panchayat permission cannot bind the Panchayat, even if knowing the circular, if the Panchayat gave you permission to construct, that does not bind the WBACTCL.
Even that. I am asking myself,
there cannot be any estoppel against state action.
I am asking myself, can an electric line be taken over my roof?
Why did the permission, the sanction, if the sanction was before the project started, before you
The
constructed,
project,
then it can.
when project has been started, I don't know. When it has been approved, it is not.
Let us
not
hear,
true.
Mr.
No, your lordship, yet to be completed the project. Only slightest diversion is necessary.
Let us hear, Mr. Panja. Yes, Mr.
Ballot 2021, 16 November 2021, two papers were notified.
To copy that.
What was modified?
For inviting objections. The project was in by through notification. All persons were invited to. If you have any objection, you
and
can.
they purchased when?
I purchased in 17. 23rd of July 17. Sorry, 19. I'm sorry, 19. I have annexed the deed.
When did you start construction?
I have started construction in 23.
October 23.
Yes, Milord. I obtained plan. Conversion has been.
When did you obtain the plan?
I obtained plan in 23.
Can it be shifted, Mr. Panja? Why not? If not, why not?
Yes. At the fag end of the project, impossible to shift. And on this, Miller, we invited him to sit with us. Yes. State government were there. And Miller, we have already stated that it is the improvement of voltage profile to the Satragachi station, because the Satragachi area improvement. And Miller,
can it be deviated a little bit? Is it possible?
Yes, at the moment, is not.
Tower has been installed. All the towers.
No. Tower has not been installed.
Then,
but other portions have been.
All the pillars have been
completed.
4, 5 foundation where?
And Miller, the tower number 4 and 5, the foundation has already been completed.
How many towers in total required?
20.
Out of 20, 13 has been completed.
Now, Miller, the 13 towers have been completed. The foundation work of in between the land, there are towers, 2 towers, the foundation.
4 and 5 affect his property.
Yes.
Well, only 2 towers. In between 2 towers, my building.
Yes, that is the tower.
Nothing doing. Foundation has been laid. What can be done?
Well,
you have to be happy.
This can be diverted by a single tower. If it 5-6 feet be.
21, it was notified. 23, you obtained the sanction plan.
Lord, in spite of everything, I approach, being a citizen of India, law-abiding citizen, I approach the authority concerned. BLRO permitted me, yes, it is converted. Panchayat, I have applied.
Seek damages against the BLRO and the Panchayat. I'll give you that liberty. Seek damages against the Panchayat for giving you permission.
I've got the report from video, my lord. Page 24.
Why did you give permission?
No, the main problem is the petition is not appearing in the meeting. Meeting it been in the all the parties. Called a meeting. Video called a meeting, inviting all the parties, including the electricity.
So you sanctioned the plan. Plan was sanctioned by whom? Panchayat. Panchayat sanctioned the plan. Why did the
and BLR has converted the land
in the sanction plan? Have you annexed the sanction plan?
No, I have.
Record of rights has been.
I have
29 November 2023.
But it was converted.
I have annexed the plan.
Paragraph 5 of the deed petition.
Conversion was sought from.
Conversion or sought for in 20. R1 was 21. Applied for conversion 23rd. And plan is at page 40. A major portion of the building has been constructed. Even if your lordship permits me, even I may cooperate to compensate some shifting of the same, if possible.
Technically not possible.
No. No, sorry. Nothing doing. The petitioner submits that the petitioner had a Sali land purchased and converted to Bastu upon obtaining proper permission from the concerned block land and land reforms officer in September in the year 2023.
Yes.
So thereafter, the petitioner also obtained a valid sanction plan for constructing a two-storied building on the property from the local panchayat and started construction. However, upon the ground floor being completed and the first floor being on the verge of commencement, the petitioner discovered that two pillars have been installed on two sides of the petitioner's property, and a high tension connection is being sought to be taken over the petitioner's property by the West Bengal State Electricity Transmission Company Limited, bracket, respond number 1, bracket closed, which will be utterly to the detriment of the petitioner. So it is submitted that the entire construction of the building as per valid sanction plan will be hampered if the connection is taken immediately over the property of the petitioner. Thus, the petitioner sought for a shifting of the proposed high tension line, which has not yet been completed, and also is willing to pay a portion of the said shifting, if so called upon to do. Next para, learned counsel for the state submits that the BLLRO sought for mediation in the matter. However, the petitioner has not turned up in the meetings called for by the BLLRO and other authorities. Learned counsel for the WBSC TCL submits that the project was notified as long back as on November 16, 2021. Next para, thereafter, substantial portion of the said project has already been completed. 13 pillars have already been installed. Pillar numbers 4 and 5 are at the stage of the foundation work having already been done. The petitioner's property falls within the said two pillars, that is pillar numbers 4 and 5. At this juncture, it is impossible to shift or deviate from the original project plan, which would involve huge hardship and borders on impossibility. It is further argued that the project is for the improvement of the voltage profile to Satragachi and concerns the amenities to be provided to the public at large. Next para. Upon a consideration of the rival contentions of the parties, it transpires that the petitioner obtained permission to convert the land from Sali to Bastu and obtained a sanction plan to construct thereon, respectively from the BLLRO and the Panchayat, pursuant to which the petitioner started construction. However, the public notification issued by the WBSETCL for the project in question was dated November 16, 2021, that is much before the petitioner undertook such endeavor. Hence, since the public notification is deemed to be a notice to all at large, it cannot be said that the petitioner was unaware in law regarding the said project. Since the petitioner, even thereafter, chose to proceed with obtaining a sanction plan and a conversion of the property, the petitioner has taken a risk for which the petitioner has to suffer now. In any event, the WPSETCL, on query of court, and on proper exploration, submits that it is not possible or feasible to have a shifting of the huge project, which is on the verge of completion. Moreover, keeping in view the balance of the interests of the public at large, which is involved in successful completion of the project on the one hand, and the personal interest of the petitioner, the latter has to give way. Hence, on such considerations, no relief can be granted to the petitioner. WPA 28639 of 2023 is accordingly dismissed. Dismissed on contest without any orders to cost. However, the petitioner shall be entitled to due compensation for the loss suffered by the petitioner due to the project Push up, the WBA-SCTCL shall give an opportunity, shall give a further opportunity of hearing to the petitioner and assess the compensation payable to the petitioner on such score. Full stop. If the petitioner is aggrieved by such quantum of compensation, comma, the petitioner will be at liberty to approach the district judge for appropriate remedy in that regard. For rest to cost,
But can I pay for adding one word? But maintaining the distance as provided. They will take away the line, but maintaining the distance as provided in law. It is their
any stray sentence in that regard would be may create an ambiguity, because I'm telling you why. Because it may happen that you continue with your construction and it may get precariously close to that project. So if you do it after citing this,
I appreciate.
you will not be there when the matter next comes up before the High Court. Some other advocate will be there who will not be knowing this.
Well, I appreciate my lord.
Thank you so much. I'll come back in 10 minutes for the next matter.
22.
22, my lord, I appear for the respondent.
Yes.
I appear for the
I'm for the petition.
Please move the matter. What is your affidavit of service? Yes, what is that?
My lord, I beg to appear for the petitioner, my lord.
Oh, yeah, right. Very well. What is that?
My lord, the petitioner before your lordship is a tenant of a premises, my lord. My lord, what has happened, my lord, due to a civil dispute, the electricity connection of the petitioner was disconnected. Thereafter, upon request to the electricity authority in CSC, herein, my lord, that connection was restored. Till now, we are in the possession of the property. Again, the connection has been disconnected, and we have again requested the CSC authority for restoration of the connection or to install a new meter. But CSC authority, my lord, at my lord, page number 68.
Have you applied for a new meter?
Yes, my lord, I have. This is at page number 67, my lord.
And 68, what do they say?
68, my lord, they have replied to me that a photocopy, they have replied that they have received an objection, although
Their objection.
CSC authority said received an objection, although the objection was not served upon me, and they have not given us the connection.
What is the stage of the eviction suit?
My lord, there was no eviction suit, my lord. We have filed a declaration suit, my lord, declaring that we are the tenant, my lord, and permanent injunction, my lord. My lord, I am still paying.
Have you obtained an injunction there?
My lord, I have obtained an ad interim injunction, my lord. Ad interim injunction over there, my lord. And my lord,
to what effect? What ad interim?
To maintain the status quo, my lord.
Yes.
And my lord, in page number 64, 66, then I am still paying the rent to the rent controller, my lord, and which shows that I am still in the occupation of that premises.
Let us hear the CSC. Yes.
My lord, firstly, my lord, the application has been.
Thus, you are for the landlord. I'll come to you last.
The application has been made by the father, who unfortunately has passed away in the meantime.
That can be taken care of. They can file a fresh application.
If they file a fresh application, upon compliance of formality, we are ready to provide a new loop meter, because we cannot give a meter in the name of a dead person.
What do you say, Mr. Das?
The only thing is, my lord, so far as the suit for declaration and injunction, nothing is annexed to this writ petition.
Do you admit or not?
No, my lord, we have not received any copies as yet.
Or you don't know about the suit at all?
And my lord, there is no pleading in the writ petition to that effect also.
Yes.
But secondly is, my lord, let him show one scrap of document that he is in possession of the property. Because if your lordship, my lord, his father was a tenant, my lord, we admit that rent receipts annexed. Death certificate of his father shows that his father, my lord, went off to Bihar, my lord, he died in Bihar. My lord, there is not a single scrap of document in the writ petition to show that, my lord, the petitioner here is in possession of the property.
Have you substituted the petitioner in the suit?
No, my lord, the suit is filed.
Suit is
We have taken
one
step
more
for
thing, my lord, the father of
There
the
is not a single document to show that he
My
is
lord, in reply to that, my
Neither sees the death certificate of his father, the last page of your lordship's brief. The place of death is, my lord, somewhere in Bihar, and his permanent address is in Bihar.
my lord, in addition,
My lord, the son says, and kindly sees the rain control challans, my lord, all dated of 22. There is nothing to show, my lord, that he has paid it for the current month before the rain controller as well.
And my lord, in the meantime, my lord, the father has also filed an application, my lord, before this honorable court by way of a writ petition, which was withdrawn. My lord, this is the order, my lord.
my lord, that was with
Passed by your lordship itself.
That was technical error itself.
Yes, but it was withdrawn, my lord. Subsequently, the father has expired.
Even on 9th of August 23, the father writes a legal notice through his advocate, my lord, saying that he is a tenant. But from where does the son come into the picture, my lord? No one knows.
Get your point. Yes, what do you say?
My lord, to answer that question of my learned senior friend, my lord, kindly come down to page number 49, my lord. 49 of my lord's brief only, my lord. The petitioner before your lordship is paying the rent, my lord. And my lord, it is a furniture shop. The father used to run. Thereafter, the petition.
You are paying the rent with the rent controller.
My lord, I have.
That does not create any right in your favor.
But my lord, I am in occupation of
anybody and everybody can go and start depositing.
My lord, section 43 says the person who is in occupation, the electricity authority is liable to.
Just because you put in the rent, deposit rent before the rent controller does not show that you are in occupation at all. Even I today can go and deposit rent regarding that property. Who cares? The rent controller won't care. That does not establish your position even prima facie. Section 43 does not come in at all. There is nothing to show that you are ever in possession. And the definition of tenant is very clear in our Premises Tenancy Act.
My lord, that is true. That is true. But
So
my
there
lord,
is nothing to show that you are in possession at any point of time. Why should they give you electricity connection to create a right in your favor?
my lord, the fact is that the petitioner and the father used to run the business over there. That is the fact, my lord. And for that reason, my lord.
And where is your? You have not even mentioned that you have preferred a declarated suit. You have commenced a declarated suit.
We have, and inadvertently it has been not mentioned. Well, it is not separate. That's why, my lord, I have come.
Just because you file a suit, your right has to be canvassed in that suit. No. No relief can be given by the writ court. This will be creating a right in your favor. You don't have a right now. There is nothing to show that you are in possession. Your deposit with the rent control, I'll deal with that. That does not create a right of possession.
My lord, the fact is that the petitioner, the respondent landlord, they are aware of the fact that the petitioner is in possession, my lord, because
they are obviously denying it.
They are denying it at this moment, my lord.
Stay there.
And also, we have taken step with the lower court below to take steps to add the petitioner before your lordship as a plaintiff over there, my lord, as means substitution as per order 22, my lord.
I don't find any prima facie case, nor have you mentioned even your suit here.
And then, my lord, kindly give me liberty. I will come up with an
But even if
supplementary
you filed a suit, that your right has to be canvassed out there. That does not get. What document have you produced to show that you are in possession of the property?
My lord, at this moment, my lord, the rent control is the only thing that I can produce before your lordship, my lord.
Sorry, no. In future, if you have something to show your possession, that you are in possession, I'll give you liberty to apply before the CSC Limited, but not right now.
My lord, just my lord, one thing. I think trade license আছে কত রকম? License কত আছে?
All rent control. Some modern, some primitive.
No, there is a trade license, but
Some are typewritten. Where is the trade license?
At page number 22, my lord. Actually, the main tenant was the Messrs. Basudev Mahato, which was a proprietorship firm named in my father's name, my lord. And trade license has been issued in that name also, my lord.
The name of the holder is Vasudev. Vasudev has expired.
It is Messrs. Basudev Mahato.
Is the name of the holder?
Basudev Mahato. But it has expired subsequently, my lord.
The writ petitioner contends that the writ petitioner is the tenant of a property under the private respondent. So when the writ petitioner took out an application for getting electricity connection, initially the same was when the writ petition previously it is argued the electricity connection of the petitioner was severed upon the petitioner approaching the CSC Limited, the same was restored, Subsequently, when again the electricity connection was disconnected, the petitioner has sought for a new electricity connection, which has not been given by the CSC Limited on the premise that an objection has been raised by the private respondent. Next para. The learned counsel appearing for the CSC Limited submits that previously a similar application was filed by the petitioner's father, but the same was withdrawn. A copy of the said order is handed over in court. However, otherwise the CSC Limited does not have any objection if the petitioner complies with all formalities. It is pointed out that the application filed for new electricity connection was by the father of the petitioner, who has since met his demise. As such, unless the petitioner makes a fresh application, there cannot arise any question of giving such connection. However, next parallel and counsel for the private respondent submits that although the petitioner has submitted that the petitioner has filed a suit for declaration of his tenancy rights, no details of the same has been furnished in the writ petition. Further, the private respondent is not aware of any such suit and no notice thereof has been served on the private respondent. Next para. It is also argued that the petitioner has never been in possession of the property. Even the death certificate of the petitioner's deceased father shows that the said father the said deceased had died out of West Bengal, comma, which has also been shown as his permanent address. Full stop. Thus, comma, in the absence of any right whatsoever regarding possession or otherwise in respect of the suit property of the disputed property, comma, the petitioner is not entitled to any electricity connection in the petitioner's name. Whose of next para, learned counsel for the petitioner submits that given an opportunity, comma, the petitioner is agreeable to disclose the details of the declaratory suit. Whose of that apart, comma, learned counsel for the petitioner places stress on the copies of the rent control challans deposited by the petitioner and annexed to the writ petition. Whose of next para, a perusal of the present writ petition and its annexures shows that the only documents sought to be cited by the petitioner by way of proof of his prima facie possession are rent control challans. Full stop. However, comma, anybody can unilaterally deposit rent with the rent controller on the averment that he or she is a tenant. Full stop. Such deposit by itself does not substantiate even prima facie the occupation of the person with regard to the property in question. Full stop. Next para. The objection raised by the CAC Limited, comma, however, comma, regarding withdrawal of a previous writ petition by the petitioner's father is not tenable, comma, since the order passed therein shows that the withdrawal was due to technical defects and leave was granted to the petitioner to file a fresh writ petition on the self-same cause of action. Full stop. Next para. However, comma, in any event, comma, I do not find anything on record to indicate even prima facie that the petitioner is in settled possession of the property, comma, which is a sine qua non under Section 43 of the Electricity Act 2003 for a person to be entitled to get an electricity connection at a premises. Full stop. In the absence of the same, comma, the writ court cannot issue any prerogative writ directing the CSC Limited to give an electricity connection to the petitioner. Full stop. However, comma, it will be open to the petitioner to approach the CSC Limited in future with relevant documents to indicate and substantiate prima facie that the petitioner is in occupation of the property. Full stop. If so approached, comma, it will be open to the CSC Limited, comma, upon satisfying itself as regards such prima facie occupation of the petitioner, comma, to consider giving electricity connection to the petitioner in the petitioner's name. Full stop. Next para. It is clarified that this court has not gone into the merits of the allegations and counter allegations between the private parties, and it will be open to the competent civil court or any other forum, if so approached by the parties, comma, to decide all issues on merits between the parties in accordance with law, independently of the observations made above. Full stop. However, comma, no relief can be given to the petitioner at this stage. Accordingly, WPA 28660 of 2023 is dismissed without any orders to cost in the light of the above observation.
Only two things, manner. The first application has been made by the father, manner, where manner we went for an inspection and we were obstructed.
Whatever.
Now, my lord, he has made the application in the name of the deceased father.
Yes.
Grateful, Lordship.
Next. না
অর্ডারটা আমি দিয়ে দিচ্ছি অর্ডারটা দিয়ে দিচ্ছি
23.
23, Your Lordship, appear for the petitioner.
Yes. Adoption.
Lordship, on the last date, what had fallen from your Lordship,
Yes.
Lordship to place reliance
Yes,
on the
certainly.
mutual. Lordship, at clause 10, it is specifically written that the wife can take the custody of the child. একটাই আছে সেটা কি করা এখান থেকে দেখো
Ms. Ghosh, what are the relevant provisions of
Lordship.
juvenile justice? Just
Lordship.
please place those provisions.
Lordship, I'll be first placing your Lordship the Adoption and Maintenance Act 1956, Section 7, 8, 9, and 11, subsection 1.
Have you got extra copies of that? Hindu adoption?
Lordship.
Hindu law দেখো Hindu law বা Hindu adoption and maintenance act specific থাকে law of adoption সে থাকতেও পারে নাও থাকতে পারে না থাকার চান্স হ্যাঁ থাকবে আচ্ছা পেয়েছি ছেড়ে please give me the sections once again.
Lordship, Section 7.
Right.
The Section 7, it first states capacity of a male Hindu.
What are the sections? Just give me the sections once. Say 7 and
7, 8, 9, 11, subsection 1, Roman 1.
right. Let us start with 7.
7. Capacity of a male Hindu to take in adoption.
Please give me half a minute.
Lordship.
Please. Yes, capacity of a male. Right.
Lordship. Any male Hindu who is of sound mind and is not a minor has the capacity to take a son or a daughter in adoption, provided that if he has a wife living, he shall not adopt except with the consent of his wife, unless the wife has completely and finally renounced the world or has ceased to be a Hindu or such and such, your Lordship. So, Lordship, the first clause is that it is with regard to the capability of a Hindu male.
So this clears the way for the petitioner number 2,
Petition
the
number
husband.
2, Lordship.
Right. Very well.
Grateful to Lordship.
Yes.
Lordship, thereafter, I'm placing 8 only because it is related to a female Hindu to take adoption. Because, your Lordship, I had submitted on the first date that it is the biological mother
Yes,
who
yes.
can also step into the shoes of a stepmother, or step into the shoes of a mother by adoption. Adoptive parents, she can also be one. So it also clarifies any female Hindu who is of sound mind, who is not a minor, who is not married, or if married, whose marriage has been dissolved or whose husband is dead or such and such. So it also clarifies that this
Ms. Ghosh, whatever happens, the biological mother cannot be the adoptive mother. She will remain the biological mother. The father may become, her husband, new husband may become the adoptive father. That may happen.
Lordship, that
But
may
if I am the biological mother, there will be a conflict. The
Lordship,
same
what
person
is
cannot be a
this?
biological and an adoptive mother.
Lordship, there is a issue, your Lordship. While they were filling up in the portal, they were asked that the mother, the biological mother, should also become one of the adoptive parents. She has to change. And with regard to, we are only on one point, whether the consent can be given by only the mother, biological mother, or father.
Absolutely. Yes.
Lordship, thereafter placing Section 9, person capable of giving in adoption. This is what is applicable. No person except the father or mother or the guardian of a child shall have the capacity to give the child in adoption. Lordship, this first clause only will suffice, your Lordship. The father, it is written, or mother. Lordship, nowhere it is being stated. Lordship, I've gone through the Adoption Act, the Juvenile Justice Act, the Adoption Regulation, and the Guardians and Wards Act. I've gone through this 4 of them. The father or mother or the guardian. Your Lordship, in this case, the Guardians and Wards Act does not apply. So, Lordship, this clarifies.
Proviso. Proviso to 2. Please read the proviso to 2.
Subject to the provision of subsection 3 and subsection 4. Lordship, subsection 3 and subsection 4.
No, leave those alone. Come to the proviso after that.
Proviso.
Provided. Proviso is not there in your book.
Subject to the provisions, your Lordship.
After subject. Subject is number 2.
Lordship.
Yours is probably a...
Lordship, might be not there.
Oh, your book must be prior to 2010.
Lordship.
It is in my book.
Oh, then Ms. Ghosh, you probably have to come more prepared then if it is
Lordship,
here.
Lordship.
But read it.
Lordship. Lordship, it is there in this book.
Yes, yes. Please read it
Provided
out.
that such right shall not be exercised by either of them, save with the consent of the other, unless one of them has completely and finally renounced the world or has ceased to be a Hindu or has been declared by a court of competent jurisdiction to be of unsound mind, your Lordship. This is the proviso, your Lordship.
Would you like to come prepared on some other day on that? That is the
Lordship,
only thing
maybe-
which comes against you.
Lordship, maybe I'll
You'll argue right now.
Lordship.
Very well. Yes.
Lordship,
If this remains, then what happens?
Lordship, if this remains, Your Lordship, thereafter the adoption regulation had come.
No. This is a bar, specific bar. That such right, it's couched in a negative language.
Lordship, that's a
That such right shall not be exercised by either of them. If the father does not give his consent, you cannot place in adoption.
Lordship, but
So
at
it
the
cannot be
very
done.
first, Your Lordship, I am
Father's consent has to be taken, Ms. Ghosh. Not something moral or something. Not that. Law.
Lordship, in this case, Your Lordship, in this instant case, Your Lordship, it is the father who has given his consent that the mother
Custody,
can
getting
keep
custody.
that the mother can take the custody. And thereafter, Lordship, after the mutual divorce took place, the father had not taken any initiative for the welfare of the child. Your Lordship,
Ms.
thereafter
Ghosh, there is a
the
distinction between adoption and custody.
Lordship.
Adoption is far greater than guardianship even.
Lordship, it will change the surname and
Not
the
only say the surname is immaterial. I mean, the custody is the least of it, least right, the lesser right. More than that is guardianship. And more than that is adoption. By adoption, you become a parent.
Lordship.
For all practical purposes, the biological parents are replaced.
Lordship.
You become the parent.
Lordship.
If the father is living, even if there is an acrimony between or a divorce decree between them, even if the biological father says you keep custody of the child, custody can definitely be retained with you. And your present husband, he can also be a part of that. Both of you can have custody, definitely. Have the custody of the child. But even for guardianship, that is also on a higher footing. And adoption, no question of that arises in view of proviso.
Lordship, in that event, Your Lordship.
Here, Juvenile Justice Act does not apply.
Lordship, the
Not a surrendered child or
Juvenile Justice Act will also not apply, Your Lordship.
None of
The
the other
Guardians and Wards Act are also not applying, Your Lordship.
Only this is
Juvenile Justice Act is for the abandoned child, and the other act is
abandoned or child in need of care
child,
and
Your Lordship.
protection
Here
or
there is no such issues, Your Lordship.
no
Only
other
it will
provision.
be the adoption regulation to be read along with the Adoption and Maintenance Act, Your Lordship.
Adoption regulation is under the Juvenile Justice Act.
Juvenile Justice Act, Your Lordship.
This is the bar.
Clear.
Lordship, in the adoption regulation, it provides for the authority of the Kara, Your Lordship, wherein the adoption portal is there, wherein the application has to be made. Your Lordship, at least my application needs to be considered, Your Lordship. On the last date, I have submitted one supplementary affidavit whereby a one-line order they have declined.
No, Ms. Ghosh, if the parent right is not there, I cannot give a direction to that effect. You don't have a right, you don't have the locus standi to place the child in adoption alone.
Yes.
That is the difficulty.
Lordship, then none of the single parent, Your Lordship, can place the child for adoption.
What do you mean by single parent exactly?
Lordship, I mean, Your Lordship,
Divorced parent.
the mother.
You are not a single parent. The
Lordship,
child has two parents.
two parents, Your Lordship.
Single parent means the child has only one parent living.
Lordship, I've just read, Your
Suppose
Lordship, the proviso.
I take a child in adoption singly, then I am a single parent.
Lordship.
If my spouse has died, then also I am a single parent. But if I raise the child, we loosely term her or him as a single parent.
Lordship.
But the raising of the child is by one of the parents. But you are not a single parent. The child has two parents.
Lordship.
The fatherhood cannot be taken away, or the motherhood for that matter.
Lordship.
Either of the two.
Both are alive.
They remain the father and the mother respectively.
Lordship.
However bad the father may be,
Lordship.
he may be the worst person in the world vis-a-vis the child also. But the parentage does not go.
He remains the father.
He remains the father. So adoption cannot be taken or given by you even. If you can't give in adoption, then the application for getting in adoption is not maintainable. I could have creased out that problem which you said. The portal won't accept. But if you cannot give the child in adoption, where does the question come in?
Lordship, may I be permitted to place one more provision of the this is of the adoption regulations? Lordship, if I may be allowed to only read out, it provides for the fundamental principles governing adoption, which says the child's best interest shall be the paramount consideration while processing any adoption.
Paramount consideration has been borrowed from the judgments on this act.
Lordship.
You know that. Paramount consideration is always the welfare of the child. What is the age of the child in your case?
6 years, Lordship. Until date, Your Lordship, nothing.
Intelligent preference has not come. And that too even if the child says that I am not the son of this person, you cannot disown the father.
As per
I
this
mean, you have to
guideline,
accept certain things in life.
Lordship.
This is one of them.
guideline অনুযায়ী,
Sorry, Ms. Ghosh.
Lordship.
I fully sympathize with your client. I mean,
Lordship.
the father also said that take custody of the child, but the parentage cannot go like this. There are limits up to which a court can interfere in personal relations and law. So
Lordship
we have reached that border here.
Lordship.
That is the difficulty. If you are convinced, I'll close the matter.
Lordship.
I'm only trying to convince you so that you stop and I.
Lordship, I am aware of this, Your Lordship. It is like, Lordship, it is they who have rejected, Lordship, on the ground that the consent of both the parents are required only for this clause, Your Lordship.
Custody, yes.
If they are alive.
Custody you already have by virtue of this. I'll
Lordship,
record that.
Lordship,
And guardianship also both of you can apply. Guardianship will suffice. And regarding the use of the surname, I'm telling you,
Lordship.
I mean, there is no bar to the child using the mother's surname.
No.
There is no bar. I can put that also in my order.
Lordship.
I mean, the mother, because the mother has custody,
Lordship.
where is the bar in using your
There is
surname for the child?
bar in using any of the surname.
You are equally entitled as the father to use your
Yes,
surname.
yes.
I'll put that in my order that there is no bar.
Lordship. Lordship.
So that will probably suffice your purpose for them. The present writ petition has been filed by the biological mother of a child of around 6 years and her present husband. Full stop. A divorce decree was passed between the biological mother, that is the petitioner number 1, and the private respondent, comma, her ex-husband. Full stop. The said divorce was passed on mutual consent. Full stop. On query of court, comma, learned counsel for the petitioner hands over a copy of the application under section 13 capital B, on the premise of which the divorce decree was passed on mutual consent. Full stop.
So it is section 28.
Oh, acha, I'm sorry. 13B যেখানে বলো, sorry. Section 28 of the Special Marriage Act. 13B টা section 28 of the Special Marriage Act. বাকি সব। Clause 10 of the said application states that both the spouses had decided that the minor son shall remain under the care and custody of the petitioner number 1 therein, that is the present writ petitioner number 1, and the petitioner number 2, that is the private respondent, within bracket ex-husband of the petitioner number 1, bracket closed, shall not claim the custody of the child in future. Full stop. It is argued by learned counsel for the petitioner that there is no bar within the contemplation of the Hindu Adoptions and Maintenance Act, 1956, for either of the present petitioners to take the minor child in adoption. Full stop. Next para. A larger issue is sought to be addressed by the petitioner by arguing that if the petitioner number 1, comma, who is in custody of the child as per agreement with her ex-spouse, comma, being a single parent, is not permitted to give the child in adoption, comma, the rights of a single parent and the welfare of the child, comma, which is the paramount consideration in such cases, comma, will be hampered. Full stop. Next para. Learned counsel also places cursory reliance on the adoption regulations, comma, which flow from the Juvenile Justice Act in such regard. Full stop. Next para. Heard learned counsel for the parties. Full stop. Although custody of the child has been given to the petitioner number 1 at the time of divorce between the petitioner number 1 and the private respondent, that is the ex-husband of the petitioner, comma, the right of custody is a much lesser right than that of adoption. Full stop. There are 3 rungs to the rights vis-a-vis a child. Full stop. The lowest rung is custody. Full stop. The second stratum in the ladder of rights is the right of guardianship. Full stop. The third and foremost right is the right of parentage, comma, which is conferred by way of a valid adoption. Full stop. After an adoption, comma, the adopted child, comma, for all practical purposes, comma, becomes the child of the adoptive parents, and the relation with the biological parents is severed for all practical legal purposes. Full stop. Next para. Thus, comma, the right of adoption is on a much higher platform than that of custody. Full stop. Next para. Hence, comma, at the outset, comma, it is required to be noted that the conferment of custody of the child on the petitioner number 1 by the mutual consent divorce decree does not tantamount to parentage. Full stop. Next para. In the present circumstances, comma, the only applicable statute is the Hindu Adoptions and Maintenance Act 1956, whose subsection 9 within bracket 2, comma, proviso stipulates that the right of a parent to give a child in adoption shall not be exercised by either of the parents save with the consent of the other, comma, unless one of them has completely and finally renounced the world or has ceased CEACD to be a Hindu or has been declared by a court of competent jurisdiction to be of unsound mind. Full stop. The language of the proviso, comma, it is evident, comma, is couched in a negative language and, comma, thus, comma, has mandatory effect. Full stop. Next para. The specific exceptions carved out in the proviso are not satisfied in the present case vis-a-vis the private respondent. Full stop. Next para. Hence, comma, the proviso to section 9 within bracket 2 of the 1956 Act debars the petitioner number 1, that is the biological mother of the child in question, to unilaterally give the child in adoption without the consent of the other parent, that is the father of the child, within bracket the private respondent, bracket closed. Full stop. Hence, comma, the grievance of the petitioner, that the petitioner's application for giving her child in adoption and the child being taken in adoption by the petitioner number 1 and her present husband, the petitioner number 2, has no premise to stand on. Full stop. Next para. At best, comma, the petitioners can seek formal guardianship legally by way of filing a proper application in that regard under the relevant provisions of this statute from a competent court. Full stop. If so applied for, comma, the same shall be decided by the court independently without taking into consideration any of the observations made therein on merits. Full stop. Next para. However, comma, the petitioner number 1, comma, unfortunately, comma, does not have the right to unilaterally give her son in adoption either to herself or to her present spouse. Full stop. Accordingly, there is no scope of granting any relief in the present writ petition. Full stop. WP 828682 of 2023 is thus dismissed without any orders to cost, with liberty to the petitioners to apply for guardianship of the child before a competent court.
Grateful to your lordship. Lordship, may I take back?
I've referred to this.
Lordship,
Give a
lordship.
copy then.
Lordship, I have a copy.
Copy niye eta diyo.
Grateful, ma'am.
Thank you. Yes.
24.
24, my lord. Yes. I appear on behalf of the petitioner. Subject matter of the dispute in the writ petition is the rejection of my prayer by the appellate authority for shifting the place of business relating to selling of wine. Lord, initially a license was given in favor of one Mr. X. Then I got the license by of a transfer. My name was recorded. There was no dispute. That happened in 2019. Since 2019, I have been carrying on business in the place where, my lord, in respect of which license was given. There was no dispute. Dispute started in 2020 when, my lord, some of the locals, my lord, they, my lord, raised some objection relating to my selling of the liquor in that particular area. So immediately I made an application for shifting. I purchased a land. I made a prayer before the authority, and that was kept pending for some time. So I come up before this honorable court and file a writ petition. Now, my lord, when I filed the writ petition, my lord, suddenly it was brought to my notice that your prayer for shifting was rejected. So it was not within the domain of the writ court to consider, because by that time I filed the writ petition. So obviously I was permitted to withdraw and to file afresh, and certain protection was given directing the police authority, my lord, not to disturb, but to ensure that there is no disturbance, my lord, in the area till my prayer for shifting is finally considered. Now, my lord, subsequently, my lord, I filed a writ petition and challenged that particular order whereby my prayer was negated because there was absolutely no reason was given. That was allowed, impugned action was set aside, quashed, my lord, and directed to reconsider, with a further rider that the police would ensure that there would be no disturbance in the locale, because disturbance was going on. Now, my lord, after reconsideration, when I made the reconsideration after the order was set aside, yet again,
Consideration was it was sent for reconsideration to the
yes,
appellate authority.
no, to the first
First
authority.
authority.
First authority.
Yes.
First authority again rejected my prayer.
First authority is a collector.
First authority, my lord, is not the collector. Collector was consulted, is the excise commissioner, my lord, as would be evident.
What is the appellate authority?
Appellate authority, my
State.
lord. Appellate authority, principal secretary, my lord.
Right.
Now, my lord,
then
kindly, then, my lord, the first authority rejected my prayer.
Again.
Yes, section 30. And there's a provision, my lord, in the rules, my lord, I would show that.
This is of the Bengal Excise Act.
Yes, Bengal Excise section 30 and 31.
Yes.
And, my lord, referring to some other rules, my lord, I would show, my lord, the most important thing, my lord, an opinion was required to be sought for. That's the provision, what it says.
Opinion from?
Opinion, my lord, from a provision by the.
From the local
no, not from the local, from the my lord, the inquiring officer, if I may say so. I will, my lord, tell your lordship his designation, my lord. That opinion had never been reflected. And secondly, my lord, it was rejected on the ground that section 30 says it's an absolute discretionary power of the authority, as well as public demand is the most important thing. Now, my lord, the fact that I purchased a land in a different area and I, my lord, wanted to take this risk, my lord, that has not been considered. So immediately after coming to know, my lord, I, my lord, realized something was going, probably it is not correct. I made an application under RTI. Now, my lord, I got to know, my lord, there was another gentleman who applied, my lord, for license, not in respect of the same area, but in respect of another area. There, my lord, 4 liquor shops were existing. In spite thereof, my lord, the license was given to him and his prayer for shifting was allowed. So this, my lord, possibly can't be done, the discrimination. And the discretion, my lord, lordship knows, has to be used judiciously, my lord. It can't be arbitrarily. And there has to be some principle.
In your case, the refusal was not on the ground that there are other liquor shops there.
Yes, one of the ground. Public demand. But the opinion, my lord, not at all been reflected.
Public demand in that sense, that there are already existing.
Yes, yes. In my case, it's 2. And the case, my lord, where. My lord, other factors are there, my lord. I did not tell you a lot.
The area may be drink prone.
My lord, the factor is, my lord,
depends on the area. If it's in Park Street on a Christmas night, then it may be.
That's true. That's true. But all in the suburbs, not in the city.
The suburb also has its own Park Street.
Yes, yes, of course they have. They have,
and everything.
And my lord, why should there be a discrimination? If we can enjoy Christmas moving around in the Park Street, they can also enjoy in their sub-blood area. My lord. But my lord, there are other factors, my lord, which I can't.
Discrimination is one of the grounds, you say.
Yes. My lord, kindly, my lord, come to the 2 orders, my lord, once. Rejection order, my lord, page 59. I'm not, my lord, showing your lordship the previous order.
Previous orders need. Page 59 is the rejection, first rejection.
After this was set aside.
First
yes,
means first
yes,
authority.
Yes. Lordship has got this, no? Lordship has.
No, not yet. Give me.
Page 59, my lord.
Yes,
Lordship.
Yes.
May I, my lord, place this one? In compliance with the order dated 1st June 2023, passed by the Honorable High Court dated so-and-so, hearing has been conducted on so-and-so, to reconsider the order rejecting the application for shifting of the excise license from its existing site. So-and-so, the area has been coded. Hearing has been conducted on virtual mode in presence of the client's name and the superintendent of excise Birbhum as representative of the collector. Now, my lord, the learned advocate appearing, my lord, the learned advocate who appeared, my lord, he has made his submission. He says because of the local disturbance, my lord, lordship would find that has been quoted. The appellant decided to shift the license and accordingly applied for shifting from the existing site to a newly proposed site. He has argued that the newly proposed site so-and-so is free from all restrictions as imposed by Rule 8. That I will show there is no bar at all. And I have complied with everything excepting the fact the public demand. Further, he contended that there is no restriction in granting more than one license in a particular area. He prayed for allowing the application for
Let us come to the reason.
Yes, the reasoning, Milord, kindly, Milord, come.
The
Milord.
court the authority says that there is no bar.
Yes, I find that newly proposed site is free from all restrictions imposed. There is no bar at all. He accepts, but non-existence of any encumbrance and just qualifying the Rule 8 is not only the criteria. Opinion of the authority in respect of suitability of there lies, Milord, the discretion. And other factors are there, of course, which I did not entertain. Opinion of the authority in respect of suitability of the proposed site for shifting is also an important. In the existing site, the license was granted having regard to the public demand, Section 30 of the BE Act 1909. In any situation, if shifting of license becomes necessary, then site should be proposed in accordance with demand of the locality, which will be duly weighed on by the license granted by the granting authority. In the instance, it is found that there is concentration of the licenses around the proposed site, such as 3 retail excise licenses are there within 1.5 kilometer of the proposed site and 7 within 5 kilometers of the same site. As per the available sale data of the existing 10 shops, it appears that in their combined sales figures remains fairly constant over the last few years, not recording any exponential growth, and therefore a new shop does not have any commercial prospect in that area. In my opinion, the existing retail outlets are sufficient to cater the local demand. Another license will lead to concentration of the license with a small radius of space. The applicant are not justified for the reason. So that's the only ground for rejection.
But decision-making process is all right, Mr. Dev.
Milord, 2 things, Milord, I would submit.
We cannot replace our views for that of the authority.
No, the discretion is always there.
The reasons have been given.
I'm not saying it's an absolutely, Milord, unreasoned order, but I say when you, Milord, Milord, kindly come to the other factor before I address on law, Milord, for 5 minutes. Milord, I have made an application for, Milord, under RTI law. I will show that. Kindly, Milord, come to page 89 and 90. 89 and 90. After making an application, and I've got this all facts, Milord.
This RTI information was before the authority when it considered?
No.
Afterwards.
Afterwards.
Yes.
Now, Milord, kindly sees, Milord, Deputy Excise Collector to the Superintendent of Excise Birvum, inquiry report and so. Name of the applicant licensee, name has been there. Kindly, Milord, comes to, Milord, page 90 straightway. The opinion of the inquiring officer. Possibly that has to be in writing, and there has to be a specific opinion on this. Not that you can consult or consult it with, come to a finding without referring or quoting the opinion itself. That's the provision possibly. In course of inquiry, it has been found that it is difficult to run the license as the existing premises, as the shop is situated in a congested area, as my case is, Milord, and surrounded with residential houses. In view of the above, the prayer for licensee is hereby recommended for according necessary approval from the Excise Commissioner, West Bengal, for change of premises of so-and-so from the existing site to the proposed site in the interest of augmentation of government revenue after proper inquiry of the proposed site in terms of Rule 8 of the West Bengal Excise, selection of new sites, grant of licensee. Rules have been quoted. Public VD Excise Department numbers were subsequently amended. So straightway this has been accepted. Now, Milord, what is the ground for rejection, Milord? That particular thing, public demand and the discretion, Milord, I submit, Milord, before your Lordship, Milord, it has to be excised judiciously in contemplation with, Milord, Article 14. You cannot accept somebody's application where, Milord, 4 existing shops are there without giving anything, just you accept. And then in another case, when it comes to, Milord, entertaining, then you say, just because of the public demand.
But do I get that there are 4 existing?
Yes, Milord, I would show.
This is country liquor?
Initially country liquor, then foreign liquor, Milord.
The other shops in your case are also, they also sell foreign liquor?
Yes.
Similar?
I'm not sure, possibly.
Not sure.
Not sure. But just give me a minute's time, my lord. Half a minute's time, my lord. I will show. Marco, page. Yes, kindly come to page 83 once, my lord. I'm sorry, my lord.
You have not placed the appellate authority's order.
Yes, I will. I'm sorry, my lord. Page 83.
83. These are those.
Yes.
4 shops.
4. It's an admitted position. Now, my lord, kindly, my lord, comes to the appellate authority's order, which is at page 72. Almost on identical grounds, my lord. Lordship has gotten page 72.
Yes.
My lord, first paragraphs.
Yes, same.
Brief facts, same. Then, my lord, the reasoning. Kindly come to the last paragraph, paragraph 5.
Heard the part.
Yes, I have heard the parties and have gone through the documents on record in the order dated so and so, which is under challenge in the present petition. Excise Commission of West Bengal, my lord, has adequately dealt with all the provisions under the extent.
It's almost a replica of that.
Absolutely, absolutely. Then, my lord, Rule 8 has been quoted, is valid. It is not the only factor. It's the same thing that needs to be considered while allowing shifting of site, but an excise public demand of the area is almost replica, my lord. Quoting section 30 of the Bengal Excise Act 909. Now, my lord, kindly have a look at, my lord, the Bengal Excise Act once. I have the copies, my lord. Got the Xerox copies, my lord, for your lordship.
Thank you. Yes. Yes.
Section 30, my lord, deals with selection of new sites for grant of license. In my case, it's a case of shifting.
Is there any other provision for shifting?
Yes, yes, absolutely, my lord. West Bengal excise shifting of existing site or change of premises of excise license rules 2009. My lord, Rule 4 specifically describes the procedure of shifting, my lord.
Right.
Now, my lord, how the application has to be made, 4.1 it deals with.
So, possibly you can take your seat, both of you. Both of you.
4.2 is also the procedure, my lord, how I have to make an application, non-refundable fees and all that. I am not on that. Kindly, my lord, come to 4.2. 4.2, I'm sorry. 4.2. On receipt. Yes, on receipt of the application, referred in sub-rule 4.1, the collector shall be competent authority to consider the application of shifting of an existing site for retail sale of liquor and certain other intoxicants where the proposed site falls within the same ward, Gram Panchayat, where existing site is located, and the proposed site is objection-free in terms of Rule 8 of the West Bengal, so-and-so rules have been amended.
4.3 is more appropriate.
Yes, in all other cases not covered by where an application for shifting of an excise site or change of premises of an excise license premises has been made, the collector shall forward the application of shifting of site or change of premises with his opinion in writing. I was harping on that. And in the other case, where, my lord, the ship.
Yes.
Sorry, my lord.
And he has to be satisfied with 4.3.1 and 2.
Absolutely, my lord. Having regard to the reasons for shifting specified in the application and the realization of revenue or potential in that area, while forwarding the application to the excise commissioner, the collector shall specifically record his satisfaction or otherwise as to whether the proposed site of the excise license for retail of sale of liquor and certain other intoxicants does not attract restrictions imposed under Rule 8. I have not violated any of the provisions, my lord. That's an admitted position. Only the public demand, and this has to be read with the opinion in writing of the collector. That has never been forwarded to me, my lord. This is my instruction. And in the other case, lordship would find there was a written in writing opinion, which I got it after making an application under RTI, that in spite of the fact there are 4 existing liquor shops, my lord, permission was given. Why not me, my lord, in my case? This is my case. And the word discretion, my lord, I accept it's a discretion. But this has to be read with, my lord, the word, my lord, judiciously. It can't be arbitrarily. You have to comply with all the provisions of law. And it can't be contrary to Article 14, my lord. You can't treat one person differently and the other person in a different note, on a different note, my lord. That can't be done, my lord. You give your reason in writing. I took the chance and the objection is on record, my lord. The other locals, my lord, which compelled me to make an application. Nothing, my lord.
Yes, Mr.
Lord, so far the order is concerned, my lord, in the first order, my lord, in the last paragraph, it has been mentioned, my lord. However, page 60, that, my lord, that however, the appellant is at liberty to apply afresh for shifting to any other suitable place.
Why not
suitable
this place?
site. No, my lord, because of the reason, my lord, there are 7 plus 5, my lord, 2, 3. My lord, 7 existing, my lord, liquor shops are there. All are country liquor shops, my lord. It is application is for country liquor shop. So, my lord, 7 is there, my lord. Now, so far the 4.3 is concerned, my lord, which has just now reported.
Yes.
Just now read it, my lord. My lord, kindly see, my lord. It has been mentioned, my lord, that 4.3 in other cases covered so and so where application for shifting of an existing site or change of premises of an existing licensed premises has been made. The collector shall forward the application of shifting of site, change premises with his opinion in writing so and so. Thereafter, my lord, the realization of revenue potential in that area. Now, my lord, here, my lord, it has been specifically mentioned in both these orders, my lord, that with regard to the revenue purpose, my lord. Now, 7 shops is there, my lord. Now, 8 number of shops, my lord. Already the sale in that area is not so potential, my lord, for which the revenue has been earning. Now, number 8 shops, my lord, it would, my lord, amount to lesser revenue that we have my lord, received now, my lord. Already, my lord, in that area, I am on instruction, I am saying, my lord, we're already less than 10%, my lord, is decreasing the sale. Now, the area where he has, my lord, initially he has doing his business, in that area from 2019, for some reason, I do not know, my lord, he has unable to do his open his shop. And purposely, my lord, 2, 3 orders are passed, my lord, wherein, my lord, this court direct him, my lord, to make an application before the police authorities for taking steps of that.
Reasons for shifting is very obvious.
So, my lord,
there is disturbance there, so he has a right to shift.
Now,
But the
my lord,
question is whether it can be shifted to where he is wanting.
Yes, my lord. Now that is why, my lord, we have given him this offer, my lord. The appellant is at liberty to apply afresh for shifting to any other suitable
So,
site.
Mr. Malik, 2 specific questions have been put by your learned friend.
Malik.
One is that another person on equal footing, there 4 liquor shops are existing. They have been given permission, and it appears from your RTI information
Malik.
that the suitability of that place has not even been considered. Just because there is no bar, no restriction, that person has been allowed. I mean, how come this distinction between the two?
No, my lord. So far that area is concerned, my lord. So far that
Although it's a different area, undoubtedly.
lordship. Within 5 kilometers, that is 4. Here it is 7. And
Acha, another aspect is that where is the opinion in writing from the collector? I mean, nothing is reflected anywhere.
now, my lord,
That
the
is also a
order,
point.
my lord, if his lordship, my lord, gone through the order once, my lord,
Yes.
it has been mentioned, my lord, peruse the case record considering the verbal written submission. I find that the newly proposed site is free from restrictions, so and so rule it, no and so. Opinion of the authority in respect of suitability of the proposed site for shifting is also important in the existing site. My lord, here, my lord, it has been mentioned, my lord, the opinion of the authority. Now, my lord, in the existing site, the license was granted having regard to the public demand, section 30. In any situation, if shifting of license become necessary, then site should be proposed in accordance with the demand of the said locality, which will be duly weighted on by the license granting authority. In the instant case, it is found that there is concursion of
Concentration of
license.
licenses, yes.
Lordship. So, my lord,
Well,
the
yes, any reply?
Sorry, my lord, I just wanted to cite one judgment, my lord, on this relating to, my lord, the word discretion, my lord. Lordship, my lord, wants 2004, my lord, volume 2 Supreme Court cases, page 370, I just missed it, relating to, my lord, the word discretion, how it has been defined.
No, no.
Paragraph 8, my lord, if lordship sees, my lord. and the opinion has to be in writing. Consultation, discussion, that cannot be constituted as an opinion in writing got from the collector. And there is a clear discrimination. Wait a minute.
Para 8.
Statutory
discretion.
Yes, para 8 and 9, my lord.
Citation টা
No.
Citation টা লিখে নিন।
Yes. It pass my order.
My lord.
Learned counsel for the petitioner contends that the petitioner had applied for shifting of his liquor shop from the existing location to a different one. Full stop. When the petitioner applied for the same comma, initially there was a rejection which was challenged before this court. Full stop. The matter was remanded to the first authority with a direction to reconsider the petitioner's application. Full stop. In the meantime, comma, police protection was afforded to the petitioner to ensure that the petitioner smoothly carries on the business in the existing location. Full stop. After similar orders being obtained by the petitioner twice, comma, ultimately by the impugned order, comma, the excise commissioner refused the application of the petitioner, which was affirmed by the principal secretary, comma, which is the appellate authority under the Bengal Excise Act. Push up. Learned counsel contends that subsequently the petitioner has obtained information under the RTI Act, Right to Information Act 2005, which indicates that a similarly placed person's apostrophe's application for shifting was allowed despite the transferee location having already 4 existing liquor shops. Full stop. Hence, comma, the respondents are guilty of discrimination, comma, which is violative of Article 14 of the Constitution of India. Full stop. Learned counsel further submits that although Section 30 of the Bengal Excise Act 1909 has been cited by the respondent authorities, comma, the discretion conferred therein is subject to the provisions of the West Bengal Excise within bracket shifting of existing site or change of premises of excise license bracket closed rules, comma, 2009. Full stop. Clause 4.3 of the same, comma, pertaining to procedure of shifting, comma, clearly provides that before deciding on an application for shifting, comma, the opinion in writing of the collector is to be forwarded to the excise commissioner having regard to the reasons for shifting, comma, keeping in view the realization of revenue potential in the area. Full stop. The collector shall also specifically record his satisfaction or otherwise as to whether the proposed new site is free from restriction and the proposed site is suitable in all respects, comma, as may be applicable, comma, for grant of license for all other categories of license not covered by 4.3.1. Full stop. In the present case, comma, there is no reflection of any such written report from the collector being considered. Full stop. Next para. It is contended by the petitioner that the refusal of the petitioner's request for shifting of location, comma, despite there admittedly being no restrictions otherwise, comma, is tainted and is required to be set aside. Full stop. Next para. Learned counsel places reliance on the judgment of National Insurance Company Limited versus Keshav Bahadur and others reported at 2004 to SCC 370, where it was held by the Supreme Court that a statutory discretion is not necessarily or usually absolute, but must be qualified by express and implied legal duties to comply with substantive and procedural requirements before a decision is taken whether to act and how to act. Full stop. Next para. Learned counsel appearing for the respondent authorities places reliance on the impugned orders and submits that the said orders clearly reflect that all documents and relevant materials were considered. Full stop. It is thus clear that the written opinion of the collector must have been considered while passing the said order. Full stop. It is further submitted that the impugned orders clearly record that there are as many as 7 retail excise licenses existing in the vicinity of the proposed new location. Full stop. 3 excise licenses are within 1.5-kilometer radius of the proposed site, and there are other 7 within 5 kilometer of the same. Full stop. Thus, in view of the sales data of the existing 10 shops indicating that the combined sales figure remains fairly constant over the last few years, and there being no exponential growth in that regard, the decision to refuse the petitioner's application was justified. Full stop. A consideration of the judgment cited by learned counsel for the petitioner clearly shows that the proposition is well settled that a statutory discretion is attended by compliance of the express and implied legal duties of the authorities, whose discretion cannot be unfettered but is also circumscribed by the requirements of law. Full stop. Let us consider in the said backdrop the facts of the present case. Full stop. It is clear from the impugned orders that the authorities clearly observed that that the newly proposed site is free from all restrictions imposed by Rule 8 of the 2003 rules. Full stop. However, both the authorities below considered the fact that in the existing site, the license was granted having regard to public demand, but in the newly proposed site, there are already 10 other existing liquor outlets. Full stop. It is clearly recorded in the orders that the concentration of licenses around the proposed site, taking into consideration 3 retail excise licenses within 1.5 kilometers of the same and 7 within 5 kilometers of the same, read in conjunction with the available sales data for the existing 10 shops, which shows that the demand has been constant in the area over the last few years, clearly indicates that there was sufficient basis for the authorities to come to the impugned conclusion. Full stop. Next para. It was observed by the Excise Commissioner and affirmed by the appellate authority that another license in the area will lead to concentration of licenses within a small radius of space. Full stop. Next para. In the same breath, the petitioner was given the liberty to apply afresh for shifting to any other suitable site, thereby lending credence to the petitioner's contention that the existing location of the petitioner's shop is not suitable to carry on the business further. Full stop. Next para. Insofar as the other comparable unit sought to be projected by the petitioner, the same is numerically different from the present. Full stop. Whereas there are existing 4 shops in the area where the proposed site was allowed for the other comparable person, in the present case, there are as many as 10 liquor shops in the close vicinity, 3 being within 1.5 kilometer radius and 7 within 5 kilometers. Full stop. Moreover, there can be a subjectivity in the discretion exercised by the authorities, keeping in view not only the objective consideration of the public demand and sales in recent years of the existing shops, but also the suitability and demand peculiar to a particular area, which has to be unique, for lending propensity to the area for further consumption of liquor. Full stop. Next para, I find from the impugned orders that both the authorities below took into consideration all the relevant factors, including the propensity of the proposed new site to absorb further business in liquor, full stop. The sales figures of the existing 10 shops over the last few years has been taken into consideration, full stop. In the order of the excise commissioner, comma, which has been affirmed by the appellate authority, comma, it is also recorded that all the written submissions and the materials on record were taken into consideration, full stop. Next para, since a presumption of correctness is attached to all official and judicial acts, comma, in the absence of any concrete rebuttal, comma, there is no reason to assume that the written opinion of the collector was not taken by the excise commissioner while passing the impugned order, full stop. In any event, comma, there is no legal requirement for the said commissioner's opinion to be quoted verbatim in the order refusing or allowing an application for shifting, full stop. Next para, insofar as the applicability of clause 4.3.1 of the 2009 rules is concerned, comma, the same also takes into consideration the realization of revenue potential in the area, comma, which is reflected in the impugned orders, full stop. Section 30 of the Bengal Excise Act 1909, comma, although pertaining to selection of new sites for grant of licenses, comma, stipulates the tests which are equally applicable to grant of permission to shift to a new site, comma, since the material considerations for setting up a new site and shifting of a new site to a new area are comparable and similar. Full stop. In such view of the matter, comma, this court does not find any fault or flaw and or arbitrariness or discrimination in the decision making process of the authorities while passing the impugned orders, full stop. Hence, comma, there is no scope of interference in the present writ petition. Accordingly, WPA 29228 of 2023 is dismissed without any orders to cost, full stop. However, comma, in consonance with the leave granted by the excise commissioner to the petitioner, comma, it is made clear that the petitioner will be at liberty to apply afresh for shifting of his liquor shop to any other suitable site than the one which has been turned down by the authorities. Full stop.
Lordship.
No
Get-
response. Sorry.
Lordship. No, Lordship. May I, my lord, file the affidavit of service?
প্রথম লাইনে affidavit of service filed to be
Grateful, my lord.
Lord, under extreme compelling circumstances, my Lord, one matter I am, my Lord, seeking leave of your Lordship to move, my Lord, unlisted. My Lord, it's a section 14. My Lord, the authorized officer is being, my Lord, empowered, my Lord, by the police help, my Lord, in the year 2022. My Lord, though, my Lord, the statute mandate this order to be valid of 60 days.
I cannot make any exception. I've refused all. Come back on Thursday. Or file it and mention on Thursday. We'll see.
But today, tomorrow they will take possession. That's why, may I file and give the number to your Lordship's officer so that I can meet tomorrow?
No, Mr. Mukherjee. File it in due course.
Wait.
Call on this.
25.
Yes.
I appear for the oil company respondent numbers 1, 2, and 3.
Right.
I am for the private respondent number 5. My lord, I am praying for to put this on record. Kindly.
Keep it with you. What is this?
This is a minutes of meeting dated 12th January.
Let them move the matter first.
Madam, may I just indicate to your lordship broadly what were the disputes raised in this writ petition?
Yes.
The first issue in this writ petition was regarding minor non-renewal of the distributorship, LPG distributorship, in favor of a partnership firm, namely Alolika. Now, Alolika had two partners, or has still two partners. One scheduled caste member is a partner, the majority partner, and another the petitioner before your lordship. My lord, what happened in 2022, an application was made, jointly made by the petitioner, the partner, the then partner, and my lord, the proposed partner, for reconstitution of the partnership and the reconstitution for the purpose of this distributorship. Now, my lord, this was submitted online. In the meantime, my lord, disputes and differences arose between the partner, the outgoing partner, and the petitioner. My lord, when we came to this honorable court, we were having this apprehension that the distributorship may not be renewed. During the pendency of the matter before lordship, my lord, a meeting was convened on January 12, 2024.
What was the original challenge in the writ petition?
My lord, two issues. One, non-consideration of the application for reconstitution, which has been submitted by all the parties. Number two, my lord, non-renewal of the distributorship. So far as the non-renewal of distributorship is concerned, my lord, the distributorship has been renewed, subject to, my lord, whatever Mr. Maul would say, submit, has been renewed on and from 12 January 2024. And that too with the existing partners. That means, my lord, the partner, the private respondent, and my lord, the petitioner. But one issue still remains, that is the non-consideration of my application or the joint application for reconstitution of the partnership for the purpose of this distributorship. So, my lord, that is prayer in the writ petition.
What was the nature of the reconstitution?
My lord, the scheduled caste member would go out, would take the exit route, and another scheduled caste member would be inducted, who is also a party to these proceedings. And accordingly, my lord,
deed of retirement.
My lord, he has already submitted deed of retirement, my lord, and my lord, the new, the proposed partner would be included in the business, and the deed would have to be reconstituted, or the distributor would have to be reconstituted. But there is a prayer E your lordship will find in the writ petition. May I take your lordship to that particular page?
Page 33.
Page 33. So this prayer still survives.
Very good. So this is the writ petition.
This is now, my lord, this petition is all about this. But, my lord, we have not been favored with the copy of the agreement which has been executed on January 12, 2024. That is on instruction I am submitting. I think, my lord, Mr. Chatterjee appearing for the private respondent has also not been favored with a copy of the agreement.
Also, I beg to say 2-3 things. One, Lordship, regarding the reconstitution, I humbly submit this petition the scope of this petition cannot be enlarged presently. The pretext of this petition is that one of the police in action matter which has been filed by my client was not allowed to sit in the shop for a long period of time, and he was restrained by the 25% shareholders and their musclemen. That is the allegation.
that is pending. In that conspectus, this petition has been filed. So far, the reconstitution prayer is concerned, I have objection to that. If your lordship wants me to file the affidavit on that, I can produce the documents, how they are disturbing. Now,
No, Mr. Chatterjee, you did not join in that filing, in that online application.
yes, I joined.
Then what is your objection?
I do not have any objection. Now only thing I want from this court lordship that let it remain like that 75-25% shareholding pattern as it is there.
No, the unless the reconstitution is approved, it has to remain as it is.
As it is, and let me be allowed to go and participate in the day-to-day business.
That would again be beyond the scope of this.
Yes, writ petition.
If your lordship wants that, then I have to make that case. I have to come up with an affidavit.
With an affidavit, you cannot come up with a new prayer. This is not your writ petition. Your writ petition is pending.
Pending.
That writ petition shall be decided independently, has to be. But within the scope of this, now it boils down to only the consideration of your reconstitution proposal.
Right.
I say that was not my proposal at all. I was forced to do that.
You said that you have no objection to that?
I have no objection to present agreement and to continue with the business. But regarding
you said that
reconstitution, I have serious objection.
you did not join in that reconstitution proposal.
125.
Right now, I do not want.
No, at that point of time, you had applied.
Lordship, that proposal.
Right now, you do not means you at that point of time you did.
There was no proposal at all. That's why it was not considered by them. Kindly come to their decision on that day.
But I will come.
That dated decision dated 12/1/2024 says both the partners, Messrs. Alolika, acknowledge receipt of the email dated 11/1/2024 from TM LPG Kolkata towards renewal of the distributorship agreement. Mr. Kashinath Das is 75% shareholder and Messrs. Alolika, whereas other partner, Mr. Anindopal, holds only 25% share. Both the partners were told that their agreement with BPCL is due to expire on 14/1/2024 and we do not have received any request for renewal of agreement from partners of Messrs. Alolika till date. Both the partners of Messrs. Alolika, Anindopal and Messrs. Kashinath Das submitted letter dated 12/1/2024 towards renewal of the distributorship agreement and told us that they wish to renew the agreement today itself under no pressure from anybody. Both the partners agreed to resolve the dispute arising among the partners. Implementation of the clauses of partnership duly approved by the BPCL.
How is this relevant to my question, Mr. Chatterjee?
Your lordship wanted me.
What did I ask you?
That whether even they have.
What did I ask you?
That whether I raised this question, whether I gave the proposal.
That is the difficulty with you, Mr. Chatterjee. You don't hear the question and start answering. The specific question was, is it your case that you did not join in that application for reconstitution? Because a joint application was filed for reconstitution. Nobody is caring about the renewal right now. My specific question to you is whether you joined in that reconstitution application. There was a joint application. You are saying no.
I joined there.
You may say that now you do not agree. But why are you not being truthful to the court, Mr. Chatterjee?
Yes,
this is the peculiar sort of advocacy I'm seeing from you.
No, sir.
You did not apply jointly with them for reconstitution.
Reconstitution I joined. But now, that's why Lordship said.
No question of but now. The question has only one leg. Whether you joined in that application for reconstitution or not.
Joined.
Once you're saying yes, once you're saying no. Once you're saying now I don't. Once you're saying then you didn't. You had joined in an application. So the question now which falls for consideration is whether even if you joined in that application for reconstitution, if you don't want to press that at this point of time, whether the petitioner can compel you to join.
Yes.
That is the only question to be decided here.
Yes.
Now, before that, I'll ask Mr. Mal. Mr. Mal, has the renewal been effected?
Renewal has been effected on Malada.
Naturally, on the prior constitution of
yes, ma'am.
Has to be because no reconstitution.
Pre-existing arrangement, my lord. Pre-existing.
But because the policy, my lord, I'll make it clear. My lord, the private respondent, my learned friend is appearing for, is a scheduled caste candidate.
Right.
Now, the policy of the Ministry of Petroleum is that he can, my lord, bring in one partner having not more than 25% share just to facilitate funding of the dealership. So, my lord,
So the premise of that renewal, Mr. Mal, was apparently his presence as a scheduled caste candidate.
Of course, and my lord, because of his prayer, my lord,
Or rather, he's being a scheduled caste candidate.
my lord,
That
whether
was
he-
the premise.
whether he exits and another scheduled caste will come in as per their choice.
Right.
My lord, cannot be the policy of the petrol. Their dealership will float new advertisement and will appoint any new
No,
dealer.
Mr. Mal, if the partnership is reconstituted,
Already reconstituted on 12th January.
no,
No,
you have
no.
renewed.
No, not renewed, not reconstituted.
If the partnership is reconstituted and a new scheduled caste candidate comes in place of Mr. Chatterjee's client, then also the composition remains the same. Mr. Chatterjee, please. Then also let me understand the contours of the case. Then also the situation remains the same insofar as you are concerned.
No.
Because why not?
Because, my lord, the process of appointing a scheduled caste candidate is gone through a system. My lord, today, my lord, because he walks out and he decides to bring in someone else, will not be in the public domain. Advertisements are floated. More than one scheduled caste candidate may apply for the same, my lord, dealership. My lord,
The partnership, you have already renewed the partnership, the dealership of this partnership firm.
in his name.
The person behind you, please don't go on nodding your head. It's very irritating. Either you hide behind Mr. Chatterjee, who is sufficiently able to cover you, or don't go on nodding your head continuously. It's very irritating. Yes.
Well, there was a partnership in which my learned friend, being the respondent number 5, was 75%. My lord,
Mr. Mal, what is your policy? That one person has to be a 75% shareholder, has to be a scheduled caste person.
Yes.
That is the policy.
That is the policy.
Hmm.
But the selection is done through open advertisement. There are number of applicants, my lord. Their credentials are being, my lord, tested.
Right.
And there are other parameters, my lord. My lord, it is not that only because someone is a scheduled caste can substitute this scheduled caste candidate.
No, the difficulty now, if you have renewed in favor of a partnership, if the partnership is reconstituted, then what is the law?
We may not accept it.
Because the reconstitution has to be with your permission.
That's right. That is as per the agreement.
My lord, may I just take your lordship to?
Then this is the conspectus of
Yes,
the matter.
ma'am.
Let me hear you on merits. Then Mr. Chatterjee, I'll hear you and Mr. Mal.
Kindly take page
You
one.
are for?
The proposed partner who seeks.
You'll be supporting Mr. Mujumdar. Then Mr. Mujumdar argues first. You supplement if anything is left out. Then I'll hear Mr. Chatterjee comprehensively and Mr. Mal.
My lord will kindly take.
Mostly Mr. Chatterjee, because you have to answer.
May only one question before Mr.
Yes, yes,
Mujumdar starts also, that I am not appearing for the proposed scheduled caste candidates. That's 75%.
Yes.
I am for the present.
You're not for the proposed. You're for the disposed scheduled caste candidate.
Existing.
Outgoing candidate.
Yes.
Existing.
Yes.
But
That
may
is
I-
very clear by now. Yes, Mr. Mujumdar, argue. Argue with or without the beard.
My lord,
On
may I
this side,
just?
that side.
I understand, my lord. My lord, may I take your lordship to straight away page 121?
Yes.
My lord, this is an application in the prescribed form.
Yes.
But this form is appended to the detailed guidelines for reconstitution of LPG distributorship 2018. But this application was made sometime in the month of March or April 2022. Now, your lordship will find, my lord, kindly take, my lord, the details of existing deceased incapacitated proprietor partners. My lord, the first name your lordship will find under serial number 2A is Kashinath Das. That is, my lord, Mr. Chatterjee's client, who had 75% existing share and who is supposed to retire. Then Anindo Pal, that is my client, who has 25% share to continue. Now, my lord, now again, my lord, the details are given. Now, your lordship may kindly turn over and take page 123, which is continuation of this form only. Your lordship will find each and every page, the relevant pages have been signed by Kashinath Das at the end of the form. Sorry. At the end of the form, your lordship will find that has been signed by both Kashinath Das and Anindo Pal. Kindly take serial number 9 at page 123.
Yes, incoming partner.
Incoming partner is Obhijit Mollik, who is again a scheduled caste
Yes.
candidate. Now, kindly turn over and take the next page, page 124 again, part of the application. This is an undertaking given both by Kashinath Das and Anindo Pal. And my lord, the signature of income is also to be found at the bottom of page 124. Then my lord, kindly take page 125. This is annexure C2 to the my lord this form, application form. But this has to be uploaded online. But this cannot be submitted manually. Details of continuing proprietor partners, incoming proprietor partners for reconstitution of commissioned distributorship, continuing proprietor, continuing partner. My lord, then your lordship will find this is Kashinath Das. Then, my lord, your lordship will find Anindo Pal. Then your lordship will find incoming partner Abhijit Molli. And this form has been signed. Your lordship will find share proposed. Kindly take the share proposed. Again, serial number 8. 0%, 25%, 75%. Since my lord Abhijit Molli belongs to scheduled caste. Now, my lord, kindly take the signatures at the bottom, page 125.
It's all have signed.
All have signed. Then, my lord, kindly take, my lord, page 126. To the territory manager, BPCL, V. Kashinath Das, Anindo Pal, that we have decided to incorporate a new partner in our partnership firm for better appreciation is that one of the existing partner, Kashinath Das, desired to retire from partnership business partner, that is such and such. It's not so legible. Well, it has been signed on 29th May 2022. Your lordship will find a typed copy at page 126, capital A, signed by all the partners. Similarly,
Page 127.
Page 127A, again addressed to my lord this territory manager.
This was not responded to by them, by the BPCL.
This was not responded. My lord, apropos the submissions made on behalf of BPCL, my lord, I think my lord, Mr. Mall has not been correctly instructed. A detailed guidelines exist for the purpose of reconstitution of LPG distributorship. In fact, my lord, this application was made on the basis of guidelines of 2018. Thereafter, new guidelines were framed in supersession of 2018 guidelines, namely 2022 guidelines. And exhaustive provisions are provided for in the said guidelines for reconstitution of a partnership with SC member, where the SC member can also be substituted. I have
by a non-SC member.
Yes.
By a non-SC member.
No, by an SC. Obviously, my lord, by an SC member. My lord, the allotment being made to an SC member, predominantly an SC member partnership.
That composition.
That composition has to be retained, and obviously a new candidate can be brought in, provided he is also an SC candidate. So, my lord, it would not be correct to say, subject to again correction by Mr. Mall, that the guidelines do not provide for reconstitution of LPG distributorship by substituting one SC member with another SC member.
Mr. Mal, which of the pronunciations of your surname do you prefer? His pronunciation or my pronunciation?
Well, either will do. I'm Mal, ML Mal.
So, my lord, I will go by Mr. Mal's pronunciation. So, Mr. Mal's submissions, subject to correction again by Mr. Mal, is contrary to the guidelines framed and circulated by, my lord, the BPCL. All the oil companies. Means that this is common guidelines for all the my lord, oil companies. So, this is one, my lord. And my lord, kindly now take kindly take page
110.
110.
110.
Yes, madam.
Has been signed.
This is, my lord, the deed of agreement come retirement. This was the basis of the application for, my lord, this reconstitution of distributorship. This is, my lord, even in fact, your lordship will find all the pages have been signed by Mr. Das. My lord, your lordship will find, kindly take page 112. My lord, this was 112. Your lordship will find that in fact an amount of rupees 25 lakhs was paid.
That was what I was going to ask.
Initially,
Yes.
thereafter again 25
My lord,
lakhs.
thereafter again 25 lakhs was paid. It was, my lord, in total
50 lakhs we have already paid.
50 lakhs has already been paid and balance.
And there is no balance.
There is no
Now they're asking more 50
In
lakhs.
fact, my lord, now the demand is that you pay another 50 lakhs and we will let you go.
We have even lodged a
But is the other 25 lakh payment?
My lord, your lordship will find.
Give me the page.
Other 25 lakhs payment টা বলো কোথায়? কোথায়?
They have not said in the writ petition they have admitted.
কোথায় বলেছে? কোন রিট পিটিশনে? মানে in their own রিট
Own writ petition, that copy is not.
in their own রিট petition,
We'll go
they
to
have
that later.
they have admitted that they have been paid 50 lakhs in total.
Now their allegation they need another 25 lakhs. It is admitted position.
It is an admitted position, my lord. This is now, my lord, like little bit of arm twisting is going on, that you pay another X amount of money, maybe 25 lakhs or more, and you get the issue settled, and you obviously you induct a new partner who belongs to the.
Have you got a copy of those guidelines? Because that
My lord, I tell your lordship, I have got the 2022 guidelines.
There is a soft copy.
2022 is not applicable. 2018 is
Well,
applicable.
it's more or less identical. Well,
What is applicable? 2018.
Well, I have to be very candid with your lordship. Well, the 2018 guidelines would be the relevant guidelines because the applications were made on the basis of 2018 guidelines. But, my lord, the question arises that during the pendency of the application, 2022 guidelines were already, my lord, introduced and implemented. So, my lord, maybe the application might have to be considered in the light of the present guidelines.
That has not yet been allowed.
Yes.
So the relevant point may be when it is considered for.
Then that means
2022
2022 comes into play. Man, I have got the soft copy of the 2022
Is
guidelines.
2022 better in your favor in some respect?
Well, it provides for.
We have to also see 2018 which goes against it.
It provides for reconstitution of a partnership with SC member by another SC member.
But 2018 does not provide for that.
It must have provided, my lord. But I do not have in possession the 2080 guidelines, to be very candid. I should not be making any submission when I am not in possession of the guidelines. কোথায় আছে দেখাও?
Reconstitution Commission.
My lord, kindly take, my lord, for once. কোথায় আছে? SC টা বল।
Is it very long?
No, it's nominee.
Then you can take out hard copies on the next day. Yes.
My lord, we can.
Anyway, what is the relevant provision of
My
that?
lord, the relevant provision is that
3.1 optional nomination of proprietor partnership. There will be no restriction time of period. Reconstitution Commission dictative up to 3 years.
Yes.
Wherein the shares incoming outside category partners will be restricted 25%.
Years of commissioning, there is no restriction of shareholding of partners in the distribution after 3 years of commissioning, except in case of induction of CST where the share in case of members. Madam, may I just come back with the, madam, I should kindly allow me to take.
No, Mr. Mujumdar, there are now two aspects of consideration in this writ petition apparently, subject to what the others say.
Yes.
One is that since Mr. Mal is of the, he is submitting that the BPCL stand is that if you have a reconstitution, then they may not permit that, they won't permit that.
Then, my lord, this arrangement continues. Then this arrangement continues with 75 being held by
Mr. Chatterjee's
Ms.
client
Chatterjee's client and with the petitioner.
But the moment your reconstitution application, if that is the other lane. If your reconstitution prayer is allowed, Mr. Mujumdar, then it is reconstituted and you are at risk. So you have to argue on both counts.
Yes.
One is that reconstitution, he cannot resile from that position after taking money and executing those documents, signing those documents. One. Secondly, if that reconstitution goes through, then Mr. Mal's client cannot resile from the guidelines, which compel them to at least consider your application for reconstitution.
Right.
So
my lord, two ways, my lord, may I just humbly submit with your lordship, subject to your lordship's kind consideration. My lord, if your lordship so directs.
You cannot pray for both. Either if you can waive your right of reconstitution of the partnership,
yes,
then no question of Mr. Mal's taking up
then,
this
my lord,
point
this
at all.
petition becomes infructuous.
Yes.
But my lord,
you can proceed with that reconstitution argument of yours.
yes.
If that is dismissed, then whatever is already
Whatever
there,
is
that
the
will remain. Then the other question does not
my lord,
come in.
my lord, then my lord, then if I take the second route, then my lord, I have nothing to lose at this stage. Maybe the reconstitution will not work out for me.
Reconstitution does not work out, but everything remains in status quo.
Status
Your
quo,
your
I
renewal
lose 50
remains.
lakhs.
He remains. You
I
remain.
lose 50 lakhs.
Your agreement remains.
And Lordship, my participation in the business should be ensured.
Yes, that is another aspect
That
of
is
the matter,
another aspect.
which I'll do in your writ petition.
My lord, that is there.
That is
But it's a
pending.
very interesting writ petition. My lord, a complaint is lodged with the police officer requesting
That is pending, Mr. Justice Sengupta.
Yes, my lord. And my lord, the prayer in the
So you can cite this order then.
my lord, the prayer made in
He does not proceed with.
prayer made in the said writ petition is like this. He is requesting the officer in charge of the jurisdictional police station that kindly resolve this matter between us.
No,
That-
resolve,
yes. That is the
because
exact
if I
term.
am not
That
allowed
is the
to
exact
hear,
term used in the
then
FI.
I have to seek the assistance from the police.
My lord, may I just,
They will come when on stamp paper a
Madam,
petition
may I
will be
just
filed before
submit
the police
humbly-
officer to adjudicate.
my lord, may I just humbly, I would request Mr. Mal, I'm so sorry.
You are
I'm-
anglicized, Mr.
My lord, I had, in my absolutely fresher days, we had one client named Dr. Shubir Ball, right?
Very well. Let us not proceed with that inquiry.
I tell you, Lordship,
Let us focus on
he
this matter.
contested the Bidhannagar Municipal Corporation. My lord, we challenged the election to the Bidhannagar Municipal Corporation by a PIL.
It is risky either way.
It's risky either ways. So I don't want to get into that zone.
Neither do I. At least sitting in court.
Yes. So, my lord, what I humbly submit, kindly keep it on 29. May I have a copy of the 2018 guidelines? We come back to your lordship with both the guidelines and the issue can be decided this way or that way. Or, my lord, in the alternative, my lord,
You also take instruction, Mr. Mujumdar, what you want to do.
I have
press your reconstitution.
But if I press suppose I fail in my reconstitution, in this writ petition.
No, the risk will not be that. If you fail in your reconstitution, whatever remains.
Remains.
But if you win your reconstitution, then the difficulty arises from it. Then the next limb of your arguments come in.
Yes, if I succeed in
the win, and the BPCL says that we won't allow this, then you will have to argue on that.
If I succeed, I will succeed with this condition that the BPCL has to allow has to
You will
induct
have to argue on both.
Yeah, both. So, my lord, I would beseech your lordship, kindly keep it on 29. My lord, kindly in the meantime direct BPCL to serve us a copy of the agreement and 2018 guidelines so that we can assist your lordship.
Yes, that can be done, Mr.
My lord, subject to hearing for a couple of minutes. My lord, first of all, whether he can at all praise the reconstitution plea now, having signed the renewal agreement only on 12th, which is for some period of time. My lord, does he, my lord, honor the renewal agreement or he wants to press? My lord, to demonstrate that, first you'll have to show that that application was really filed. And at best, my lord, what he can ask is for consideration of that reconstitution application by the authority.
Yes.
My lord, nothing more beyond that.
Even that he won't get if Mr. Chatterjee succeeds in convincing me that he can resile now.
That is also
That is the best order he can get.
Yes.
Yes, because that
the constitution cannot be allowed by this court definitely. At best, he can get a direction that has to be considered.
But now it is extended for 5 years, if I am not wrong. My lord, only on 12th of this month, and he has signed it, and Mr. Majumdar's client has also signed it. My lord, whether he gives a go by to that, my lord, unless he gives a go by to that, he cannot press, my lord, the prayer for reconstitution.
This is also a valid constitution to take instruction on that also, because you have signed the renewal agreement.
I have signed the renewal agreement
as it is.
As it is. But on that day,
on
that day when I signed the agreement, I also submitted in writing that my reconstitution application is pending on 12 January.
It may be pending, Mr. Majumdar.
But kindly take, my lord, this renewal is effected in terms of the clause provided for in the existing contract. That is already there. So, my lord, this is an extension of the existing contract.
You argue on all these aspects.
All these aspects. Can we come back on 29th or 30th?
Submission also I want to make under instruction, Lordship, that the 50 lakhs which has been shown that.
No, Mr. Chatterjee, I'll hear you on that.
No
I'm not hearing on
no payment made.
The petitioner, a twofold argument has been made by the petitioner in this case, First, the writ petitioner contends that a joint application for reconstitution of the partnership firm constituted between the petitioner and the private respondent number, you are
Five.
and the private respondent number 5, comma, the latter being a scheduled caste person, comma, is not being processed by the respondent authorities. Full stop. It is submitted that the partnership firm comprised of the petitioner and respondent number 5 was granted the license, that the distributorship, granted a distributorship by the BPCL, that is the Bharat Petroleum Company Limited. Full stop. Next para, Corporation Limited. Full stop. Next para. However, comma, subsequently a renewal of the said distributorship was sought for, and in the meantime has been granted by the BPCL. Full stop. While signing the said renewal agreement, comma, it is contended that the petitioner also made it clear in writing that the present writ petition is pending for pressing for reconstitution, pressing for the reconstitution application of the petitioner to be decided. Push up next para. The private respondent number 5 contends that the said respondent does not want to press the joint application for reconstitution, and the private respondent number 5 wants to remain as a partner of the partnership firm in question. Pushab Learned Counsel for the BPCL submits that although a renewal has been granted for a particular period, comma, the said renewal was signed by both the partners, and in the event the petitioner resigns from the position that the partnership firm which was granted the renewal will remain as it is, comma, it will be open to the BPCL to cancel the distributorship and to float tender for inviting a new distributorship. Push up next para.
Advertisement will make it, not tender.
By due process of law. Push up next para. Thus, comma, a peculiar predicament has arisen, full stop, in the event the petitioner succeeds in its prayer seeking a reconstitution of the partnership firm, comma, the petitioner might be at risk of the BPCL insisting upon cancellation of the agreement, full stop. However, comma, in the event the petitioner loses on such count of reconstitution, comma, the position remains as it is and the writ petition otherwise becomes infructuous. So be that as it may, comma, since learned senior counsel for the petitioner seeks to rely on certain guidelines of the BPCL of the year 2018 and seeks some adjournment on such count, comma, let the matter be placed under the same heading in the list on January 29, 2024 for further hearing.
A copy of the
For passing
guidelines.
further orders. Learned counsel for the BPCL shall hand over a copy of the renewal agreement to his counterpart appearing for the petitioner as well as the private respondent number 5 in the meantime.
And the guidelines, guideline is not available in the public domain. 2022 guidelines are
We
available.
have signed it in due process.
No, the guidelines are public
No,
document.
copy please hand over.
Copy of the agreement.
And the
Renewal
guidelines.
agreement.
And the guidelines.
Guideline may not be also available with the ballot.
But 20,
Renewal agreement, please hand over copies. Renewal agreement, please hand over copies to him and him.
the 2018 guidelines are not available in the public domain. I cannot get access to those guidelines. I have got access to 2022 guidelines.
Mr. Mal, please give them access to 2018 guidelines. Let us be fair, at least.
We also have 2022. I'll try to find out, my lord. I'll try to give it, but it's normally available in the site.
No, it's not available. Subject
Lordship,
to
in the meantime, Lordship, I am seeking,
18.
Lordship, since your Lordship has decided to hear it out, Lordship, kindly ensure my presence in the business, Lordship. By this time, in the meantime, the status quo will remain in respect of the
status quo remains.
Lordship, kindly pass an order.
Status quo remains.
Kindly pass an order in this regard.
Status quo.
Lordship, otherwise, Lordship, they will not allow us to enter. That's
This
they
is not
have.
your writ petition, Mr. Chatterjee. There is no question of passing in status code. Call on the next one.
Yes.
So the date 29th of
26.
February, Lordship.
Yes, what?
26 who is appearing?
My lord, I am for the applicant. in this.
We are not sure even whether there is a guideline of 2018. We'll have to find out. He
So,
just
my lord,
said,
the application, I will just for my lord assisting Mr. Mal,
my lord,
the
we'll check.
application was made in terms of guidelines of 2018, and that would be apparent from the application
My
itself.
lord, we'll check and find out.
I take
Service, affidavit service.
my lord, affidavit of service. My lord.
Good service.
My lord, effected. Service has been effected.
Right.
The my lord, petitioner case is this. My lord, the petitioner, my lord, running a tea shop, my lord, with due proper license from the corporation as well as the my lord, food authority. Yeah, my lord, the Kolkata Port Trust, my lord, gave the my lord workspace, my lord, for occupational. My lord, I have given the my lord occupational charges from 2018 to 2023. And all on a sudden, my lord, the authority of the Kolkata Port Trust, my lord, issued a notice, served a notice saying that I should vacate the workspace within 3 days. Well, without giving any opportunity of hearing or something else. Already, the clear violation of the natural justice. Well, this notice is at page 22. They are saying the no further extension has been given by the
No,
authority.
this is a legal notice. If you don't vacate the space, they'll initiate proceeding under 1971 Act. I'll make that clear.
Malad,
Of course, we are going to do that only.
Legal notice, legal action would follow.
Yes.
Malad,
I'll record that.
Malad, 2018 since 20, I am saying, Malad, livelihood has been
Decided in a proceeding if initiated by them. Without due process of law, they cannot evict.
Malad, till the due process of law concluded, Malad, let my business be running. That may be protection will be given.
How it will be?
Malad,
Yes,
they
why
are
not?
That
Till you get an eviction by due process of law, tea stall.
Statutory authority, we have to follow that, but that has not.
If statutory authorities
Understood.
followed the law to the
authority
letter,
has
Mr.
been
Nag,
informed.
we would be businessless. We wouldn't have any business if statutory authorities followed the law to the letter.
Yes,
So don't say that.
well, the license was for 3 months. It is not going to be extended. If he vacates, well, or will initiate proceedings under.
Malad, I am ready and willing to
So
pay the
that
Malad,
is
draft
obvious,
has been
Malad.
ready. That was also Malad,
I'll say that you cannot evict him without due process of law.
No, that is inbuilt.
Only that much. Learned counsel for the petitioner contends that the respondent authorities have illegally sought to oust the petitioner from the occupation of a tea stall being run by the petitioner as a licensee on wharf, WHARF, wharf space allotted by the Kolkata Port Trust itself to the petitioner, whose of the petitioner has been paying occupation charges from 2018 to 2023. Push up next para. Learned counsel appearing for the respondent authorities points out that the impugned notice is a precursor of legal action to be initiated by the respondent authorities. Footstep next para. A bare perusal of the impugned notice annexed at page 22 of the writ petition shows that the same is indeed a precursor of legal action to be initiated against the petitioner by the respondent authorities. Footstep as such, comma, the petitioner as such, comma, the same cannot be interdicted by issuance of a writ by this court at this juncture. Footstep. The respondent authorities shall be at liberty to initiate appropriate proceedings. Footstep. However, appropriate proceedings pursuant to the said notice. Footstep. However, comma, it is made clear that the respondents shall not evict the petitioner or disturb the peaceful possession of the petitioner with regard to the tea stall in question without due process of law. WPA 503 of 2024 is disposed of in the light of the above observations without any orders to cost.
Malad, I am ready and willing to Malad, pay the occupational charges. That is annexure P5. Malad, if
Pay
they are
Mr.
not
Nag and
accepting,
Mr. Banerjee separately.
Malad, they are not accepting the Malad.
Pay them separately, they'll accept.
Fine. Grateful to us.
Next.
27.
Yes. Respondent or petitioner? Petitioner. Yes. Come this side. Who is for the respondent?
I'm for the state, Lord. With Mr.
My lord, respondent number
Bosumali.
Yes.
my
Yes.
lord, respondent number 7 has floated a tender
Right.
on October, in the month of October. Lord, petitioner, being interested person concerned, had participated in the said tender. The serial number 9 works for that, serial number 1 to 9. And it participated in all the works. Surprisingly, the first one was allowed, and all the remaining serial numbers in respect of 2 to 9,
Serial numbers means there are separate works.
separate works.
Very good. One was allowed.
One was allowed.
Yes.
And with regard to 2 to 9, the application of the petitioner was rejected. But on the ground that same credentials has been submitted by the petitioner. Lord, kindly look into this.
Same credentials cannot be submitted.
That is the reason. That's what I've stated in page 15, Annex P2. This is the first one with regard to serial number 1. My first Mahakali enterprise. My application was accepted. But kindly turn to the next page. Next page, Your Lordship.
Yes.
Next page, serial number 3, rejected. Status is rejected technical. A remark is, Your Lordship, due to same credential as on serial number 1. And it continues.
Same ground.
Same document.
So let us see the eligibility criteria or credential. What is the relevant criterion?
Criteria, my lord, criteria, Your Lordship, at
Regarding
page 14. At page 14.
Page 14.
Yes, Your Lordship.
That is relating to the credential.
Yes, Your Lordship.
Let us-
C,
Yes.
A, B, C, D.
What is the worst?
The credential.
What is the worst clause against you, which can prevent you?
Nothing.
Is there anything to show that
Nothing.
you cannot produce this?
Nothing. Credential 1, same type of works, work orders, payment certificates, and completion certificates which are applicable for
Which clause?
C, Your Lordship. At page 14.
Page 4. Oh, I'm sorry. I was looking at 13A.
14.
14C, right?
14C is a credential.
Credential 1 is applicable to you.
Yes, Your Lordship.
Same type of work order. Very good.
I submitted in all the applications.
So this is the grievance.
Yes.
Let me hear that.
Subsequently, Your Lordship, thereafter, they rejected my application. I made a representation before the Pradhan on the next, at page 14, 24, 25, and 26.
Not considered.
It was kept pending, didn't consider. Subsequently, Your Lordship, the Pradhan has floated a subsequent tender in respect of all the works that was rejected, except they have added only one. Only one. And it would be evident, my lord, from the first annexures, Your Lordship.
What is that page?
At page 28. If Your Lordship relate it with page 12 and page 28.
Only one is extra.
The side details will be evident, the same.
What is the extra? Which one is this?
The last one.
10.
My lord, what you have stated before Lordship, that at least you should allow me to do it. Consider my application, and my application has been wrongly rejected.
What is the stage of the new tender?
New tender, Your Lordship, 19th, Your Lordship, their last date of tender is 19.
So it's still in process.
Yes, it's still in process.
So Mr. Bosumali must have a good explanation for that.
No, only yesterday I received this brief.
Oh, what?
And no, my lord, the problem is, my lord, the Pradhan.
That is not a ground.
No, my lord, the Pradhan is there, my lord. Whether the Pradhan has at all been served or not, that I don't know. Oh, he's appearing.
So one of the grounds go.
No,
First you received yesterday, that goes. I negate that.
No, but
Pradhan not served, Pradhan is here.
Pradhan is at
Any other ground, Mr. Bosumali,
No,
to
no,
defend?
দাও কি আমি কি বলবো বল কি আছে
Yes, Pradhan, what do you have to say?
Has been adopted, my lord, whereas my lord video has specifically stated that my lord new tender should be initiated as because my lord already 2 persons already be.
You have to show me only from this your tender document that there was a clause preventing the same credentials from being produced for all the works. Show me that from your tender document. Subsequently, what your video says, what the Secretary of the State says, what the Chief Minister says, I am not interested.
Just kindly see for a moment as per rule of the tender proceeding is paragraph 2, my lord.
Give a copy to them also. Whatever you produce, give a copy to the petitioner.
আরে জানে ফানে বললে হবে, আমাকে দেখাও তো।
Notice inviting e-tender. This was a different notice, tender notice.
This is the actual government rule, man. Not this is a tender notice. Tender procedure rule.
The caption is notice inviting e-tender.
Yes, Maria. So kindly see the first page of this.
No, what are you saying? The first page says notice inviting e-tender, encrypted electronic bids are hereby invited by the executive engineer, Mograhat Drainage Division, irrigation such and such, through a single stage two-part for execution of works of similar nature and desired financial capacities.
Middle paragraph, and I have stated what here specific.
Have you got a copy of this? Read the first paragraph.
But you say kindly say 8 participation.
Read the first page, sir. Date 11/4/2023. This is another tender altogether. This is not any guideline. What are you saying?
রিজেকশনের কারণ কি?
This procedure is followed in all respect, so that one.
I am only interested in the present tender document. That is only what counts. Only the clauses of the present tender document are required to be looked into, nothing else. And if something else is to be looked into, that has to be indicated in the present tender document, that those are also applicable. If not, then no, I cannot look into that. You cannot discover subsequently new guidelines. And this is another tender altogether. This is not a guideline.
Page 13, one point has been initiated.
Which one? Tell me.
Paragraph 8, says page number 13, paragraph 8, the acceptance of the tender will rest with the Pradhan, Raidiki Kampanchayat, who does not bind himself to accept the lowest tender and reserve to himself the authority to reject any or all of the tenders without assigning any reason. He further reserves the right to distribute the work among the more than one contractor.
This is the best clause you can find out.
And so that after that one meeting has been and one resolution was adopted, and on the basis of that you have to kindly seek for amendment. On that basis, new tender has been initiated, and there is a time.
I'll scrap that new tender. I'll cancel that new tender immediately.
We have to participate in the new tender.
He won't participate in anything. He will succeed in this tender.
Otherwise, other two persons,
maybe.
Person has to be participated and added, my lord.
Who are to be added?
Two persons, other in 2, 3, and 4, my lord. SB Enterprise has been selected, my lord. And in respect of 8, my lord, Susila Enterprise has been selected. And so that should be great.
In the present tender, others have been selected.
Previous tender, my lord.
In the previous tender, the one which has been challenged, there are 9 items in total.
Yes.
Out of 9, he was chosen in only 1. Regarding the other 9, you have floated new tender.
No, my lord. 2, 3, and 4 already. They have we have chosen SB Enterprise. I have chosen, my lord.
They are not parties here.
No, my lord. They have not made party.
They're not parties.
So
because
there is sufficient time, my lord. He has to apply in within 19th, and I shall try my level best to participate all of the proceeding. And one resolution has been adopted, man, on that basis, so that this new tender has been initiated as per instruction of the BDO.
Keep your resolution with you.
As per instruction of the BDO. BDO has been instructed me, my lord.
No, but the new notice inviting tender is on the same work.
Same.
For the same work.
2 to 9 on the same.
Exactly same work.
Yes.
On the basis of the resolution and on the basis of instruction of the BDO, this tender has.
If you don't want me to tear off that resolution and throw it out of the courtroom, don't rely on that again. Your BDO resolution, keep it with you. BDO does not have any business in the matter. He cannot change the tender terms. What BDO resolution? Who is the BDO? Who the hell is he? The BDO is initiating a resolution that will bind the court. Throw it out of the court. BDO instruction. If possible, throw out the BDO also. You are repeating on and on and on and on and on. BDO instruction. Who is the BDO to instruct you? Who is the BDO here? Pradhan has floated a tender. Tender document does not contain any clause in that regard. And the Pradhan reserves to himself the right to do whatever he likes. The Pradhan will remain personally present in court on the next date and explain his conduct. And I'll direct him to go to jail if he cannot explain his conduct. He's a state functionary. Is he only there to earn money? This is a public project. Who is the BDO to resolve something beyond the tender terms? You don't understand the ABC? Tender document contains certain clauses. BDO is putting in a resolution on record, handwritten resolution subsequently to change the tender terms. Unheard of. Unheard of. Show me from the tender document where is this clause that his credentials have to be pertaining to the same previous work. Cannot pertain to the same previous work. Show me from the tender document one clause. Then but you will have to implicate the other persons. They will be affected. The petitioner has raised a strong prima facie case for hearing the writ petition on merits. Full stop. Although the tender in question, the notice inviting tender in question did not contain any clause indicating that the bidders had to provide separate credentials for each of the works contemplated therein, comma. The petitioner's bid has been rejected on the technical count that all the documents pertain to the same credential as serial number 1, comma, for which work the petitioner was successful. Full stop. Out of the 9 total contemplated works in the tender, comma, the tender clauses indicated that the bidders have to have the same credential which were complied with by the petitioner, comma, for which the petitioner was chosen as the successful tenderer with regard to serial number 1 work. Full stop. As such, comma, in the absence of any such specific condition in the tender document, comma, the rejection of the petitioner's bid on the ground that the documents pertaining to credentials were the same as for serial number 1 is prima facie illegal, comma, arbitrary, comma, discriminative, and contrary to the terms of the tender itself. Push up. Next para. Learned counsel for the Pradhan repeatedly tries to lay stress on some unseen regulation, on some unseen resolution taken apparently by a block development officer. Push up. This court fails to understand as to how a subsequent resolution by a BDO, comma, having no business to change the terms of the tender document post facto, comma, can have any bearing on the consideration before this court. Full stop. Next para. However, comma, learned counsel for the Pradhan is justified in arguing that the other bidders in the impugned tender, comma, who were successful on the other works are required to be impleaded as parties to the writ petition. Full stop. Next para. Accordingly, the petitioner shall implead the other successful participants in the impugned tender as party respondents. Full stop. Necessary consequential corrections to that effect shall be carried out by tomorrow to the cause title of the writ petition by the learned advocate on record for the petitioner. Full stop. Copies of the writ petition shall be served on the added respondents, indicating that the matter shall next be listed on February 6, 2024 under the heading Upgraded Matters, and an affidavit of service to that effect shall be filed on such date by the petitioner. Full stop. Next para. The subsequent tender dated January 5, 2024 floated with regard to the remaining works subsequently, comma, annexed at page 28 of the writ petition, comma, shall remain stayed till disposal of the writ petition. Full stop. Next para. The respondent Pradhan shall not in the meantime allot any work to the successful tenders with regard to the present impugned tender also till disposal of the writ petition. Full stop. Affidavits in opposition, if any, shall be filed by the respondents within a fortnight from date. Full stop. Reply, if any, shall be filed on the next returnable date. এটা ফেরত দিতে হবে। Please annex this to your opposition.
Lordship. Get.
Thank you.
Obliged, Lordship.
Yes, call on the next one.
28.
28, I am appealing for the respondent number 9
Respondent.
and 10.
Madam, 28 for the petitioner led by Mr. Pratik Kumar Chatterjee.
Writ petition is now infectious because the order impugned dated
been
5th
complied.
January already cancelled by the subdivisional officer at the court.
You agree?
Can you see the order?
Learned counsel for the respondent numbers 9 and 10 as well as the petitioner submit that the writ petition has become infructuous, comma, in view of the impugned action having been called off by an order dated by a communication dated January 9, 2024. Full stop, a copy of the same is handed over in court today. Full stop, accordingly, WPA 881 of 2024 is dismissed as infructuous without any orders to court.
Affidavit in
Affidavit size file today be kept on.
Obliged. Good.
Next.
New motion. Item 29.
I am for the petitioner, my lord.
Yes.
My lord, petitioner was a contractor, my lord.
All have been served. Where is the affidavit?
My lord, this is only the state, my lord.
But the affidavit of service
Yes,
has-
my lord. I have. my lord.
Yes. What is the matter?
My lord, the petitioner is a contractor, my lord. Petitioner was debarred for 6 months without any show cause, my lord. That has been challenged before this court, my lord. My lord, by that time the matter was taken up, that 6 months has been elapsed, my lord. So, my lord, this court has, my lord, observed that, my lord, already 6 months elapsed. So, my lord, there is no debarment, but, my lord, give liberty to me, my lord, to challenge the, my lord, the show cause notice as, my lord, there is a stigmatic. My lord, kindly take the, my lord, the High Court's order at page 49, my lord.
Then that writ petition would have survived.
Yes.
My lord, kindly take page 49, my lord. Page 49 of, my lord, Lordship's order, my lord.
Yes. What did you challenge there? The debarment was challenged.
My lord, debarment, I was challenged the debarment. By that time, my lord, the time has been elapsed.
Yes.
Elapsed, my lord.
Right.
Then, my lord, the court observed that, my lord, by that time, my lord, the debarment has been, my lord, already been, my lord, elapsed, my lord.
So
my
challenge
lord,
became infructuous.
challenge became infractions, but, my lord, the stigma that, my lord, appended to me, my lord, because,
That
my
will
lord,
be decided in that writ petition then.
yes, my lord, my lord, that has been, my lord, challenged this writ, in this writ petition, in this writ petition, my lord. Kindly take page 50. My lord, 49, my lord, the order starts, my lord. Kindly take page 50, my lord. My lord, may I read for your lordship the relevant paragraph, my lord?
The 6 May was challenged there. Anyway.
Yes, my lord. But, my lord, today, my lord, I am before your lordship, my lord, because, my lord, liberty was given. For that point, my lord, that is stigmatic, my lord. A stigma is also, my lord, with me, my lord, unless until it is, my lord, declared illegal. My lord, in the next tenders, my lord, and the years come together, my lord, I have to
I'll
declare
also give you liberty to challenge the stigma again if subsequently you are debarred in another matter on the ground.
That is not in my hand, my lord. Your lordship knows, my lord.
This is also not in your hand.
But, my lord,
6 May was challenged specifically. Why was it not decided?
I don't know. And, my lord, the fact.
What is your challenge? Without show cause, that is the
Without
challenge.
show cause.
But that has become infructuous as per the coordinate bench's order.
My lord,
and you are challenging the notification which withdraw that.
Withdraw, my lord, subsequently, and that has also will not been, my lord, communicated to me. Before the court, it has been, my lord, declared, my lord, that my lord has been withdrawn.
Yes, but you also sought for liberty to challenge that withdrawal.
My lord, and, my lord,
I'll allow
was-
that challenge them.
And, my lord, I today, my lord, I seek for the, my lord, that, my lord, that debarment. What is, my lord, on the, my lord, previous debarment is illegal, my lord, because of that is without show cause. My lord,
You
without any
want to
reason.
remove the stigma from that.
Stigma from me. And, my lord, that remains, my lord, for that, my lord, 2 count. 2 effects will be there, my lord. One is, my lord, I can, my lord, seek damages. That liberty I will seek, my lord. I can seek damages, my lord. And, my lord, for the, my lord, the future, my lord, I cannot be held, my lord, I am, my lord, debarred from someone, my lord, that was not been, my lord, held illegal. That was, my lord, withdrawn after 6 months. But, and, my lord, those debarments is, my lord, unreasoned on the apparent of the face of it, my lord.
What is the debarment?
My lord, kindly take, my lord, the debarment, my lord. Kindly take, my lord, page 31.
Yes.
That is the, my lord, their instruction, my lord, before the, my lord, the court. Relevant page is, my lord,
The relevant
Ms.
page is, my
Bhattacharya,
lord,
please take your seat, both of you. Yes. Which
relevant,
page?
relevant page is, my lord, page 34.
34, yes.
For quite some time, it is observed that the number of agencies failed to execute the roadworks entrusted to them through competitive bidding process. After careful consideration of the issue, it is decided that the blacklist these agencies, contractors for participation in any bid tender under West Bengal State Rural Development Agency and Panchayat and Rural Development Department, Government of West Bengal, as detailed in the table. This is the approval of competent authority.
Oh,
I
this
don't
was
know.
the only order of blacklisting.
Absolutely. And my lord, my name is, my lord, at NT 54, my lord. That is at page 38. That is only, my lord, and before that, my lord, no show cause, nothing, no hearing, no show cause,
Bhattacharya, how do
nothing.
you support this?
My lord, if your lordship kindly comes to page 33.
33.
This is the letter sent to the writ petitioner
Yes.
where his conduct has been, where his what has actually brought to the 6th May letter, that is explained in page number 33. If your
But
lordship,
that is a unilateral explanation, and you have not given a show cause to him, giving him opportunity to explain himself. That show cause, and the show cause also has to mention the implication. What
that
will
has not been given. No.
that has not been given. So I'll set aside the stigma. This was a bad blacklisting.
But
Only vis-a-vis him.
only one submission, manner. This is the order of 18th April at page 49. The order starts. The petitioner has challenged an order dated 6th May. The same notification has already been also been challenged in this writ petition.
But that liberty was given.
But subsequently, the liberty in the same order, it is recorded that order has been challenged.
Yes.
And the last paragraph, again, the liberty to challenge the same order has been
Yes,
given.
but you have not sought for a recall of this order.
No, I was.
So this order remains.
I was not there.
The circumstances of the present challenge are a bit peculiar. First up, the petitioner had challenged an order blacklisting the petitioner and other contractors by the respondent authorities with a order dated May 6, 2022. First up, during pendency of the said writ petition challenging the blacklisting, it came about that the state, by a notification dated April 5, 2023, had withdrawn the order of debarment with effect from November 6, 2022. Pushed up. In such context, the writ petition was disposed of by a coordinate bench, granting the petitioner to challenge the notification dated April 5, 2023, insofar as it reiterated that the petitioner had been blacklisted before withdrawing the said blacklisting, and also the debarment order dated May 6, 2022, if the petitioner was so advised. First up, it is argued that the stigma remains with the petitioner in view of the debarment, although the challenge previously made was infructuous. First up, without any prior show cause notice, the blacklisting impugned herein is prayed to be set aside. First up, next para, learned counsel for the respondent authorities places reliance on the communication dated March 16, 2021, where the executive engineer WBSRDA, Purvo Medinipur division had categorically given the specific reasons why the petitioner and other contractors were debarred. It is thus submitted that the debarment was reasoned. Next para, moreover, it is pointed out that in the previous writ petition, the same order of debarment stroke backlisting had been challenged, and as such, the present writ petition is not maintainable on such count. Next para, a careful perusal of the order of the coordinate bench dated April 18, 2023, passed in WPA 13113 of 2022 indicates that although the blacklisting order dated May 6, 2022 was challenged therein, the learned single judge observed, in the context of a subsequent withdrawal of the same, that the said writ petition had become infructuous. More importantly, leave was granted to the petitioner to challenge the blacklisting order dated May 6, 2022 afresh, along with the notification dated April 5, 2023, which withdrew the debarment, inter alia reiterating that the petitioner had been blacklisted in the first place. Next para. The leave granted by the coordinate bench can be interpreted in the following manner, next para. Since technically the challenge to the blacklisting had become infructuous in view of its withdrawal, comma, the leave was granted by the coordinate bench, full stop. Insofar as the notification dated April 5, 2023 was concerned, comma, although the same had the effect of withdrawing the blacklisting against the petitioner, and superficially the petitioner did not have any cause of action to challenge such withdrawal, since it inured to the benefit of the petitioner, comma, implicitly, comma, the withdrawal of the blacklisting reiterated that there had been a blacklisting in the first place, comma, which was being withdrawn by the said notification. Full stop. Citation of the blacklisting as the cause of action for the withdrawal itself cast a stigma on the petitioner. Full stop. Moreover, comma, the initial blacklisting dated May 6, 2022 remained against the petitioner, comma, casting a shadow on future work which may or may not be awarded to the petitioner, insofar as several tenders contain clauses where the bidder has to give a declaration that there was no previous blacklisting, comma, where the petitioner would suffer a stigma and professional loss. Pushed up next para. In such wider context, comma, the present challenge is entertained. Pushed up next para. The reliance of the respondent authorities on the communication dated March 16, 2021 is misplaced insofar as the same merely gave general reasons for the blacklisting but could not substitute a proper show cause notice. Pushed up next para. It is well settled and has now become cliche that any order of debarment or blacklisting having a severe penal impact on the accused person has to be preceded mandatorily by a proper show cause notice, where not only is the specific offense allegedly committed by the accused to be disclosed, but also the specific sanction or measure to be taken against the accused in the event proper cause was not shown also has to be specifically enumerated. Full stop. There being no such show cause notice at all, comma, the impugned blacklisting of the petitioner dated May 6, 2022, annexed at page 34 of the writ petition, was palpably bad and dehors the principles of natural justice. Full stop. Hence, comma, WPA 28929 of 2023 is allowed on contest, thereby setting aside the blacklisting of the petitioner vide the order dated May 6, 2022, only insofar as the present petitioner is concerned. Full stop. Insofar as the present petitioner is concerned, comma, the said order is thus set aside. Full stop. It is also made clear that the notification dated April 5, 2023, where the said blacklisting was withdrawn, shall stand rectified to the limited extent insofar as the same refers to the petitioner having been blacklisted in the first place. Full stop. In view of the blacklisting of the petitioner itself having been set aside by this order, comma, the withdrawal of such debarment stroke blacklisting thus becomes redundant. Full stop. It is made clear that any stigma, comma, if if attached to the petitioner's activities, professional activities till date by virtue of the impugned blacklisting, comma, hereby stands uh, obliterated. Full stop. The petitioner shall be able to participate in future tenders floated by any authority on the premise that the petitioner was never blacklisted by the impugned order dated May 6, 2022. Full stop. No orders to cause urgency. Refresh. Next. Oh, audience. যেভাবে আছে সেভাবেই এক্সটেনশনটাই আগে ডাক Ye-
Original side listed matters, extension of interim
Want
order,
to take it
item
on?
number 1.
Item number 1, my lord, I am for the respondents 1 and 2.
My lord, I am for the petitioner, my lord.
When is the interim order expiring?
Yesterday, it expired yesterday, my lord.
I'll extend the interim order. The interim order granted earlier is extended till February 29, 2024 or until further order, whichever is earlier. The matter shall be listed on January 29, 2024 for hearing. I think
For hearing, item number 2.
there are too many tops, so I'll go serially. Yes, Mr. Bhattacharya.
No, my lord, this matter.
2, 3, and 4 are different.
Yes, 2, 3 are same.
2 and 3 are same.
My
Yes.
lord, I'm praying for a short passover.
Provided you don't nod your head. Provided you don't nod your head. Yes.
I'm praying for a short passover. I'm led by Mr. Krishnaraj Thakkar.
Mr.
Krishnaraj Thakkar.
Use the mic.
Mr. Thakkar is appearing.
Yes, what do you say?
Well, my only difficulty which prompted me to mention the matter yesterday is the life of the special officer, administrator. My lord, is expiring tomorrow. Now, the act,
So why expiring tomorrow? It was given
because
for.
my lord, it was given for 3 months.
I'll extend that. I'll extend that.
Kindly extend it.
Now, my lord, I'm praying for a. It is you produce my petitioner's right, my lord.
For a few days.
My lord, kindly keep it at about 4:15 or kindly tomorrow at my lord 3 p.m. my lord.
No.
Just
Just
short password, my lord.
No.
Short password, my lord.
An adjournment is sought on the ground of learned counsel for respondent number 3, full stop. It is pointed out by learned counsel for the petitioners that the learned special officer was appointed for a limited period.
Learned administrator.
Administrator, my lord, I am representing the administrator.
Very well. I'll extend your time for a week.
My lord,
Learned administrator had been appointed for a limited period which expires tomorrow. Full stop. In the event the tenure of the administrator is over before the matter is heard out, comma, it may create unnecessary complications. Full stop. Accordingly, the tenure of the administrator is extended on an ad hoc basis till January. I'll extend it to January 31, 2024, or until further order, whichever is earlier. Full stop. The matter be placed under the same heading for hearing tomorrow. Come back tomorrow, it will appear as a top matter, argue the matter.
Adjournment has been sought for on their behalf.
Yes, this is on an ad hoc basis. I'll hear it.
No, adjournment has been sought for on their behalf.
my lord,
Respondent 3, I stated that.
kindly,
He is the petitioner in the second matter, and in the first matter, I am the petitioner.
my lord, in the first matter,
Next matter.
Wait, item number 4, the affidavit will be taken on record
Tomorrow. Respondent number 3 in.
I'm sorry, my lordship takes it up, my lord. I'm sorry.
Pass my order. Ad hoc
My lordship
basis.
is not signed.
Tenure is extended till 31st January. I'll take it up top tomorrow.
Tomorrow, I'm sorry. Great.
যদি আমি আটকে যাই
No, even if nobody else is there, I'll take up the matter. The people who oppose today, even if they are not present, if you are present, I'll take up.
I have not opposed. I have not these. I have never opposed.
তুমি কেন টাইম
Yes, Mr. Bharat.
No, 4.
4.
This Mr. Mitro had mentioned yesterday,
Why?
indicating that he would not be here. Your Lordship's desire was that somebody should come and indicate that. And so I have
keep it.
But any day, if it could just be appearing as the fixed at 3 p.m.
No longer 3 p.m. No longer.
Well, that is my only brief. I have no other reason for engagement. Really.
My lord, in this matter, we have already filed our brief notes of argument. They were to file their final notes of argument.
For that only?
Yeah.
No,
There-
we have to argue. We argued, they have given, they have
Argument is
argued.
probably concluded
No,
on their
arguments are
part.
not.
Keep it, give me a day.
Any day, my lord, any day,
Not
Lordship
any
keeps
day.
it.
Any day I fix it and then you come back. And
Lordship keeps it tomorrow.
you are brief to take time.
Lordship keeps it tomorrow. If Mr. Mitra doesn't do it, I'll address you.
Tomorrow I already fixed another matter, the other.
Day after, my lord. Friday or on Monday, whenever.
Not Friday, I'll keep it on Monday. Then.
My lord, subject to correction, in your lordship order, your lordship had recorded that argument has been concluded on the part of the petitioners.
No.
Yes. In order to file the petition's written notes of and to conclude oral reply.
Correct. I have to give
reply.
a reply. I have to give a reply.
On the prayer of the petitioner, the matter is adjourned till January 22, 2024, when it will be placed for hearing at 3 p.m.
I'm very grateful.
Grateful. 3 p.m. আর কি 3 p.m. নেই তো এবার টপ গুলো না একটু নোট করে রাখতে হবে তাহলে একই দিনে বেশি টপ ফেলবো
My lord, I'm for the petitioner.
My lord, so far,
My lord,
I'm
this is
appealing
that-
for the bank, my lord.
Which
Yes,
matter?
bank.
Item number
Five.
Item number 5.
I was not yet been called on. Oh, Samalot, sir.
Item
Yes.
number 5.
Yes.
I'm for the Yes Bank, my lord. On the
Yes.
last occasion on 4th of January,
Yes.
my lord had taken up the matter when we had indicated that we have come up with a vacating application.
Right.
And we wanted to also use a supplementary affidavit. Your lordship had granted us the liberty. We had filed it in the department on the 8th, serving them an advance copy as directed by your lordship. In the meanwhile, it was open to the parties to sit
May I?
and try to mutually settle the matter.
My lord,
They had
pursuant to the-
approached us and there was a hearing in the bank on the 9th itself. They had provided us certain documents that we had sought for and
To the last sentence of your submission.
yes, so basically that is going on. We haven't yet heard on the basis of the
When should I keep it?
documents we have
My lord,
When should I
demanded.
keep it?
My lord, Monday. My lord, because, my lord, tell your lordship, my lord, we had given them certain documents. They were supposed to revert back with a draft proposal. They haven't. Now, my lord,
that is
university is
not
also
correct.
suffering for
I'm
possibility
not-
of funds.
Should I
Kindly-
keep it on Tuesday, on Monday?
Monday, my lord.
I think in all fairness, if it is kept 1 week after, it
No, my
will
lord,
be
we are
better.
suffering, my lord.
I
We
don't
let it
mind
either
if it
be
is
decided
kept
on Monday.
also.
If there is a resolution between.
My lord,
us-
if there is, my lord, I am, my lord, kindly, my
How
lord.
are you
carry on.
suffering?
My lord, the operational and other expenses are not being released. We are totally coming to a standstill. We are not.
You are that college.
Yes.
So
We
that's
had
why, my lord,
indicated
if-
that there is a
I'll
fund
keep it.
on
I'll
which,
keep it on January 24th.
very well,
Somewhere in between 22nd and what you were saying.
very well, very well. We don't mind.
Since talks of settlement are going on, comma, in order to ascertain the outcome thereof, let the matter stand adjourned till January 24, 2024, when it will be listed fairly at the top of the.
My lord, kindly, my lord, pardon me for interrupting. My lord, I am led by Mr. Mukherjee in this matter. S. Mukherjee, my lord, he will be present on 22nd. 24th, probably he might not.
When should I keep it? Tell
My
me.
lord, Monday, 22nd, my lord. Please, my lord.
I don't mind. I'll come back on Monday. 22nd if
তাহলে
it,
January 24th না করে January 22nd, 2024. Fairly at the top করার দরকার নেই।
and my lord had already directed that we should come with our written notes of argument, so we should file.
Do
the
that
written-
on that. It is.
Yes.
Deeply
grateful
obliged.
to Raj.
You also come prepared with your written notes, Mr. Malhotra.
And I take it they are not coming up with any opposition.
No,
to our
we will.
supplementary.
If they do not, if it's
Then
not
at
resolved,
least
we
an
will,
advance copy
we will
should
serve
be
an
issued
advance
to
copy
us.
by Friday. We will
By
serve an
definitely
advance copy by Friday.
It shouldn't be like on Sunday evening we are
All
being.
these things outside the courtroom.
Yes, but at least they should serve an advance copy, my lord, as per your lordship's direction. Grateful to Raj.
Court applications under Article 226, item number 6 to 14.
Yes, Mr. Banerjee.
Lordship.
Yes. I don't remember exactly, but I was about to dismiss the matters, that matter.
I don't remember exactly also as well.
The respondents should probably remember.
Mr. Gupta is for the respondents. He is honestly.
Who?
Mr. Gupta is for the respondents. Lordship.
Let him come. Mr. Banerjee. He will remind me everything. Although the petitioners are represented, comma non-appeal, although the petitioners are represented, yes, Mr. Gupta is there.
Melody.
What, Mr. Gupta? Don't. This is
Melody.
not your drawing room.
No, I'm sorry. Mr. Deobrata Banerjee is leading. He said that he is coming. Therefore, my learned friend can continue, my lord.
No, not like that. Pass over, pass over. I'm
No,
passing it
it's
over
not
for
pass over, asked him.
when he comes up.
Monday, let's Lordship fix it. Monday, then we will come.
Let him come, Mr. Banerjee.
2 minutes. 2 minutes. Yes,
I'm let's pass it over, please. কিছু রেকর্ড করতে হবে না, pass over. এসে গেলে রাখবো। In any event, there are not too many matters where both sides are there, probably.
আমি বললাম আপনার গ্রাউন্ডে
Ready? Everybody is there?
Yes.
Did I call it? Then I'll take it up.
Sorry,
Yes.
Doctor, I'm quote number mistake.
No, no. Yes, Mr. Banerjee, what is it?
Lordship,
Why was the maintainability point taken? Just remind me that.
Lordship, there was a earlier writ petition filed by a person who is also a owner who said that rate, enhancement rate, and this tenure of the lease was negotiated amongst them, but they have not actually acted upon. So Lordship has directed that this is a negotiation of contract between the parties. So I will not interfere in that because there is no public element is there. Lordship has relied, though not actually expressly said, but there was a judgment of Gas Authority of India Limited, as well as
what do you pray now?
Lordship, my exact is a different. I am a tenant there. I was inducted. I am governed by a particular tenancy act. Good, bad, indifferent. My tenancy as of today is not been recalled or terminated. I am a tenant under a contract with them, statutory contract, Lordship. Now that statutory contract clearly stipulates the way how it to be terminated. If they terminate me, Lordship, then I have my course of law, which Lordship has indicated. Now, they have asked for arrear of rent. I was paying the rent on portal. They open a portal, I pay. So when they accept that, obviously the earlier month rent goes. Now they have come to a solution or a conclusion that they will be charging me a particular rate of rent from such and such period. And with a retrospective effect, they have asked the money. So now within the ambit of a statute, when one of the parties act in violation of the statute, then the writ lies. That's the law hold in Gas Authority and ABL Industries.
Now, what are you challenging?
No, Lordship, but I'm
retrospective effect to the
Lordship,
claim.
Lordship, kindly turn to my prayer.
Now, what is the claim by them, Mr. Banerjee?
Lordship, that is the first demand at page 23. If your Lordship kindly takes 1862 টা দেবেন, Judge Sahib. আমি 62টা পড়েছি তো, আমি একটা একটা করে দেখাবো সবটাই।
What is the difference between the two writ petitions, two separate petitioners?
You had a lease, then the lease come to an end, and then they started paying rent. After a flux of the lease, they become tenant.
Which one? The one 1862?
No, 1862 was an all-along tenant. There are two types of person who had no lease agreement ever with them, and a person who are
1862. You are on a slightly better footing in that there were lease agreements which have expired.
But after expiry, they have accepted the rent on a portal. So, by virtue of efflux of time, they have turned into a monthly tenant. Now, Lordship, kindly see first letter, page 23. On 29/11/2022, you will make a payment with reference to above. You are required to enter into an agreement with this corporation for a short term of 15 years. So there, this is the first time I am getting a letter where a tenant is said that no, I will not come into an, in this date, on this date, my tenancy is subsisting. Kindly see, Lordship. You will have to make a payment of security deposit of such and such with GST. I have no issue for that. With a 6 months rent, the monthly rent will be 80 rupees per square feet. This is also, I am not agreeable, but not amiable to writ jurisdiction. You are have to make a payment of outstanding 7,52,000. Lordship, this outstanding, there is no breakup, and so this is a demand. So with regard to this point number 2, you will have to submit an undertaking
that you will have to pay all outstanding due if declared later on. So if declared later on, so they can have a retrospective effect of their decision. These two sentences for which I am before your lordship. You will have to surrender your original lease document, Lord Kaushik 9C. You have to surrender your original lease document in respect of stall number 4, such and such. You will have to execute and register lease. So, lordship, with regard to 1 and 6, I have no issues. But lordship, now they are saying whether you have any document, you will surrender, you will give an undertaking that the arrear, if any, first he is indicating a arrear of 7,72,000. So arrear, if any, so there is no demand, there is no justification of the demand of the arrear rent. So lordship, that's the arbitrary action on their part, for which I am before your lordship. Second, they are saying that you have to undertake that you will pay all outstanding if detected later on. Lordship, this letter is the first cause of action of this writ. Now, lordship, immediately I have not jumped to court. Now, lordship, kindly turn to.
You had applied for a renewal. What was the basis of this? There was
No.
a board meeting, apparently board of directors.
No, lordship, this is, I have not applied. On this date.
No, lordship.
No, I'll hear you. Yes.
On November 22, I did not apply. I am not aware of that. First, I received this letter.
Then,
lordship, after receiving of this letter, next page, I started writing them. I have received your letter dated whereby your good office has given a direction to execute a lease deed in respect of this. I would like to state that I was inducted by your good office on or before blank lordship. Since then, I am paying rent to you. The relationship between your good office and the undersigned company is maintained and guided by West Bengal premises tenancy, because I said premises tenancy, it was below 6,000. It is pertinent to mention here that June 2019, which was clearly show that amount of such and such per month, and therefore I tender the rent month by month. You have issued a circular whereby your good office has stated that your good office will be charging monthly rent at a rate 80 rupees per square feet plus GST if the said letter reference such and such. You have also demanded an outstanding of this. I would like to request you to withdraw the said letter forthwith, as the said letter is without any basis and without any reason. Your good office has also indicated a circular number such and such. I would like to state that the said circular is not binding as undersigned. I tendered the monthly rent of such and such for the month of October, November, December via check number detail this. So immediately I said, whatever the circular you have, it is not binding upon. Now, lordship, kindly turn to the next page, the circular 26. This circular was page 26. Circular was in the month of August. Kindly see the circular. As per the decision of 362nd board meeting dated this, WBSIDC, the rate of the short-term rent of Silpo Bhavan has been considered and approved at this for the ground floor rupees this, for the first floor, for renewal for 15 years. So this is a circular, a decision they have taken. Upon taking that decision, where I was not a party, whether this decision, what are the reasons of these decisions, nothing was communicated to me. Based on this decision, the notice which I have indicated to your lordship has been issued to me. And considering that time, my relationship with him as a tenant was subsisting. I was a...
Mr. Banerjee, these are not public premises.
No.
These are public premises.
No.
Why not?
Lordship, Public Premises Occupancy Act is a separate act where the public premises has been described.
Is it not a public premises?
No.
Why not? This is owned by the by an authority which is an instrumentality of the state.
Yes, lordship. That's why I have shown your lordship. I have made the research. Lordship, whenever there is a public premises, then lordship, the premises has to be owned by them as their asset in the IT file. A premise, yes, lordship, I'm distinguishing. A premises owned by a government company as a stock in trade is not a public premises. Suppose housing board. Housing board has few flats and few offices, which is their stocking trade. Means they are selling it, like Vaishnav Ghata, Patuli, Golf Green, different housing projects were there.
They don't have ownership in those.
They have ownership, full ownership.
Is there any qualification on stock in trade and the other
Yes, Lordship.
aspect in the Public Premises Act? I don't think so.
No.
Then
Lordship, in the public premises, Lordship, public.
They have to be simply the owner of the premises. That is all. Stock in trade and all, no. There is no distinction in the statute, Mr. Vani. So they are free to take out proceedings. If they have to evict you, they have to take out proceedings under the Public Premises Act.
No.
Where all the defense you can take.
No, Lordship.
And
no.
Mr. Banerjee, if you, because you have stated that you are governed by the Premises Tenancy Act. If you are governed by the Premises Tenancy Act, go and ask for fair rent before the controller. Or deposit before the rent controller if they don't accept.
Then
you have your remedy. Choose that.
I have checked it, Lordship. Thereafter, after writing that letter, I have checked it. What is
You are not governed by the Premises Tenancy
No,
Act.
probably not.
Then you are governed by which act?
West
Transfer property.
Bengal Government Premises Tenancy Regulation Act 1976.
Right.
So this is the act which governs me. So neither the Public Premises Occupancy Act, because I am not an illegal occupier there. I was allotted and there I am staying. So Public Premises Occupancy Act will not apply. Neither the Premises Tenancy Act will apply.
So then you are a licensee under this act.
I can be leaseholder, licensee or a tenant. There is a different nature under this act. Now, Lordship, I will take your Lordship to the little more arbitrary action.
There is a scope of tenancy under this act.
Yes, Lordship.
Show me that.
There is a provision. These all were allotted to me.
No, where is the tenancy contemplated in this act?
I'm coming. There are three categories. How I am being inducted. Auction salami, leasehold and monthly tenant. Few persons were given an auction salami. Means they auctioned for tenancy. They were inducted upon payment of certain money. And upon payment of salami, they were given rent of this month. So, Lordship, this is one. Second is there is a leaseholder. And third is who are the tenant. Maybe by transfer from the earlier tenant or something. So, they auctioned it. They made a salami also. Now, Lordship, I am come back to this circular. Lordship, kindly to come to page 26. Now, page 26 is a circular or rather a decision of a government company. Yes. Which says that I will be charging like this. Now, Lordship, kindly turn to the next page. Lordship, kindly turn to page 27. The stall number such and such has been allotted in the year 1982. Lordship will get it. Where you have not executed and registered lease with this corporation. Whereas renewal offer letter has been issued by such and such for making payment of the security deposit and outstanding of this. So, Lordship, they are asking outstanding. Whereas it is found that you have neither made payment nor executed the registered lease deed with the corporation. Now, in exercise of the power conferred upon me as a prescribed authority, as per provision of West Bengal Government Premises Tenancy Regulation Act 76, you are asked to show cause why your tenancy will not be terminated and such will resume this corporation. So, Lordship, this is the show cause with regard to my tenancy. Tenancy they have not terminated. Now, kindly turn to next page, Lordship. How I used to 28. How I used to deposit. Reply to show cause was given, Lordship.
The relief you are seeking here, Mr. Banerjee.
Lordship, first, two relief.
Yes.
One relief is, Lordship, the show cause notice which was first given to me, this show cause notice will remain. Show cause to terminate will remain because that's the statutory governed. I have remedy under that statute. If I have, yes. There is no remedy. Maybe I will come back in a...
Page 23 you are assailing.
Lordship, this page 23 is a demand of the area rent. What I suggested to them, that's why every time I was coming back to your Lordship and I said, I'm ready. I said, area you cannot demand under any circumstances, first. Second, I am ready and willing to submit to your new rate, new tenancy, everything. But the area portion, you should not. So I repeatedly requested this court as well as to them, Lordship, I will take you few more documents, otherwise the sequence will not complete. I said, I need an amicable settlement. Please understand. Area you discuss with me, what are the areas, which period, it should not be an arbitrary action, your demand. And with regard to your future action, yes, I am agreeable to you. Now, Lordship, kindly turn to the next page. Yes, Lordship. Page 29, I gave a reply to the show cause. I have received your letter such and such, where you have stated that you will terminate my tenancy within 15 days if I do not accept the terms of your letter dated such and such. 2000 November. I agree with you sincere effort for renewing the lease. I am ready to enter into new lease. I am also ready to enter in a short-term or a long-term lease. However, the amount of the rent you raise too high is not a fair rent. Considering that fact, we are a small trader such and such, we would like to appreciate that we are a bona fide that and such. So, Lordship, what I only said in the show cause notice, I said that yes, I am agreeable to your terms and conditions. Now, Lordship, kindly turn to the next. I am not a defaulter, then I tendered the entire rent month by month. Now, Lordship, kindly come to page 34. Sorry, 35. Kindly turn to page 35.
This area is not as per their demand, as per your calculation.
No. My last payment made, I kept on tendering that last.
No, you see, you are also tendering arrears?
Area of 3 months during that period.
Yes.
So my area is calculated on the last payment. Because the agreement was tenancy agreement we entered upon, and
the negotiation is going on for a new lease being given to you. So how is the court interference?
No, Lordship, that there are two parts in it.
Scope.
Lordship,
Now,
there is, Lordship, kindly come to page 35.
Yes.
Allow me little time, Lordship. Now there is a decision they have taken. They have said that.
Yes.
Now kindly see. Requisition for negotiation of rent for such and such. With referred to our several communication held with you time to time. However, we are not allowed to deposit the existing rent. They stop me from depositing existing rent. That's also another arbitrary act.
What can the REIT court do in this, Mr. Banerjee?
I'm coming.
No, explain first. This is a wastage of time otherwise.
Lordship, let me place only this
What
page.
relief have you sought here? I don't understand, because your negotiations are going on between you.
So regard to negotiation, I have
asked for an exorbitant amount. Their relief lies against you in filing an eviction suit under whatever provision of law. If they file that, then you can always take the defense that this demand was exorbitant.
I'm coming.
No interference here.
No, Lordship. Then there is a.
You are seeking for acceptance of rental from the petitioner at the contractual rate, and the REIT court will direct that. That is prayer A.
Not really that prayer A.
That is the main relief here. And quashing something.
Yes, Lordship. That quashing is that.
Notice. Why should the court quash it?
Because, Lordship, 18.
The veracity of the claim is not associated. I mean, the veracity of that claim is not vindicated by that notice issuance itself. On the basis of the notice, they have a claim against you. Why should that be quashed? That is a precursor of some legal action they may take. Let them take the legal action, take your defense there. The court cannot interdict them from issuing a precursor to a legal action. They have made a claim only. The veracity of the claim is not vindicated by anybody. So why should the court interfere at this point of time? Their claim may be right, their claim may be wrong. Take your defense in whatever proceeding they initiate for the recovery of that claim. No question of interdiction by the court.
True. There is.
I'll hold that.
Lordship, that is
counsel
actually,
for the petitioner.
Lordship, allow me 3 more minutes and then Lordship.
Very well, yes.
Lordship, kindly turn to page 5. Then. Page P5, 35.
Yes, I'm there.
Lordship, here I said that you are demanding the area at the rate 80 based on a decision. Now I wanted to know how you have arrived to a decision. Lordship is saying that it is only a legal notice to you. It's a demand to you. So when they will execute the demand in the court of law, then you take the defense that they are not entitled or they are entitled. This is probably passing by the mind of the court. But I am saying, when you are a statutory body, every demand or every decision, because the demand has also incorporated decision, every demand and decision cannot be arbitrary. My only single sentence, arbitrary. It has to give it might be wrong. He might say instead of 80, he say 500. But he has to say area from this period to this period at rate this period to this period. I must be given a no, because moment a government authority issues a letter, it cannot be an arbitrary action. So there are two notice. One notice is the demand without giving a breakup of it or even giving a hints of it. And second part, you cannot make me defaulter without making me know for what I am defaulting.
You are challenging the notice at page 23 only.
Lordship, 23 and the board meeting there too, because the board meeting is indicated there. I have to challenge consequentially.
Which page?
Lordship, that 25, probably, Lordship. Circular, Lordship, 26.
26.
So, Lordship, these two documents.
Circular, what is the ground for court interference? They have decided.
Because their notices.
They have approved of a particular rate of rent.
No. Their notice, they talked about this circular. Incorporation by reference.
Why should the circular be set aside?
I'm not saying. I don't know what else was there in the circular. That's what I was taking to your Lordship at page 35. This is the gist of the circular. But what are you
challenging here?
Lordship, I am first challenging.
29th of November 2022 order.
Lordship.
The communication at page 23.
Lordship.
What else?
And this circular with regard to decision, the way they arrived at. Why? Because this, if I say that your reasoning of arriving at a decision was wrong. Now, Lordship, I will say that. Now, kindly come to page 35.
Yes.
It is almost like a RTI. Who were the member present at the board who decided 80 rupees? No, Lordship, kindly see. The parameter considering for fixing the rate at 80 rupees. What are the parameter you have considered for arriving at a conclusion? This is the most important. See, I said, it's all right. It might be 100, but you should have some parameter to arrive at, because you are taking a decision. Government body decision, you are making a action based on their decision. You are making me defaulter based on that. So, Lordship, I have asked this. What is the component in rupees 80 rate for maintenance of the building and standard and condition to be maintained? Whether the building is complied with the rules and laws under the Fire Safety Act. So I said that, all right, 80 is all right, but I have a right to know fire safety is there. What is the maintenance component and who are the person and how you have taken it? Because you are communicating a decision. A government decision cannot be that it is a private thing, I can decide anything. So this decision I have challenged on this 3 points. Now, Lordship, kindly turn to next page, 37.
Mr. Banerjee, this is a frivolous, premature application. There is no scope of interference here. You have been asking questions to the authorities. They are not bound to reply to you.
They have.
You don't have a legal right. No.
37, they have.
Very well. If they've replied, they've replied. Why are you going on reading these pages? And what is the relief you have sought? You have sought for a direction on them to accept rent from you. Do you seriously assume that the court will pass this direction?
No, I will be.
Frivolous application. Why shouldn't cost be imposed against your client? Absolutely frivolous application. The writ court will direct them to accept rent from you at a particular rate.
Lordship, maybe I will
This is a frivolous application and saddle exemplary costs against your client for this.
No, Lordship,
just wastage of time of court. Frivolous application, premature application. Why should the court direct them to accept a rent at a particular rate? Why?
Lordship, I honestly thought that when a area demand is made without giving a breakup, and that's an arbitrary action on their part, because the statute says civil court is barred. Otherwise, I could have treated it as a civil dispute.
Premature, Mr. Banerjee, no right has been violated of yours. They have only made a claim. That claim may be baseless. Take your points if they claim that before a court of law.
Then in that case, Lordship,
I'll impose cost on your client. I'm serious on this. Very serious on this. This is not only premature, this is frivolous. Why should the court interdict a cause of action for a claim, future proceeding which may be initiated by them? Let them make the claim, make your defense there. Why should the court interfere at this stage? Direct them to accept rent at a particular rate.
No,
I would have not,
I would have not,
pay.
fine. Lordship, I would have not prayed that. I would have prayed D for
B.
D. D.
D.
Lordship, that's the reason why I came here with a D along with a clear K, that let there be a.
No, they're not agreeable to mediation. I asked.
Yes, Lordship. Because
order turning.
Lordship, in that case, may I have a last chance to avoid that order by saying that I will withdraw with the liberty?
No, need not withdraw. It won't impose cost. The petitioner has challenged a perceived arbitrary action on the part of the respondent authorities. It is submitted that the petitioner had been a tenant in respect of a property under the respondent authorities. Although the tenure of the tenancy expired, the petitioner continued as a monthly tenant, since rent was being accepted from the petitioner by the respondent authorities even after the expiry of the lease. Next para. Vide communication dated November 29, 2022, annexed at page 23 of the writ petition. Eta kintu WPO 1862 of 2023. Annexed at page 23 of the writ petition, the respondent authorities made an exorbitant claim not only of security deposit to the tune of rupees 1,04,784.
I'm sorry, Lordship. I'm not challenging security deposit, neither the rent, only the arrear without breakup.
But also asked for a payment of alleged outstanding dues of rupees 7,52,029. It was also indicated that the petitioner had to submit an undertaking that the petitioner had to pay all outstanding dues if detected later on. It is contended by learned counsel for the petitioner that the respondents being statutory authorities, are bound by higher principles of fairness and transparency than an ordinary lessor. Next para. It is argued that the claim of outstanding dues of rupees 7,52,029 is not only exorbitant but without any basis whatsoever. That apart, the blanket claim of outstanding dues within double inverted, if detected later on, double inverted clause, is also dehots the law and natural justice. Next para. Pursuant to the said notice, which was replied to by the petitioner, a further show cause notice was issued on August 22, 2023. Next para. Learned counsel also challenges a purported circular issued by the West Bengal Small Industries Development Corporation Limited, dated August 18, 2022, whereby the rate of short-term rent of stalls at the Shilpo Bhavan Commercial Park, where the petitioner also runs a stall, has been considered and approved at the rate of rupees 80 per square feet per month for ground floor and rupees 72 per square feet per month for first floor for renewal for further 15 years within bracket short term. It is argued that no basis for coming to such assessment of rent has been disclosed in the said circular. Hence, the said circular suffers from lack of transparency and any supporting reason. In fact, the petitioner made certain queries with regard to the said fixation of rent, annexed at page 35 of the writ petition, where the petitioner sought to know, inter alia, who are the members present at the meeting of board of directors, where it was decided that rupees 80 will be the rent for ground floor, what were the parameters for fixing the rent at the said rate, etc. Full stop. Next para. However, comma, the respondent authorities did not respond to the same. Full stop. Such action on the part of the respondents, comma, it is argued, comma, is palpably illegal and dehorts the law and principles of natural justice. Full stop. Next para. Heard learned counsel for the parties. Full stop. It transpires that in the impugned notice dated November 29, 2022, the respondents have not specifically made any claim for the outstanding dues, but have indicated that in the event the petitioner seeks to enter into an agreement for a short-term lease for 15 years, comma, such amount as indicated therein as outstanding dues has to be paid by the petitioner. Pushed up next para, the clause with regard to the undertaking of the petitioner that the petitioner shall pay all outstanding dues if detected later on is neither here nor there, comma, since the same does not comprise of any specific quantified claim. Push up next para. Although the petitioner might have a point in arguing that there was no basis of such quantification, comma, this is a premature stage to challenge such claim of the respondents. Push up next para. Initially, the petitioner had, comma, in its written reply, comma, taken a stand that the petitioner is governed by the West Bengal Premises Tenancy Act. Push up, however, comma, at the time of argument, learned counsel for the petitioner submits that the governing statute is the West Bengal Government Premises within bracket regulation of occupancy bracket close act, comma, 1984. Push up next para. Be that as it may, comma, the communication dated November 29, 2022, comma, at best, comma, could be a precursor, precursor, for subsequent legal action to be taken by the respondents. First up, in the event the respondents make a money claim and stroke or initiate a proceeding for eviction under the extant statute against the petitioner, comma, it will always be open to the petitioner to take in its defense all the grounds as agitated in the present writ petition with regard to the quantification of the claims of the respondents. Full stop. However, comma, at this juncture, comma, it would be premature for the writ court to pass any direction on the respondent authorities with regard to the said quantification, comma, the veracity of which is yet to be tested before a competent court stroke forum. Full stop. Next para. Insofar as the circular dated August 18, 2022 is concerned, comma, it is well within the authority of the proposed lessor to quantify a proposed rent at which it seeks to lease out the property belonging to it. Push up next para. In the event the petitioner is governed by any provision of law which casts a right on the petitioner to seek fair rent to be assessed, and or if the petitioner has a valid argument as regards the respondents being bound by some specific schedule of rent in that regard, comma, it will be open to the petitioner to take all such issues in a properly constituted claim or eviction proceeding, comma, if initiated by the respondents against the petitioner. Push up next para. However, comma, since the petitioner is already in occupation of the property in question at this juncture, comma, it is, comma, as discussed earlier, comma, premature to pass any direction in that regard. First up, insofar as the relief A in the writ petition is concerned, comma, the same is obviously beyond the domain of the writ court, comma, since the direction on the respondent authorities to accept rental from a petitioner at a particular contractual rate would fall squarely within the periphery of a private civil dispute between the parties where the writ court ought not to interdict. Full stop. Next para. In such view of the matter, comma, WPO 1862 of 2023 is disposed of without any interference in the light of the observations made above. No rest to cause urgency.
Much obliged. Lordship, only the act which governs me, Lordship has said.
You handed up this.
No, I have checked. There is another. The
76.
76, not 84.
You handed up this because they have quoted another statute, 76 statute.
No, no.
But you argued this, you handed up this document.
No,
not
Lordship,
this.
I handed over this. Probably আগের দিন দিয়েছিলাম, so they marked it. So it should
তাহলে যেখানে স্ট্যাটুটটা বলেছি, the West Bengal Government
Just a statute.
Regulation of Occupancy Act 9 দাও 1984 যেখানটা বলেছি, এটা জায়গায় দেখবেন, ওখানটা ওটা কেটে দিয়ে the West Bengal Government Premises within bracket Tenancy Regulation bracket Closed Act 1976. Thank you. এটা হচ্ছে আইটেম নাম্বার কত জানেন? 1862 যেটা আছে দেখে নেবেন করে
6.
হ্যাঁ আচ্ছা 1861 you are not tenants.
Lordship, if Lordship, the direction of the order is, tenor of order is, this is premature, that is this. So this order will govern everyone. My status, if Lordship has come to prayer A, then status could have been different.
In 1861 you did not ever have any contract.
Always I was Selami and entered. There are two categories, Selami, entered and continued.
I'll pass a very short order in 1861 text order in Alada. WPO 1861 of 2023.
Otherwise, Lordship, I can.
The petitioner never had any tenancy agreement with the respondent. Full stop. The present challenge has been thrown against allegedly arbitrary quantification of. Here also they have asked for outstanding dues.
Yes, yes, everywhere.
Arbitrary quantification of outstanding dues as a the outstanding dues, comma, the payment of which has been made a precondition for the respondent entering into a short-term lease with the petitioner. Full stop. It is contended that the basis of such claim of outstanding dues and a circular whereby the proposed rent for grant of lease has been fixed arbitrarily by the respondent is palpably arbitrary, comma, not being backed by any reason. Full stop. It is argued that the respondents being instrumentalities of the state, comma, have to act on a higher footing of transparency than an ordinary landlord. Full stop. Next para. However, comma, it transpires that the impugned communication of the respondents is only on the premise that a particular quantification has been done by the respondent, insisting upon payment of the same by the petitioner for entering into a lease agreement with the petitioner. Push up. Next para. At this juncture, comma, no legal right of the petitioner has been violated. Full stop. Only in the event a specific claim is made before a competent court/forum for the quantum of outstanding dues quantified by the respondent or a proceeding for eviction of the petitioner is initiated, comma, the arguments made in the present writ petition by the petitioner shall be available to the petitioner as grounds of defense to such claim. Full stop. Next para. However, comma, as mentioned earlier, comma, the challenge at this stage is premature and need not be entered into. Full stop. Accordingly, WPO 1861 of 2023 is disposed of without any interference in the light of the above observations.
May I pray for one mercy?
Yes, Mr.
One sentence can save someone's life.
What?
This disposal of the writ application will not preclude us to approach and negotiate with the authority. Otherwise, they just throw me up.
I'll put it. And there.
Of the self-same matter, Lordship, pass different judgment, Lordship, followed by another judgment by Justice Motion Bhattacharya. Lordship, there is no component of public law, there is no scope of interference, Lordship, in this case, Lordship. The judgment are with me.
Public law, even public law, we need not go to public law.
Yes,
Here, no law has
law
been
is here.
infringed by you at this stage.
And all the
After line add করে দিন, it is made clear that nothing in this order shall preclude the petitioner from approaching the respondent authorities to negotiate the proper quantum of rent
and terms of lease.
And terms of lease.
They for Lordship, the so-called notice was issued, they appeared, and Lordship heard and then passed that order.
You can reject by one line.
Yes.
Let them approach you. They are stall owners.
Yes, I'm not. All are separate.
সবগুলোতেই এক order.
All separate matter.
Or otherwise, Lordship can say, in view of the order passed in two matters, all are dismissed.
No. That is separate. All are separate matter, Lordship. Same.
6 to 14, which of these you were previously tenants?
That's what I was saying.
Just give me that list. দুটো অর্ডার পাস করেছি তো, একটা 61 এ 1861 আর 62 তে। 62 টা আগে বলেছি, একটা জিনিস শুধু মাথায় রাখবে, 62 তে হচ্ছে ওরা মানে আগের লিজ ছিল আর 61 আগের লিজ নেই। আমি বলে দিচ্ছি কোনটা 61 টা ফলো হবে।
61 there was a lease. আমি একটা করে বলে দিচ্ছি। 61 there was a lease.
বলে দিচ্ছি 61 টা ফলো হবে না 62 ফলো। 1862 there was lease.
No, 1861 there was a lease.
Why lease? Why not lease?
No, 1862 you said there was
62 there was no lease. 61 তে লিজ আছে, 62 তে লিজ নেই।
Read petition have lease. Lordship 61.
এখন শুনলাম কোনটা? 6 টা শুনলাম।
62 টা। My lord, I requested to take up
1862 কোনটা? প্রথম অর্ডার যেটা দিলাম সেটা 1862 তে?
Yes, Lordship.
তাতে বলেছি যে ওই had deeds of lease. 1861 there was lease.
18 there was a lease.
61 তাহলে 1861 টা প্রথমটা 1861 করে দিন।
1860
যেটা আগের অর্ডার দিলাম সেটা 1861। 1862 no lease.
No lease.
তাহলে উল্টে যাবে। 1861 প্রথমটা, দ্বিতীয়টা 1862 ভুলে যাবে না তো? আচ্ছা, now what about the others?
63
no lease.
No lease.
No lease এর ক্যাটাগরিতে পড়ছে। 61 টা বললাম লিজ। 61 you had a lease.
61 I had a lease.
62 তে no lease.
No lease. 63 no lease.
WPO 1863 no lease এর ওই
64
সেম অর্ডারটা হবে। হ্যাঁ, কিন্তু কোনটা কি হবে সেটা বলেছি। 1861 এ হচ্ছে লিজ আছে, সেটা এখন আর কোনো ঢোকেনি। 1862 তে হচ্ছে লিজ নেই। 1862 এর অর্ডারটাই রিপিট হবে 1863 তে। 1864
no lease.
ওই একই লাইনে 1863 তে যায়, তাই মানে 1863 তে যা হবে 1864 ও তাই হবে, নো লিজ। 1865
no lease.
65 no lease.
সেম। 66
There was lease expired in the year 2019.
Lease
1866 টা আবার অন্যটা চলে যাবে, যেটা লিজ আছে ওই যেটা 1861 এ যেটা আছে সেটাতে তার আন্ডারে, ঠিক আছে? And then 1867
There was lease expired on 2019.
এটা 1861, হ্যাঁ। 1868
No lease.
no lease.
নো লিজ মানে অন্যটা চলে গেল 1862 এ। 69
No lease.
No lease.
1869 ও নো লিজ, ঠিক আছে? তাহলে in two matters only there is lease, 1861
Yes.
and 1866 probably. ওই 1861 এর সঙ্গে কোনটা ক্লাব করলাম?
1861 or 1866.
67 three matters.
I am giving the tabulation sheet. Lordship, for
আপনি একটা এটার সঙ্গে চেক করে নেবেন।
নাম্বারটাতে লিখে দিয়েছে।
লিখে দিন।
1861, 1866 and 1867 there was lease.
Yes, much of it. Lordship, there was lease.
Very, যা বলেছি সেটাই, ওটা না চেক করলে চলে।
I'm much obliged. Thank you. Always pleasure appearing before this.
Yes, thank you.
Always.
Reciprocal. Next.
A previous judgment was challenged before the division bench passed by your Lordship. Or no interim order of past Lordship, nothing have been passed.
It will be set aside at one go without passing it. Yes.
Item number 15.
May it please, Your Lordship, I'm appearing for the petitioner.
Right.
At the very outset, before I start with the matter, my lord, I find some discrepancy in the papers. My lord, at page 24, Lord, there's a list of the reminders, but these copies are not annexed in the petition, I find. My lord, this is page 24 of the petition. However, I'll indicate, my lord, my case is very brief, and I'll not press for all the prayers that are made in the my lord, petition. There are, my lord, if your lordship takes up, there are.
You are for the Axis Bank?
Yes, your lordship.
Axis Bank.
Yes.
So you are the main contesting respondent?
Yes, my lord.
Yes,
The
what is
respondent number 2. Lord, I'll only press.
Some time to file my affidavit, your lordship.
Let me hear the matter. If it's a short matter, no affidavits are required.
I'll
RBI
only
has been
indicate what
served.
the matter is.
Mr. Bagh, RBI has been served. File the affidavit.
They have, my lord. May I file the affidavit of service?
Yes.
They have been served. May I hand over?
What is the grievance?
Your lordship, I need some instructions from my client. I haven't.
You would have had instruction. It is appearing for quite some time. No,
Very briefly, I'll indicate, my lord, in 2021, 16th of June, there was a disbursement. So my banking operations, the company's banking operations were with Axis Bank, the respondent number 2 before your lordship. In 2021, there was a disbursement made for a sum of rupees 4 crores.
Before the narration, Mr. Bagh, what is the relief you are asking? Just tell me.
Only that, my lord, now that I'm not happy with Axis Bank because of XYZ reasons which are pleaded, I'll indicate, my lord, they have been deducting money for no reason. We have made repetitive reminders, my lord, which was not considered.
Take instruction, come back tomorrow.
Only one, my lord, since my learned friend can take instruction on that point also.
Please take care.
Since we are not, my lord, willing to continue our banking operations with Axis Bank, we want to shift it. My lord, there's a no objection certificate which is required.
Take your
That they are not giving. I'm only praying for, my lord, them to be directed that they should be issuing a no objection certificate so that the petitioner before your lordship can carry on with the banking operations. Yes, my lord. That's prayer A. That's the first prayer.
Did you ask for I mean, did you write to them for that?
That's the negative part, my lord. We have not. We have not. All the reminders, this point is not there.
So this is another aspect of the matter. They're challenging certain actions of yours, and they're also asking to withdraw banking operation from you. Take instruction on both counts. Come back tomorrow, please.
My lord, tomorrow may I only pray for, my lord, an additional day. Tomorrow in the second half, I may be stuck. That's the reason, my lord.
That will be easier for you also. Thursday. Very well, Thursday.
Gratefully.
Very deeply.
An adjournment is sought by learned counsel for the bank. Sorry, an adjournment is sought by learned counsel for the bank for taking instruction. Accordingly, let the matter stand over till January 17, 2024.
Very deeply obliged.
Oh, sorry, January 18. January 18, 2020.
Deeply obliged.
Thank you. Affidavit of satisfied to be kept on.
Item number 16.
16, my lord, I am appearing for the petitioner. Mr. Arijit Bardhan is appearing, my lord. He is not present for his personal.
Not today. Grateful. You are appearing for the bank. At order record kunin. An adjournment is sought. An adjournment is sought by the petitioner. Let the matter stand adjourned for the day. Namgulo ekটু record. Slip দিয়ে দিন তো।
Item number 17.
নাম লিখে slip দিয়ে।
I'm appearing for the Union of India, madam. May it please your lordship,
Yes.
I'm appearing on behalf of the petitioner.
Right.
My lord, in this matter,
this is the last chance to you. They were present on the last.
my lord, I'm so sorry for personal difficulty. I could not be
Anyway,
present.
what
my
is
lord. I
that?
tender my apology.
No.
My lord, a tender was floated for purchase of a property which is in Salt Lake. My lord, that particular property is the property where I was born and I had grown. Because thereafter, under my lord, the competent authority had acquired that property from my father. And we had handed over possession of that property, my lord, sometime in 2016. Now the competent authority is the owner of that property. They have, my lord, floated a tender in, my lord, 2023 in November. My lord, the date of auction was 4th of January. Auction must have taken place. But, my lord, prior thereto, we had written, my lord, a request letter to them that the price of rupees 3 crore 44 lakh, which they are wanting, my lord, I am ready and willing to pay that price. Kindly negotiate with me. If you ask for any higher money, I am in a position to pay and I can buy the property for sentimental grounds.
What was the circumstance under which it was taken over by the competent authority?
My lord, it was adjudicated that certain properties of the father was acquired through unlawful means or illegal. That is under the SAFEMA Act.
Very well. So you give an offer that I want to match the price and
I want to match the price.
Match what price?
Match the minimum reserve price, which was, my lord.
You can participate in the auction.
I didn't participate in the auction, my lord. That was the circumstances.
No,
But
the
my lord,
auction is over now.
the auction is over now.
Then
But there is one innocuous prayer which I have. That is, my lord, if today the competent authority can indicate what is the highest value which they have.
If it has been transferred, then what is the
It
scope
has
of
not been transferred. But based on 4th, it has been the auction. 4th January auction proceeding has taken place. If that instruction I get, Millard, I'll speak
No,
to
no,
my
if
client.
somebody, if it somebody has turned out successfully, has a right.
I
in
only, Millard, asking for the amount which is the highest bid. If I can match that, only then I may have some, Millard, submission to make before a lordship. I'll then take instruction, come back and withdraw the report.
Yes, what is the highest bid?
Well, I will have to then take instruction whether it was the amount. If I need to come back with your lordship.
No, the e-auction is over.
Over.
Was it successful? I mean, somebody turned up.
Yes. Well, I shall, my lord, be indicating to your lordship, my lord, we have received, my lord, the request by which, my lord, we have been requested to a public, my lord, private arrangement. That is, my lord, beyond the statutory bound.
Yes.
I can, my lord, show to your lordship, my lord, we had to, my lord, go through this process. Because this forfeiture, my lord, that is something, my lord, which my learned friends client have assailed.
No, I'm sorry, I cannot give you any.
But just a day's accommodation, Millard, I'll withdraw upon instruction. I'll also tell my client that this is not the procedure which the government can operate through. Just one, Millard.
You have to withdraw right now. Call your client and tell me in 5
Millard, at least just the amount which, if that can be indicated, Millard, it can be indicated verbally. I do not wish for any written correspondence to be exchanged.
How will that help you?
No, at least I can inform my client that this is the amount and you may not be in a position. Millard.
No, even if she matches, it cannot be undone now. If the sale has gone through.
It will be easier for Millard as an counsel.
Sale has gone through. Are you sure on that?
That is something, my lord, which I'll have to take instructions. Because I believe, my lord, the
sale has not
been has opened, my lord, we must have.
The claim of the petitioner is the claim of the petitioner is innocuous. The petitioner has certain sentimental ties with a particular property involved in the present litigation. The said property had been taken over by the competent authority, that is respondent number 2, and was put up on auction sale. Although the sale date is over, the
auction date, Millard.
Although the auction date is over, the petitioner wanted to match the price and get back the property. For such purpose, it is submitted by learned counsel for the petitioner that the respondents be directed to disclose the price which the property fetched in the auction to give an opportunity to the petitioner to match the same. Next para. Learned counsel for the respondent authority submits that no private arrangement can be entered into by the respondent authorities under the confines of law as proposed by the petitioner. However, on query of court, learned counsel for the respondents shall take instruction as to what was the outcome of the auction which took place on, what was the date?
And that is on
4th of January 2024.
On January 4, 2024. For such purpose and passing further orders, let the matter stand adjourned for the day. Come back tomorrow.
Millard, if your lordship can keep it day after tomorrow, if one day he can communicate to my learned advocate on record,
I'll communicate.
I'll be ready.
Adjourn stand over till January 17, 2024.
Deeply obliged.
Grateful.
You're for the?
Number 6.
My brother of the petition.
I am for the executor of the deceased.
Executor.
Don't complicate matters.
This is beyond the will.
Yes.
I'll not give you opportunity.
This is like a family arrangement between, my lord, the parties, and we are, my lord, have taken actions as per law for feature that has been assailed before Supreme Court. That has been got confirmed.
Succeeded initially in the single bench.
I'm not interested.
This is beyond the purview of the
thing,
bill.
my lord, I shall indicate to your lordship, we have got no scope.
Sorry, 18, not 17, 18th.
18th.
18th. Day after tomorrow. There is no scope of granting any relief in this state petition.
There is not, because the gentleman has received the order. He has accepted the order.
Yes.
That was subsequently earlier. Unfortunately, that day I was not there. They took advantage.
This is another way to look at.
No, there is no order passed with respect
to whether you will withdraw the writ petition.
No, there is no order passed with respect to this particular property. I'll come back and Millard inform your lordship. That was my first submission before your lordship.
Order with respect to this property. The entire attempt through these proceedings is to prejudice the trial in the probate suit by saying that the father was incapable of handling his affairs. It's a larger game.
The conspiracy theory, I don't go by this.
This is not at all.
I'll hear you.
I have already made submissions that I may withdraw this application. Obliged.
Get from
Item number 18.
18, yes.
But 18, I'm kindly take it up tomorrow, Lordship. I have taken out a supplementary affidavit, my lord. Let a copy be.
Let it go. Leave is granted to the petitioner to file a supplementary affidavit, which is filed today and kept on record. A copy thereof is handed over to learned counsel for the respondent. To enable the respondents to prepare themselves on the supplementary affidavit, the matter is adjourned for the day.
Grateful.
Come back. Affidavit of service filed today be kept.
Item number 19.
Yes, Mr. Kankani, infractious matter.
No, my lord. I'm for the petitioner, my lord.
Yes.
My lord, I'm filing my affidavit of service, my lord. A small application for expeditious disposal of my application under Section 14 of the SABYASACHI Act, my lord.
The statutory time is over.
It is over, my lord. And the matter is fixed tomorrow, my lord. My application
Mr.
was...
Kankani,
My lord.
have you either stated or have you got instruction whether any Section 17 or any other challenge is pending? If
My
it
lord,
is
there
pending,
is-
I cannot give a direction.
My lord, sections... My lord, I'll have to take instruction on that.
instruction.
My lord,
In order to enable learned counsel for the petitioner to take instruction as to whether any proceeding is pending under Section 17 of the SABYASACHI Act or otherwise, which may prevent this court from passing a direction as sought for, comma, let the matter stand adjourned for the day. Stop. The affidavit of service filed today be kept on record. Take instruction, come back tomorrow, I'll pass.
my
it.
lord, grateful.
For hearing item number 20.
Your Lordships, I appear for the petitioners in this matter. I am led by Mr. S.N. Mukherjee in this matter. This matter relates to a challenge to an order passed by the Calcutta Stock Exchange. Your Lordship, Mr. Mukherjee had concluded his arguments and the respondent was supposed to start today.
My lord, perhaps 15 minutes might not. And my lord, I'm being led by Mr. Ray. He was requesting me, my lord, if the matter could be fixed on 25th.
Why 25th so long?
And even, my lord,
You have for the respondent number?
1.
On the prayer of learned counsel for the respondent number 1, the matter is adjourned till January 25th, 2024.
Grateful.
Come back on that day. January 25. 25th January 2024. Which is sorry.
Item number 21.
This is my petition.
Yes, Mr. Shah.
21, Mr. Rai is appearing. His own leg in court 12.
Which Mr. Rai?
Home Narayan Rai.
He'll come in.
No, a long matter is till 4:30 it will be taken up.
Before which judge?
Before 12.
12, who is sitting at?
Surya Kumar and Mr. Justice Rausi were there. The tax matter is going on.
Numbers 21 and 22, my lord. Writ petition challenging declaration of willful default. Any day convenient, your lordships.
Only not today. On the prayer of the respondent, the matter, two matters. দুটোই একসঙ্গে দেখে দেবো on the prayer of the respondents, the matters are adjourned for the day. Presence, please give your names.
I'm grateful.
Mr. Shah, whoever is appearing with you, please ask.
Yes, ma'am. I'm grateful.
Item number 23.
Don't give the name of Mr. Rai.
No.
Yes.
Chief, item number 23. I'm for the petitioner. Mr. Joydeep Kaur is appearing in this matter.
What is the matter about? Start the matter.
Chief,
why are you without brief? You are sufficiently senior, you are sufficiently capable. Start the matter. You should come with brief.
Chief, kindly makes it
not to
for the
order not to
much of it.
Item number 24.
যদি না করে তো উঠে যায় নেই তো
25.
আচ্ছা একটু কল করো
My lord, I'm for the petitioner in this matter, my lord.
Mr. Datta is on. Yes, Mr. Datta, what is the matter?
Lordship, no, my lord, there was a direction for exchange of affidavit, my lord. I am suffering. Since there is no stay order, my lord, the matter is very serious, my lord. This is a matter of Geological Survey of India. My lord, the pre-bid minutes was manufactured and it replaced the genuine one. There is a practice of fraud, my lord. And my lord, for favoring a particular participant in the bid. And the order has been...
no opposition copy has been given to you?
Lordship. My lord, can you see the last order, my lord?
Yes, it was specifically...
My lord. Well, the issue is very serious, my lord. That has been...
because in 12 minutes probably this won't be over. I'll give them a last chance. I'll record an order that if they are absent on the next date, I'll take up the matter expertise.
May I have one kind indulgence, my lord, that it may be recorded that whatever they will do on the basis of P5, which is under challenge in this writ petition, will be subject to the decision of this writ petition.
Very well. None appears for the respondents at the time of call, although the petitioner is represented through counsel. Full stop. No affidavit in opposition is also filed in court today as per previous direction. Full stop. Next para. As a last chance to the respondents to appear and contest the matter, comma, the same is adjourned for the day. It is made clear that You are appearing.
My lord, this is a CSC matter, my lord.
No.
I apologize, my lord.
It is made clear that in the event the respondents are not represented represented on the next date, comma, the matter will be taken up for hearing ex parte. Full stop. Any action taken in the meantime shall abide by the outcome of the writ petition.
I am grateful. I am grateful.
I apologize, my lord.
Not this matter.
No, my lord. It was item number 23, my lord. And it was made not today, my lord.
23, yes.
My lord, I apologize, my lord. I came running, my lord. I thought that by the time I'm grateful.
May I pray for an indulgence, my lord? But item number 19.
You are also in the invitation group.
Invitation, my lord. No.
He is also in your panel of inviters. Yes, he is not there. Mr. Kankani is out.
He's there.
He is also there.
Well, item number 19, I've taken instructions, my lord. There is no section 17 pending, my lord.
Past a formal order, somebody may be watching, Mr. Kankani. Let us come back. Somebody might have been watching, but they are not here now.
Very well. I'll come back.
Let us come back.
Item number 26.
Your Lordship, I appear on behalf of the petitioner. I am being led by Mr. Shuddha Sattu, sir. He's on his leg before another court.
I'll
Your
adjourn
Lordship.
only if you start the matter. Otherwise, no. Otherwise, dismiss or default. What is your name, please?
Your Lordship, it's Avi Jaiswal. Your Lordship.
You're practicing for how long?
It's just been about 8 months, Your Lordship.
Very good. Start the matter. Yes, he will start the matter. He will start the matter. No, fighter. Yes. What is the matter about? What are the reliefs you have sought?
Your Lordship, the reliefs that we have sought in this writ application. Your Lordship, the FCI has acted arbitrarily by issuing directions in the letters dated 15th of June and a cost settle that we were not allowed to appear in.
They floated a tender.
Yes, Your Lordship. We had applied for a tender. We had been granted the tender, but there was one delay due to the puja holidays having taken effect, and the bank was unable to remit the amount into the bank account of the FCI. It was not on it was not our
It was
default.
a technical fault, not your fault.
Not our fault, Your Lordship. They had issued a
You tendered the amount in time.
Yes, Your Lordship, we had.
But for the bank's technical defect,
Yes, Your
it was
Lordship.
not credited
It wasn't.
to them. So for that, your tender was rejected.
It wasn't rejected, Your Lordship. It was only after we had sought for the authorization letter and the letter of award that they had woken up and issued this letter demanding the money, demanding the amount to be paid.
Yes.
And Your Lordship, they had arbitrarily blacklisted us and terminated the tender.
You have challenged that termination and as well as the blacklisting.
Yes, Your Lordship.
You are Mr. Varun Kedia. একটা order record করুন। Although Mr. Jaiswal, led by Mr. Kedia, commences arguments in the matter, the same cannot be taken up for hearing in view of extreme paucity of time. In view of paucity of time today, let the matter stand over till tomorrow. But tomorrow also he will have to start, Mr. Kedia. He will be there, but we'll have to start.
Your Lordship, I am also led by Mr. Shuddha Sattu Banerjee. If Your
Mr.
Lordship,
Banerjee, you irrespective, he will have to start.
I'm grateful.
All of you will be assisting him. Or guiding him, not assisting, guiding him.
Surely, Your Lordship.
Yes.
Item number 27.
Yes. Not today. Order record করতে হবে।
Item number 28. Item number 29.
Yes, ma'am, you want to do any matter?
Lordship, I am for the respondent number 3 in item number 30.
আচ্ছা 30 পর্যন্ত কল করো তবে উঠে যাবো।
Item number 30.
Respondent.
Yes, respondent number 3, Lordship.
Although the respondent number 3 is represented through counsel, your name please?
Srijoni Ghosh.
Counsel Ms. Ghosh, comma, none appears for the petitioner. Push up accordingly, let the matter stand adjourned for the day. চলে এসো। Miss Tijoni Ghosh, পুরো নামটা দিও, বাচ্চাটার পুরো নাম।
Serial number 30, Your Lordship.
Whatever has happened, happened. You are for the petitioner. If you are for the petitioner, it was dismissed. And if you are for the respondent, it was allowed.
Lordship. 30 has just been called out, Your Lordship.
কোন ম্যাটারে?
The matter serial number 30 has just been called, Your Lordship. The board is showing 30. I am in 30 for the petitioner. May kindly keep it tomorrow, Your Lordship, or else if Your Lordship wants me to argue the matter.
The petitioner, it must have been dismissed for default.
Lordship, may kindly
ascertain from